Lord, matter pertaining to Kotal 14. Yes. Monday, garu.
All memos, please hand over Portal 14. Concerned court officer will give you the date.
Please.
What is the urgency?
She has been unnecessarily arraigned, my lord, for an employee committing suicide.
When was the charge sheet filed?
She was not by this
What is the
investigation.
date? The date of the offence?
My lord, it is October of 2020.
20?
Five.
And what is the urgency? It will come up on Monday. Urgency is only if he is put to the noose.
My lord, notice has been issued to us.
Only if a noose is put on him, otherwise no urgency.
Portal number 14 Monday.
Concerned court officer or date ಕೊಡ್ತಾರೆ. Please hand it over.
Lordship, for orders, I filed an application for restoration, extension of interim order.
Portal
RF
14.
23, your lordship.
RF is a number.
RFA vacating order has been
Kodi, RFA kodi.
Monday not.
Monday lamma. It will come up on.
Vacating order.
It will come up on Thursday.
This matter, my lords, 2022, 484, my lords. Family matter. My lords, marriage has been resolved in family court, my lords. There are certain terms and conditions. I'm ready to comply that. 8 lakhs and 1.5 acres has to give. But she is not coming, my lords. I've produced the affidavit as well as the DD before this order before suspended. Have it on Monday.
Kodi, yes.
Your Lordship, on RFA 2024 matter, it was referred for mediation. It has not been settled there because the other party has not appeared. Further, they've given the civil court has given an.
Matter is admitted or not?
Yes, Your Lordship, it's admitted.
Then
For
we can't take it up. 2023 matters we are taking up.
RFA fresh matter.
Kodi. Thursday.
My lords, Kotal 14 NBW issue agide, my lords. Kotal 14 NBW petitioner against issue agide. Avaru foreign
When was the NBW issue?
My lords, 3 days ಆಯ್ತು ಅಷ್ಟೇ.
No, when was the NBW issue?
3 days back.
3 days. Sure.
Yes, my lords. ಅದಕ್ಕೆ ಅವರು ಫಾರಿನ್ ಗೆ ಸ್ಟಡೀಸ್ ಹೋಗ್ಬೇಕು my lords. ಅದಕ್ಕೆ ಪಾಸ್ಪೋರ್ಟ್ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ ಮಂಡೇ ಕೊಡ್ಲಿ my lords ಪರವಾಗಿಲ್ಲ.
Monday.
Kotal 14.
ಯಾವ ಕೋರ್ಟ್ ಅಪ್ಪ? ಮತ್ ಕೊಡಿ ಅಲ್ಲಿ ಮೆಮೊ.
Vacating stay my
Huh?
Kotal 12.
ಕೊಡ್ತಾರೆ. Yes.
RFA fresh matter.
ಕೊಡಿ. Fresh matter ಕೊಡಿ. Tuesday, Thursday.
My lord, Kotal 14 matter. ಇದರಲ್ಲಿ plant ನಾನು ಜಿಂಜರ್ ಪ್ಲಾಂಟೇಶನ್ ಇದೆ ಸ್ವಾಮಿ. ಅಗ್ರಿಕಲ್ಚರ್ ಆಕ್ಟಿವಿಟಿ ಜಿಂಜರ್ ಹಾಕಿದೀನಿ ನಾನು. ಅದಕ್ಕೆ ಕಾನ್ಸ್ಟೆಂಟ್ ಆಗಿ ನೀರ್ ಬೇಕು. There is a dispute ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ ಹೇಳಿ ನನ್ನ ಅಗ್ರಿಕಲ್ಚರ್ ಆಕ್ಟಿವಿಟಿನೇ ಮಾಡಬಾರ್ದು ನೀವು ಅಂತ ರಿಸ್ಟ್ರೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ತಹಸೀಲ್ದಾರ್ ಆಸ್ ಅನ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. ಇವಾಗ ನೀರ್ ಇಲ್ದಿರೋ ಒಣಗೋಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಅಟ್ಲೀಸ್ಟ್ ನನ್ನ ಅಗ್ರಿಕಲ್ಚರ್ ಆಕ್ಟಿವಿಟಿ ತೊಂದರೆ ಆಗುತ್ತೆ. ನಾನು ಲೋನ್ ಬೇರೆ ರೇಸ್ ಮಾಡಿದೀನಿ. ಹಂಗಾಗಿ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮೈ ಲಾರ್ಡ್.
ಯಾವತ್ತು ಆರ್ಡರ್ ಮಾಡಿದ್ರು?
ಮೈ ಲಾರ್ಡ್ 13/3 ಆರ್ಡರ್ ಮಾಡಿದ್ರು. 27/3 ನನಗೆ ಕಾಪಿ ರಿಸೀವ್ ಆಗಿರೋದು ಸ್ವಾಮಿ.
ಮತ್ತೆ ಮಂಡೇ ಬರುತ್ತೆ.
ಅಲ್ಲ ನನ್
ಆ ಕೋರ್ಟ್ ಮುಂದೆ ಮಂಡೇ ಬರುತ್ತೆ.
ಅಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಸ್ವಾಮಿ. ಹಂಗಾಗಿ
ಕೊಡಿ ಆ ಕೋರ್ಟ್ ಮುಂದೆ.
ತುಂಬಾ ತೊಂದರೆ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ತಮಗೂ ಗೊತ್ತಿದೆ ಜಿಂಜರ್ ಪ್ಲಾಂಟೇಶನ್ ಅಂದ್ರೆ ಕಾನ್ಸ್ಟೆಂಟ್ ನೀರ್ ಬೇಕಾಗುತ್ತೆ.
ಜಿಂಜರ್ ಪ್ಲಾಂಟ್ ಕಾನ್ಸ್ಟೆಂಟ್ ನೀರ್ ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲಿ
ನೀವು ಹೇಳ್ತಿದ್ರಂತ ಬೇಕಷ್ಟೇ.
ಅಲ್ಲ ನಾನ್ ಫೋಟೋಸ್ ಎಲ್ಲಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ಮೇಡಮ್ ಜಿಂಜರ್ ಪ್ಲಾಂಟ್ ಶುಂಠಿಗೆ ನೀರು ಬೇಕಾಗಿಲ್ಲ. If you are trying to tell me something which I do not know, I can understand.
This is my.
ನಾವು ಜಿಂಜರ್ ಬೆಳೆದಿದ್ದೀನಿ.
ಅಲ್ಲ ನನ್ಗೆ ಬಂದಿರೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಪ್ರಕಾರ ಮತ್ತೆ ಬಂದೋಬಸ್ತ್ ಹಾಕಿರೋದ್ರಿಂದ ಅಲ್ಲಿ
15 ದಿನಕ್ಕೆ ಒಂದ್ಸತಿ ಅಷ್ಟೇ.
ಕರೆಕ್ಟ್. ನನ್ಗೆ ಇವಾಗ 13ನೇ ತಾರೀಕಿಂದ ಬಂದೋಬಸ್ತ್ ಹಾಕ್ಬಿಟ್ಟು ನಾನು ಅಲ್ಲಿ ಮನೆ ಕೂಡ ಅಲ್ಲೇ ಇದೆ. ಹಂಗಾಗಿ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್.
Fresh Kotal 14. Kotal. Told. Yes. Yes. Adjournments.
Adjournments phase wise.
page number 6, serial number 21 to 23, page number 7, serial number 24 to 26, page number 8, serial number 27 to 30, page number 9, serial number 31 to 38, page number 10, serial number 39 to 42, page number 11, serial number 43 to 45.
That's serial number 45. We've informed the other side also, my lords, for the appellants. Mediation ಹೋಗಿತ್ತು, mediation ಅಲ್ಲಿ fail ಆಗಿದೆ. There's some inconvenience to senior counsel. Any date next week, my lords.
My lord, same submission from beginning.
No
last
adjournment.
year
Yes,
in
next.
My lords, any date next week, my lords.
Oppose ಮಾಡ್ತಿದ್ದಾರೆ.
ಬೆಳಿಗ್ಗೆ phone ಅಲ್ಲಿ inform
He
ಮಾಡಿದ್ರೆ.
is opposing, how can I grant adjournment at
Senior
10:30
counsel,
when he is
senior
opposing?
counsel is in
Next.
this.
Page number 12, serial number 46 to 49, page number 13, serial number 50 to 52.
Time for the appellant, my lord, my serial
Serial
number
number?
52, serial number.
52.
AOR is not well. Rajshekhar Siri, the opposite side advocate's relative died. Therefore, the funeral, therefore not be able to come again.
That's 49, my lord. ನಾನು ಲಾಸ್ಟ್ ವೀಕ್ ತಮ್ಮತ್ ಕೇಳ್ಕೊಂಡಿದ್ದೆ ಹರ್ಪಿಸ್ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿದೆ 2 weeks ಅಂತ ತಿರ್ಗಾ ಅವತ್ತೇ ಬಂದಿದೆ.
Yes.
49 lords. I had sought for 2 weeks time because I'm advised 2 weeks I should not go because I'm having that infection. It is contagious, my lords.
The learned counsel for the appellant seeks time on the ground that he is unwell. List on so and so.
16th April.
That's 2 weeks.
Learned
2
counsel
weeks.
for the appellant joined the proceedings through VC, submits that he is unwell.
Mine
Please
is
list on so and so.
52, my lord.
ಆಯ್ತು.
Date next week.
16th April.
16.
Interim order granted as extended to the next hearing, serial number 49.
Grateful, man.
List number 1 for order, serial number 1, Vinod Prasad.
Vinod Prasad.
Petition, my lord.
Amendment is ready, lordship.
Amend it.
Ready.
My lord, the matters fully settled, my lord. The proceedings have
Settled.
already been disposed of before the trial court, my lord.
Proceedings are disposed of.
Disposed of, my lord. The CC itself
When?
is disposed of. It's already fully settled.
When?
My lord, my colleague has the, she's just producing the memo.
Yes, yes.
We are ascertain and make submission on this.
Ascertain, we'll close it, you ascertain and come back.
27th of January was CC 4560 of 2019, my lord. And 31st of January was 800 of 2020. It's fully closed, my lord. We've settled the entire matter.
Copy me permission.
The petitioner in all these petitions has challenged the proceedings initiated by the respondent. Number 1.
Respondent number 1.
Respond number 1. For an offence punishable under section 138 of the Negotiable Instruments Act in CC number so and so on the file of so and so. When this petition is listed for orders regarding amendment of the cost title, it is brought to the notice of the court by the learned counsel for the respondent number 2 that the case before the trial court is already settled.
Yes, ma'am.
Settled, my lord. We've disposed the entire. Please, my lord.
Is already settled and he has paid up the check amount.
My lord, not the entire amount. We worked out our OTS, my lord. We closed the entire amount.
Settled and that the petitioner has agreed to pay the amount under an one-time settlement scheme. Full stop. In that way of the matter, these petitions do not survive for consideration and the same are disposed.
Please, grateful, my lord.
There are 3 matters.
All 3 cases.
Grateful, my lord.
Serial number 2, Lakshmi Holla.
Lakshmi Holla.
Appear for the appellant, your lordship. In this matter, actually, the argument is already over, and commissioner report we have applied on 26th too. Even now, nobody had received that report. So after getting the report, the argument may be continued. Actually,
I can't keep it pending. Yeshati keladu. How much more time should you spend on this appeal? 2010 appeal.
report nodidre, then it may be concluded. Actually, that's
I'll ask the commissioner to furnish a copy of the report to you if you want. But I can't keep
we have
this
already
pending.
applied on 26th too. Apply madideni. That's the problem. What 10 days kodi, I will proceed with that.
No. Next Thursday ಆಗ್ತೀನಿ ಇದ್ರೊಳಗೆ ಮಾಡಿ ಏನ್ ಮಾಡ್ಕೊತೀರ ಮಾಡ್ಕೊಳ್ಳಿ. Otherwise I'm going to decide it on next Thursday.
Much obliged.
Counsel for the appellant seeks time on the ground that the commissioner's report is not received. Allari, our copy sikkilla anta.
Copy
On the
ಸಿಕ್ಕಿಲ್ಲ.
ground that the certified copy of the commissioner's report is not furnished. Since as a last chance list on Thursday,
ಮತ್ತೆ
it is open for the petition, learned counsel for the appellant to take extracts of the report submitted by the commissioner before the court from the court file. Yes.
Serial number
Much obliged.
3, PR Subramanya.
C.R. Subramanya,
I represent the respondent. Ma'am. Matter is settled in the mediations.
Barcode. The appellant has challenged the judgment and decree dated 15/9/2023 passed by so and so court in OS number so and so. Full stop. When this appeal is listed for orders, comma, it is brought to the notice of the court that the parties are referred for mediation and a settlement is arrived at before the mediation center. Illi the terms of which are as follows. Illi the terms, illi.
Lord, it is settled for 5,50,000 rupees.
Illi the note. Copy out. Since the settlement is just and proper, comma, the settlement is accepted and the appeal is disposed of in terms of the agreement entered into before the mediation center.
Lord, office may be directed to withdraw.
Office is directed to refund the court fee.
Not the court fees, my lord. The deposit has been made by the appellant, 3 lakhs rupees.
Any deposit made by the appellant
In
shall
favor
be
of
refunded
respondent.
to the
Respondent.
respondent.
Please.
Yes. Court fees shall be refunded in accordance with the judgment of the apex court in the case of so and so. Yes.
Serial number 4, BR Srinivas Gowda.
B.R. Srinivas. On complaints of office objections,
Copies are not served to me, members. Caveat respondent.
there is no representation for the appellant. Office objections are not complete. List on date. Yes, suit is for what? Declaration.
ಇಲ್ಲ ನಾನು ಕಾಪೀಸ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ನನಗೆ. caveat ಹಾಕಿದ್ವಿ ಅಷ್ಟೇ for
Yes, list on so and so code
9th April.
for complaints of office objections.
Serial number 5.
Mr.
Ramji.
Sangvi.
Appear for appellant. I may be permitted to carry out the amendment.
Madi, do it now, pass over.
But
Serial number 6, Syed Khalil Pasha.
Pass over ಮಾಡಿ. ಅದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಂತಲ್ಲ ಏನು?
ಅದರಲ್ಲಿ ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ. 95% ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ.
95% ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ ಅಂದ್ರೆ?
All the 3 floors were vacated. Some portion will have to be some.
On the last sheet you said that entire thing is
ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನೋಡ್ರಿ ಅಲ್ಲಿ 95% ಅಂತ ಹೇಳಿ ಇವ್ರು ಬರೆದಿದ್ದಾರೆ.
Anyway, we'll consider. Let him amend. ಈ R2 and R3 ಬೇಕಾಗಿಲ್ಲ ನೋಟಿಸ್ ಅವ್ರಿಗೆ?
ಅಲ್ಲ R2 and R3 they are the tenants.
They have filed detailed statement.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ.
ಅವರೇ ಇವರೇ ವಕಾಲತ್ ಹಾಕಿ.
ಅವ್ರಿಗೆ ನೋಟಿಸ್
ಅವರೇ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. WS they are not in.
No, whether R2 and R3 necessary parties to this appeal?
Yes.
How?
Because at the time of argument they have filed wakalatnama stating that I am in possession of the property. They filed written statement. ಅದಕ್ಕೋಸ್ಕರ.
Sorry, but then why should he will take notice?
ಅದಕ್ಕೋಸ್ಕರ and no address has come. There is no such address ಅಂತ ಬಂದಿದೆ.
No. If he had entered appearance for the response
They have
to
entered appearance.
before the trial court, he will take notice now also.
ನಾನ್ ತಗೊಳ್ಳಲ್ಲ.
ಇವ್ರು
ನಾನ್
ತಗೊಳ್ಳಿ.
plaintiff ನಾನು. ನಾನ್ plaintiff.
ಮತ್ತೆ ಇವ್ರು ಯಾರು? 2 and 3 ಯಾರು?
2 and 3 are defendant 1 and 2.
ಇವ್ರು ಯಾರು?
You're defendant 3.
Defendant.
Number 3. He is the person in occupation.
Oh, he is in occupation.
Under the defense 1 and 2?
1 and 2.
Under the defense?
No.
1 and 2.
Not under 1 and 2.
And his claim is that
they say, I am the tenant. My father, Jugraj Pukraj, was the tenant. Jugraj Pukraj, there is no such person. Nari is my father. It is a very, they have issued the notice. At the time of argument, they filed a written statement. That lady came. No address is, there is no such address.
It will consider, yes.
We will.
Pass over.
Serial number 6, Syed Khalil Pasha.
Syed Khalil Pasha. Non-filing of relevant proof of valuation for the purpose of jurisdiction.
My lord, in partitions, the similar case is pending before this honorable court in RFA 706 of
Before the division bench or
single bench, my lord. This also stand in similar. I am also putting in
Right.
this
Does it
submission.
arise out of the same
Same,
decree?
same. That is OS, my lord. That is partition suit. That is out of partition suit, my lord. That men's profit is order.
Alri.
Same, 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 Swami, same.
Same, Indra, yenu.
Allah.
Does this appeal and the appeal that you are referring to arise out of the same decree?
Same decree.
Same decree?
Also.
ಅಷ್ಟೇ ಹೇಳಿ. ಎಲ್ಲಿ ಕೇಸ್ ಸೂಟ್ ಎಲ್ಲಿದೆ ಇದು?
706, RFA 706 of 2017, my lord.
This is FDP.
FDP.
You're challenging FDP.
I'm challenging FDP, that is OS 212 of 2012 is pending.
Correct, sir. What is the value of this property?
Less than 10 lakh rupees, my lord. The same.
Why don't you give a statement that it is less than 10 lakh?
No, I have already given in writing in the statement before the pending nalli ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? Where have we mentioned it is less than 10 lakhs? ಅದೇ 10,000 and above ಅಂತ ಬರ್ತಿದ್ದೀರಾ?
ಹೌದು. Your lordship, please kindly see. OS case is disposed of. Suit for partition is disposed of. Against that suit, my lord, partition suit is disposed of. Main suit. Against that order, FDP initiated against me. In OS 706, my lord, RFA 706 is pending. Seen before the single bench, my lord. It is posted before the single bench.
That is against the decree, preliminary decree passed in 391.
Please, my lord.
Preliminary decree passed in 391.
Pass in.
The Learned Counsel for the appellant submits.
That is submission made by the
passed in OS number 391 of 2012. RFA number
706 of 2017, my lord.
706 of 2017 is pending before the learned single judge of this court. He therefore submits that this appeal arises out of a final decree proceedings passed pursuant to the preliminary decree in OS number 391 of 2012, and therefore this the value of the subject matter of this appeal does not exceed the sum of rupees 10 lakhs as is valued in RFA
706 of 2017, my lord.
2017. He therefore submits that the appeal is maintained before a learned single judge of this court. Hence, office objection regarding non-furnishing of relevant proof of valuation is overruled. Issue emergent notice to the respondents, list along with RFA number so and so.
My lord, this stay, my lord, because men's profit is order and I have to pay since from the date of suit, my lord.
Deposit money 50%.
My lord, I am the owner of the property, my lord. That's what I am. Suit for partition is pending. Lordship, please kindly pose this matter tomorrow. I'll argue the matter before this honorable court.
Yes. The takeout notice first.
No, my lord, because they are every execution pending is pending, my lord. They attach my property because I am the owner of the property, my lord. The court has directed, my lord, to pay the amount to the.
There is something called Order 21, Rule 26. File an application in the execution. Barcode. Issue emergent notice to the respondents. It is open for the appellants to serve the learned counsel for respondents. Learned counsel for the respondents who appeared before the final decree court or who are represented in RFA 706 of 2017.
Till then, my lord, till then stay may kindly be order for
list on date could yavat ಬೇಕು?
Next week anytime.
Next week. ಅದು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕು.
ಮಾಡ್ತೀನಿ.
List on next week could ಯಾವುದು?
10th April.
ಆಗು.
ಸತ್ಯಾನಂದ್ ಭಂಡಾರಿ. Satyanand BS, sorry.
Satyanand BS.
Chandan K.
Copy has already been served on the same day itself. The documents, my lord. IA2, my lord, which was filed by me.
Suit is for what?
Suit is for permanent injunction, my lord. Seeking a restraint orders against BBMP, my lord, from interfering with the property. My lord, construction of the apartment towers. And also, my lord, from interfering and demolishing the stormwater drain work constructed by the plaintiffs.
Constructed by the
plaintiffs in the suit schedule property and the health. This is the suit, my lord, which has been filed by them, and suit has been decreed by the learned judge, my lord, absolutely restraining me from, my lord, interfering and disturbing the construction work of apartment towers in the suit schedule property, and also from demolishing the.
What is the stage of construction now?
No, construction, they have completed the construction, my lord. I am not supposed to do anything now by virtue of this order.
No, but
This is
what
one
is the-
aspect of the
no, Let
matter.
us see what is the decree.
Please, my lord.
Temporary order of temporary purpose also disturbing the construction work of apartment towers in this. Temporary sponsors or
This is, and then the stormwater drain. I am not supposed to interfere in the stormwater work also.
How
My
can the
lord,
court,
this-
how can the court injunct? Hmm.
According to plan given by them, to construct a cover to the stormwater drain so that we mitigate the property the stormwater drain. So people do not fall in it, and this was more a sewage drain rather than a stormwater. I obtained permission, I construct based on the design and the plan provided by them.
Where is that plan marked?
my lord, exhibit P13. There is no dispute insofar as granting permission by me, my lord. But now what happens is it is granted subject to certain conditions. Conditions of whatever conditions what had been imposed by me, my lord, have been violated. My lord, even to find out that also, my lord, I am restrained now from going into the property at all because it is running into the property. Consequently, my lord, they undertook that they are going to put up construction in accordance with the plan sanctioned by me. That has been done. Now, my lord, this stormwater drain is my property.
No, but what you are restrained is only from demolishing.
Demolishing is, my lord, what have to be done by me now? To find out, my lord, that this particular property, there is some violations and the conditions which have been imposed on me, my lord, have been violated. Now, my lord, I'll have to enter the premises. I'll have to go there, find out.
Who has stopped you? Nobody has stopped you.
They are, my lord, holding this particular order.
Will permit you to inspect the building.
My lord,
OC
in fact, what happened was.
Have you issued an OC?
Please, my lord.
OC is issued?
No, that is insofar as the building is concerned. OC is issued, yes.
ಇನ್ನೇನಕ್ಕೆ
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್ ನನಗೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡೋದಕ್ಕೆ ಅದನ್ನ ಮೇಂಟೈನ್ ಮಾಡೋದಕ್ಕೆ my lord, I'll have to
nobody has stopped you from maintaining
Lord,
it.
with that clarification, my lord, in accordance with law ಅಂತ ಹೇಳಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
Yeah, that is right, but then you should allow them access. You should allow them access to inspect.
They have not even approached there to inspect. They, it is just a glitch.
My lord, it is.
I have never allowed.
In fact, they are
inspecting the thing. It is their property. They can inspect it at any point of.
Fair enough. So therefore, we'll record your statement. We will say that this judgment will not come in the way of the BBMP inspecting, maintaining, and doing anything other than demolishing it.
My lord, what has happened is they have now put up a compound wall on the stormwater drain.
That you have to remove.
Compound, that's exactly, my lord. All these things, this report is placed on record before your lordships along with the additional documents.
There is no compound wall on the stormwater drain. Actually, it is an entrance to the property. It is open. It is a gate. That's all it is there. It is an entrance to the property. The gate is put out there.
Yes.
Anytime they can come and inspect.
Yeah.
I have placed the report, my lord, before your lordships, for your lordship's consideration. My lord, along with the additional documents. This is what, my lords may kindly turn to page 75.
I'm just searching for a young lawyer who can go there and inspect and submit a report. Any young lawyer? Yes, madam. Can you go? New colleague or Chandan? She is not here. Yeah. Can you go as a court commissioner? How many years you put in? How many years of practice you have? 3 months. You're too wrong. How many years? 6 years. 6 years. And you are not young. ಯಾರಾದ್ರೂ ಇದ್ರೆ ಹೇಳಿ. Anybody? ನೀವು ದೊಡ್ಡ ಆಫೀಸು ಬೇಡ ನೀವು ಕೂತ್ಕೊಳ್ಳಿ ಯಾವ್ದು ಚಿಕ್ಕ ಆಫೀಸ್ ಯಾರು ಹೇಳ್ರಿ. Yes, that be spectacled man. Yes. Come. Yes. Let him go inspect. Yes, too.
Something, in fact, it is their appeal, but they should bear the cost. They are making allegations which I am saying I have not done anything. They are allowed to inspect.
Yesterday. How much?
My submission is it is their appeal. They are making allegations.
No, that is right, but both of you will have to bear.
I leave it to your lordships.
Huh?
I leave it to your lordships.
But you have to pay at the spot.
That I will take a decision. I'll instruct my officials.
Barkul.
Reasonable.
Hey, you are not
Nobody is in the apartment association without the owners.
Century Real Estate.
Century Real Estate.
I have exited from the project.
You have sold all the units. All the units are sold.
Then how?
Almost is not all.
And how did they maintain a suit itself?
Anyway, it is you who has developed it. It is you who has developed it. If there's any objectionable construction put up, it is you who is answerable. So therefore, you pay it. It is not as if Barkul. This appeal is filed by the Municipal
Bangalore
Corporation.
North City Corporation.
Bangalore's North City
Corporation.
North City Corporation, challenging the judgment and decree dated 13th August 2025, passed by the 20th Additional City Civil Judge, Bangalore City, in OS number 31226 of 2017, by which the corporation is restrained from demolishing the construction put up by the in the suit property.
Yes.
And also from demolishing the stormwater drain which is developed by the respondents. Full stop. The learned counsel for the appellant submitted that the impugned judgment and decree is coming in the way of the corporation taking steps to inspect the stormwater drain, maintain it. He also submits that a compound is constructed by the plaintiffs over the stormwater drain, thereby obstructing access to the property, to the stormwater drain. He therefore prays that the impugned judgment and decree be modified so as to enable the appellants to inspect the stormwater drain and also maintain it, and if need be, to remove any objectionable construction over the stormwater drain. Full stop. This is, however, contested by the learned counsel for the respondent, who contends that a cover is laid on the stormwater drain as per the permission granted by the appellant vide Exhibit P13, and the building is constructed as per Exhibit P14.
That is a drawing.
P14 is also regarding the stormwater drain.
That's a drawing, my lord.
And also the P13 and 14. He, however, denies that any compound is laid over the stormwater drain and submits that the stormwater drain can be inspected by the corporation at any time, and it is open for it to maintain it. Full stop. Since there is a dispute whether the respondents have put up construction over the stormwater drain, this court felt it appropriate to request Mr.
Dhanvantri Anant.
Mr. Dhanvantri R, who was present in the court.
Anant.
Dhanvantri Anant, who was present in the court, to visit the property and submit a report whether the respondents have constructed have constructed any structure over the stormwater drain and whether access to the stormwater drain is restricted. Full stop. He accepted the request and therefore he is appointed as a court commissioner. Full stop. Office is directed to issue appropriate commission warrant, authorizing him to execute the commission work. Full stop. His fees is fixed at a sum of rupees. Yeah, 1 lakh. ಇಷ್ಟೊಂದು ಜನ ಇದ್ರಲ್ರಿ.
ಅಲ್ಲ, they are all owners,
ಆಯ್ತು.
and owners not with them, it will be very difficult. And let the BBMP, let the share 50%.
One family, see how many flats? YC Rajanna, YR Muralidhar, son of Rajanna, YR Muralidhar, YC Rajanna, Madhusudan. ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಅವ್ರು ಇದ್ರಲ್ರಿ.
ಎಲ್ಲ ಫುಲ್ ಒಂದೇ ಫ್ಯಾಮಿಲಿ, ಎಲ್ಲಾರು ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೆವಲಪ್ಮೆಂಟ್.
These are the owners of the
They are the owners
property
of
or
that
the
particular
flat?
property.
They are the landowners.
Landowners.
ಒಂದ್ಸಲ JD ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರುಗಳು it will be very difficult for them to even bring for registration.
ಆಯ್ತು, 1 ಲಕ್ಷ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ. 50,000 both of you.
Yes.
1 lakh payable by the petition appellant as well as the respondents in by the payable 50% of which is payable by the appellant and 50% of the remaining is payable by the respondents at the spot. Full stop. The commissioner shall execute the warrant on, when can you go?
Anytime, my lord. I lived up to.
I asked you, you're asking, don't tell it to me. When can you go, Andre? You tell me what day is convenient to you.
My lord, anytime next week, man.
Good. ಯಾವ ತರ ಕೊಡಿ?
4th you are ready? This.
4th
April.
6th or 7th.
ಆಯ್ತು. 11th is a holiday.
6th or 7th.
6th, Monday.
Yes, ma'am.
Monday is okay?
Yes, ma'am.
6th March 2026 at 11 a.m.
11.
It is open for the appellant as well as the respondents to be present at the spot. Full stop. The commissioner's fee shall be payable without fail at the spot. Yes. Report shall be submitted by or before 9th of April 2026. List on 16th April. Yes.
Can it be on 17th, my lord? If my lord.
17th April.
Aye.
Sachin, ಯಾರಿಗೆ? ಎಲ್ಲಿ ಇದು ಚಂದನ್, will you accept notice for the other respondents?
Lord, 1 to 28 I have accepted notice.
Last day itself he has made a submission.
ಇನ್ಯಾರು ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
ಅದಿನ್ನು BDA and ಮತ್ತೆ BMTF. In fact, crime was registered against them.
Were they parties before the trial?
Yes, they were parties.
BDA na?
ಹೌದು, ಇಬ್ರು ನಾನ್ ಕಂಟೆಸ್ಟಿಂಗ್.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. BDA ಯಾರು? Mr. K. Krishna has directed accept notice for respondent number 30. BMTF
was placed ex parte before the trial court.
Since 29, respondent number 29 was placed ex parte, notice to respondent number 29 is not necessary and is dispensed.
Please.
Yes.
Number 8, Sachin BS.
Sachin BS. Pawan Chandra Shetty.
The affair for the appellant. Lords, the service, my lords, for R3 and R4, my lords, it is unclaimed. Lord, and so far as others, my lords, will take out, my lords, notice to others today, in the course of the day.
Pardon?
Lords, R6 to R1, R2, R6 to 9, my lords, it's showing, my lords, furnishing of PF for second time.
Notice R3 and R4 same address,
Same address.
Compare, nodidra.
Lords.
Barkoldi, the notice issued to the respondent number 3 and 4 is not claimed. The address of the respondents 3 and 4 mentioned in the cause title of this appeal corresponds with their address mentioned before the trial court. In that way of the matter, notice to the respondent number 3 and 4 is held sufficient. Office is directed to show their names in the cause list and also indicate that notice to them is held sufficient. 1 week time is granted to take process to serve the other unserved respondents.
Lords, insofar as, my lords, interim order, my lords, on the last occasion, my lords, have directed, lords may hear the interim order.
But you notice issue as
Lords,
the
R10
interim
to 13, my lords, we are seeking for interim order. They are represented, my lords, by the council. Lords, R10 to 13.
The partition decree.
Partition decreed, my lords, there are 6 items scheduled properties. My
What is the stay you want?
Lords of the, my lords, in injunction, my lords, so far as the R10 to 13 is concerned, my lords. Not to alienate, my lords, is
So
what
suit
I'm
is
saying.
dismissed.
Suit, my lords,
Yes,
there are
my
6 item scheduled properties. 5 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, 1 ರಲ್ಲಿ dismiss ಮಾಡಿದ್ದಾರೆ. Defendant number 5, my lords, based on
But,
the.
please, my lord. Against the, my lord, item number 5, the property which has been purchased by me, my lord, through by way of general power of attorney.
I will consider that.
My lord,
Don't alienate it.
Before the trial court, there is no interim injunction order against the item number 5, except other properties.
Was there an
Lords,
injunction?
No, my lords, I've stated
No.
4/12/2020, there is an interim order.
No, before the trial court, no, my lord.
4/12?
2020, my lords, interim order, I've stated in my affidavit. 4/12.
Then, my lord, one more humble
So is it in
submission.
respect of item number 5 also?
5. Item number 5, my lord, I have purchased through the family.
Was there the interim order?
No, my lord, there is no interim. That is, my lord, my submission. It may be kindly record on the, my lord, on behalf of the bar.
On behalf of the bar, Andre?
I am representing, my lord, on behalf of the, my lord, respondents.
Correct.
That is my statement.
On instructions or?
On the
without-
instruction.
On instruction.
On the instruction.
Yes, you have a
I
copy.
have asked specifically with the counterpart advocate also, whether, my lord, item number property, whether any injunction order is there or not. Then, my lord, your lordship may kindly peruse the, my lord, running page number 7, cost title for a moment. Only one appellant came before this honorable court, my lord, that is the daughter. None other than, my lord, respond number 1,
Passport,
2.
you get that order, let us.
Please.
The ex parte interim order is there, my lords, copy. Lords, final
After
order,
that
my lords,
vacated.
I'll-
Noted, yes,
Please,
pass
I'll-
over.
Serial number 9.
My lord,
Mahesh Ayya, Rudraya.
Maintainability of this appeal. Yes, madam.
My lord, in this case, my lord, the district court itself has passed the judgment, my lord. So I have filed this as a RFA, my lord. Kindly convert this RFA into MFA, my lord.
MFN.
Yes, my lord.
This is a PNDC matter.
Yes, my lord.
Barcode. This appeal arises out of an order dated 8/1/2026 passed by the 3rd Additional District and Sessions Judge Shumoga in PNDC 17/2020, which was treated as OS number 6/2021. Full stop. In view of the remedy of an appeal provided under the Indian Succession Act, an appeal under section 96 of CPC is not maintainable. Hence, the appellant is permitted to convert this appeal, this regular first appeal, to miscellaneous first appeal. So for statistical purposes, this appeal is treated as closed. Counsel for the appellant is directed to make appropriate corrections to bring it in line with the format of a miscellaneous first appeal as prescribed under the rules. Yes.
Serial number 10, Gopal Gowda, HK.
Appear for appellants, my lord. It's an appeal filed against the order of granting probate in the PNDC proceedings. Instead of filing MFA, RFA is filed.
Same order.
Serial number 11, Hanmantappa Harvi.
Hanmantappa Harvi. Plaintiff share does not exceed 10 lakhs. Barcode. Office, this is an appeal that arises out of a judgment and decree for partition. It is stated in the valuation slip that the value of the property is 10 lakhs and the plaintiff's share works out to 5 lakhs. In view of section 19(1) of the Karnataka Civil Courts Act, the appeal is to be tried by the district court. Hence the district court. Hence the office is directed to return the appeal papers, and the appellant is permitted to present the same before the appropriate district court. For statistical purposes, this appeal is treated as closed in this court. Yes.
Serial number 12, Varun Jaikumar Patil.
I'm for the appellant. I may be permitted to withdraw this
The
appeal.
memo
and
is
file-
filed by the learned counsel for the appellant to withdraw the appeal. In view of the memo, the appeal is dismissed as withdrawn. It is open for the appellant to
File before the district court.
present the appeal before the concerned district court.
Your lordship may kindly direct to return the certified copies, my lord.
Office is directed to return the certified copy of the impugned judgment and decree after retaining a photocopy. Yes.
For hearing on IA, serial number 13, Pawan A.
Modification. What is this modification?
Yes, my lords. My lords, this IA is filed. Praying for modification of the order of this honorable court passed on the 18th of March 2026.
What is the mistake?
My lords, if I may please
content, there's no
direct you
procedure for
to
issuing
paragraph
solicitation
8 and 9 of the order, my lords. May I read, my lords? Page 20 of the IA.
The petition granted opposition.
Yes.
Yes, Mr.
My lords, the difficulty faced by the learned trial court was that though paragraph 8 stated that it highlighted the predicament of the petitioners that they are not able to obtain the solvency certificate from the state of Tamil Nadu. However, in paragraph 9, the very same difficulty has arisen, my lords.
Correct, Mr. Either local or for many person in Tamil Nadu who has a solvency certificate.
Correct, my lords. But Tamil Nadu, by a GO dated 26th May 2025.
No, but see, there should be some solvency because you can't furnish some documents which is mortgaged to some bank or a charge is created in favor of some bank. You can't bring that property and give us surety.
Yes, my lords.
You can't bring those properties as surety.
Well, as far as the case is concerned, my lords, so basically what had happened was we tried to secure sureties, my lords, either in local or in jurisdiction of Tamil Nadu, my lords. They have no accountances. That was the difficulty faced by me. So with respect to the order, my lords, I tried to comply, and with all the difficulty, my lords, we secured the solvency certificate from the bank. Along with the solvency certificate with the bank, we produced 4 to 5 documents, my lords, including the net worth certificate.
Solvency certificate of some person in Tamil Nadu.
Please, my lords. Solvency certificate issued by the bank, and also along with that, I placed 5 documents, my lords, along with the affidavit, my lords. Let me produce the documents to your lordships.
No, within 2 weeks' time was given.
I completed, my lords. Yes, my lords. That the 2 weeks time period got over.
When did you apply?
My lords, I filed everything on the date of 26th of March, my lords. Because the order dated of this honorable court was 18th March. 19, 20, 21 was the holiday. Thereafter, on 26th, I produced all the sureties, and I also appeared before the learned trial court. And subsequently, my lords,
so what is the difficulty? What is the trial?
Well, the learned trial court has actually rejected my sureties, citing this particular paragraph of this honorable court, saying that I cannot interpret the order, and you produce the solvency certificate issued by the revenue authorities.
Where is the order passed?
Please. It is in page number 13 and 14 of the IA, my lords. If my lordship may considered page number 14. In page number 13, my lords, at the bottom of the IA, my lords. May I read, my lords? Accused number 1 to 3 present. 1 PA advocate files wakalat for accused number 1 to 3 and files certified copy of the order of this honorable High Court in criminal 4411 of 2026. Along with this said order, the counsel for accused also files surety affidavit along with the solvency certificate issued by Canara Bank, Ganapati branch, Coimbatore. Surety. So next 2 paragraphs, my lords, it describes the sureties, my lords. And in page number 14, my lords, however, second paragraph, however, on perusal of order of Honorable High Court Karnataka in para number 9, the Honorable High Court has directed the accused to furnish surety either local or from any person in Tamil Nadu who has a solvency certificate from the concerned revenue authority. Hence, the sureties are present not in accordance with order of the Honorable High Court. That's my difficulty, my lords. Unfortunately, my lords, the paragraph number 9 said to have become infructuous to the entire order, my lords, because considering the paragraph 8 of this Honorable Court, where it has been clearly recorded, my lords, that is my entire difficulty. That is the sole reason why this Honorable Court has set aside the trial court's order. I complied with all the necessary conditions.
You can't modify this order.
Please, my lords.
You have to challenge the order passed by the trial court.
I
don't have power of review, mister.
This is not a review, my lords. This is just a clarification because
you file a fresh petition.
My lords, the difficulty is. Please, my lords. My lords, may I make a submission, my
Okay,
lords?
1 of 4 of 26 is filed for modification of the order dated 18/3/2026. Since once an order is passed, a criminal court, including this court, is not entitled to, this court cannot review its order. And therefore, the review or modify its order. Hence, IA 4 of 26 is rejected. However, liberty is reserved to the petitioner to challenge the order passed by the trial court, rejecting the surety furnished pursuant to the order passed by this court.
May I please, my lords? I'm not, I bow down, my lords, but I'm not pressing for the modification. What I'm actually praying before your lordship is to just seek a clarification with respect to the concerned revenue authority.
Whatever it is, I have to modify it. I can't do it.
Please, my lords, I also face my difficulty because on 27th, the very next day, I filed this IA, and also on the 27th, I appeared before the IO. Now, IO is threatening me, saying that I will arrest you if you're not getting the bail.
Move the petition on
My lords,
Monday. I'll take it.
Then liberty may be extended to the petitioners by.
Take
Because
it up
if-
on Monday, Mr. You move it.
My lords,
Move it at 10:30. I'll take it up at 2:30.
Please, my lords.
Yes,
I'll do that.
next.
My lords, also one more suggestion, my lords. Let there be no apprehension during
No,
this.
no. Yes, next.
Serial number 14, B.
Okay.
Ramesh.
B. Ramesh.
Suit for bare injunction.
Admit ಆಗಿದೆಯಾ?
ಆಗಿದೆ. Next
Yeah,
week.
125 is allowed and the officers directed to list this appeal for hearing on ಯಾವತ್ತು ಹೇಳಿ?
Next week.
After vacation.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ ಯಾವತ್ತು ತಗೊಳ್ಳೋಣ. Any
After
date.
vacation. There is some urgency, my lord.
Please pick ಇಬ್ರು ಡಿಸೈಡ್ ಮಾಡಿ ಯಾವ ಡೇಟ್
16th, my lord.
6 after vacation.
6th? 6th of June, yes.
Serial number
Manjunath.
Right of the vacation, my lord. So
Manjunath
take a
H.
chance.
Anusha B. Reddy.
16th, my lord.
He is not ready ಏನ್ ಮಾಡು?
My lord, he is now trying to interfering with my position by taking advantage.
Is there
He is
any
not at
interim
all-
order?
Yes, my lord.
Interim order ಇದೆಯಾ?
ಇದೆ.
ಮತ್ತೆ? Yes, Manjunath.
For the appellant's counsel. But there's a,
ನಮಗ್ 6 is Saturday. ಅವ್ರ ಹೆಸರೆಂತ ಕರೀರಿ ಅವ್ರನ್ನ.
ವೀರ ರಮೇಶ್ ಸರ್.
6 Saturday ಆಗುತ್ತೆ.
8th June ಕೊಡ.
5th ಕೊಡಿ. 5th June.
Serial number 15.
appellant's counsel.
Manjunath H.
But there's a delay of 4,245 days. The suit was filed for rectification of the sale deed. And the suit came to be dismissed on 18/6/2009.
Yes.
The suit was being prosecuted by the husband of the appellant. There were other 2 suits which were pending and which was being diligently prosecuted by the husband of the appellant. Appellant's husband passed away in 2012, my lord. This suit came to be dismissed in 2009. And I have produced medical records to demonstrate that he was undergoing dialysis and he was ill. They reside their permanent residence of Hyderabad. They were residing in Hyderabad and she was unaware of the present suit. Well, present.
Who was residing in Hyderabad?
The appellant, my lord. Appellant, he is a permanent resident of Hyderabad. This relates to a property which she has purchased in the year 1994. There was a suit filed by her in 2004 seeking for a bare
Who is
injunction.
this Venkateshwarlu?
Venkateshwarlu is the husband of the appellant. GPA holder, who was the GPA holder. He passed away in 2012, my lord. He was on dialysis for a period of almost 3 years from 2009. She was unaware of this. She became aware of this dismissal only in the year 2022, wherein she had filed a suit for bare injunction. In that, the respondent herein, who has been impleaded, who is a subsequent purchaser, files this judgment, and that is when she becomes aware that the suit has been dismissed. She was unaware of the pendency or the dismissal of the suit. And if your lordship may
No, this judgment was marked as an exhibit in some other suit.
No, my lord. They filed along with the written statement.
In which suit?
In the suit which was filed by her in 2021 for against the respondent for bare injunction.
For bare injunction.
Bare injunction. In that, along with the WOS, this judgment came to be filed. That is when she becomes aware of that, and that is when the
lot of confusion created unless dates are provided. Not for your lordships. A lot of confusion unless dates are supplied to your lordships. Please have a. There are 4 suits that are filed between 2004 and 2021. Now there are some dates which are very crucial. Just plus, please see, Lord.
18/6/2009, which is the fifth entry. OS 3599 of 2008 is dismissed. But against the dismissal of this suit, the present RFA was filed in 2023 November. 14 years delay. But please see, I'll have to show your lordships what are the 4 interconnected litigations that have been pending since
Have you
2004.
filed objections to this application?
Yes, I have filed. I have filed. Just please come to the first date. The 2004 suit, in which the present appellant is the plaintiff, she files a bare injunction suit concerning 3/3B. She says she's the owner in possession of 3/3B. She traces her title to a sale deed of the year 1994, and her sale deed reflects that she is owner of 3/3B. In 2006, respondent number 7, his vendors file a comprehensive title suit for declaration of title concerning 3/3B, in which the appellant is included as defendant number 2. Comprehensive title suit.
Now, this 8729 is also filed by the husband?
Please, as GPA holder, filed by the husband. Bare injunction suit. 2006 suit is filed by my vendors for comprehensive title declaration. In 2007, the 2004 suit is dismissed for non-prosecution. In 2008, that suit is restored by the son. By the son.
When did the husband die?
Husband died in 2012. I'll come to that. 2012, November. In 2008, 3599 is filed by the appellant before Lordship Kusuma Kumari against her vendors, in which she claims that what I have purchased is not 3/3B, I have purchased 17/2A, so kindly rectify. Defendants are placed ex parte. Ex parte, that suit is dismissed. Ex parte. Now please come to 2009. In 2009, I filed my written statement. The defendants filed their written statement. And in 2009, please see, in 8729 of 2004, they amend their suit schedule property. They now say what I have the suit schedule property is amended from 3/3B to 17/2A after dismissal of their rectification suit in which they failed. So in the rectification suit, they said what I have purchased is 17/2A, not 3/3B. That suit is dismissed when the defendants are placed ex parte. And then they amend their own claim in 2004, to which they now change the survey number from 3/3B to 17/2A. In 2010, they bring about a further amendment. They add a relief of title declaration. So what was an injunction suit concerning 3/3B by 2010 has become a title declaration concerning 17/2A, notwithstanding the fact that her suit
What has happened to OS number 9897 of 2006?
decreed in my favor in 2025 September. Now please see 2010.
Is there any appeal against that?
Pending, still in office objections, not compliant. Now please see in 2012, Venkateshwarlu, the husband, dies. And in their affidavit, they say it was only Venkateshwarlu who was aware of all my litigations. From 2009 to 23, they had to explain day by day account. Kartiji principle has now been diluted. Now please see what happens after 2012. In 2013, she executes a GPA in favor of her son. The son has litigated the 2004 suit, the 2006 suit consciously, continuously from 2004 and 2006 all the way to 2005. Again, the suit is dismissed for non-prosecution. So the 2004 suit which he is litigating is dismissed twice for non-prosecution. Twice it is restored. The son enters the box as PW1 in the 2004 suit. In the 2006 suit, the son enters the box to represent the mother. Throughout, I have the entire order sheet to show that from 2004, in the 2004 suit and the 2006 suit, I have an entire order sheet to show in 2006. From 2006, when it was filed as defendant number 2, all the way to 2025, when it was decreed, conscious participation has entered the box, has cross-examined me, has done everything.
Yes. Who are the
Additional examination in chief file.
Who are the defendants in OS 8729?
I am one of the defendants, not there are a line of defendants.
Who are?
I'll just tell you.
Vendors, my lord, and
vendors,
his
my
vendors.
who are also the plaintiffs in 2006 suit. Hafizur Rahman and all his family relatives.
Vendors and
myself, not defendant number 9, Ganesh Babu, who traces his title from Hafizur Rahman.
Ganesh Babu. 98, 97 is filed by Ganesh Babu.
Ganesh Babu's vendors, Ganesh Babu is also a plaintiff.
8729.
8729 is
Yes.
filed by
3599 is filed by Kusuma
Suma
Kumar.
Kumari, who is also the plaintiff in the 2004 suit.
To Venkat Lakshmana.
Now one more suit is there.
5621.
5156.
5156. That is filed against whom?
That is also filed by Kusuma Kumari against the vendors and myself, Ganesh Babu.
Vendors in the yard. What's her name?
Hafizur Rahman.
Hafiz.
Hafizur Rahman. Concerning the same suit schedule property, 17/2A.
Ganesh Babu.
Yes.
Yes, madam.
Please. And she claims in her affidavit, for the first time she got to know that the 2008 suit, which was dismissed in 2009, in which she is seeking for rectification, because without the rectification, she'll fail in her 2004 suit. In her 2004 suit, she's claiming title to 17/2A on amended pleadings when her title deed shows 3/3B. So she realized that having failed there now, unless I have my suit rectified and I file an appeal, in 2023, this appeal is filed.
Yes, ma'am.
Please. My lord, what my learned friend has stated about the pendency of the suits and the filings of the suits are correct. My husband passes away on 27/11/2012. My lord. I give power of attorney to my son in 2023. So
20?
he had 2013. My lord.
How about this miscellaneous is filed by him?
No, it is not filed by. It is filed by Venkateswarulu. He was alive. In 2007, the miscellaneous gets filed. It is filed by Venkateswarulu because he had the GPA. The GPA came to be executed in favor of the son only in the year 2013.
Yes.
Subsequently, my lord, that there was a miscellaneous file that was also dismissed. Subsequently, filed by the son, my lord. Son takes over from 2013. Both the suits.
Who gave evidence in miscellaneous?
In the miscellaneous in 2007, husband had given the, in 2007, my lord. In 2014, there was another miscellaneous file. For that,
I'm not talking of the second miscellaneous. First
first
miscellaneous.
husband has given the evidence.
Yes.
Husband was very much alive at that time in 2007. 2012 is when he passes away. The present suit appeal arises out of a suit filed for rectification of the sale deed. The defendants were placed ex parte, my lord. I am not going on the merits of the matter, but it gets dismissed in 2009 within a span of 1 year. And he had fallen ill from 2009. I have produced documents to demonstrate that he was ill and undergoing dialysis, and he passes away in 2012. The son and the wife prosecute the pending suits, and in 9897 there is a decree in their favor which is for 3/3B. My specific case before the court is that there is a correction which needs to be done to my sale deed. Hence, my rectification suit was filed. Subsequently, my lord, for my bare injunction suit which was filed in 2004, I amend the prayer to seek for declaration of ownership on 17/2A. I am relying on a survey which was done by the Tahsildar's office. Based on that survey, my lord, I have amended my claim in 8729, which is the 2004 suit, which is pending for final arguments now before the trial court. 8729.
3599, you can pursue it, isn't it? Sorry, 8724.
8729, I have, my lord. That is also for declaration that I am the owner in 17/2A, not 3/3B. Because I am relying on a survey report of the Tahsildar. Now, this suit which has been dismissed, I became aware of it only in 2022. So that is why I am before your lordships now seeking. All these are correct, my lord. All these are pending. My lord, as a owner of the property, I wouldn't have received any benefit by not challenging this. The moment I became aware of the suit which has been dismissed, filed by which was being prosecuted through my husband, I have come before your lordship seeking for.
On what ground this is dismissed?
My lord, dismissed on the ground that impugned order is at Annexure A, my lord, at page 25 of the appeal memo. Lord, the court goes on to say that in the sale deed there is no averment that the vendor of my vendor was possessing the property as a ancestral property, but there is a specific averment in the sale deed itself. And also there are a lot of issues, my lord, which the court comes to the final conclusion. My prayer before the court was that my sale deed needs to be rectified to denote 17/2A. Ultimately, the court says that I am not the owner of 17/2. My prayer was that I am the owner of 17/2. My prayer was that I am the owner of 17/2A.
Now, you please come to internal page 7. Read the first paragraph.
Please.
ಈ ವಿಷಯದ ಬಗ್ಗೆ ವಾದಿ ಪರ ವಕೀಲರು
ವಾದಿಸುತ್ತಾ ತಮ್ಮ ಕ್ರಯಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಿರುವ ಚಕ್ಕುಬಂದಿ ಸರಿಯಾಗಿದೆ, ಆದ್ದರಿಂದ ತಮಗೆ ಪ್ರತಿವಾದಿಗಳು ಮಾರಾಟ ಮಾಡಿರುವ ಆಸ್ತಿ ನಂಬರ್ 3/3B ರಲ್ಲಿ ಇಲ್ಲ, ಅದು 17/2A ರಲ್ಲಿ ಇದೆ ಎಂದು ವಾದಿಸುತ್ತಾ ಈ ಕಾರಣಕ್ಕಾಗಿ ತಮಗೆ ಮಾರಾಟ ಮಾಡಿರುವ ಆಸ್ತಿಯು ಗಾಣಕಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 17/2A ರಲ್ಲಿ ಇದೆ ಎಂದು ವಾದಿಸಿರುತ್ತಾರೆ.
So how is your suit maintainable for perpetual injunction?
For rectification, my prayer was for rectification of the
3539 is for rectification.
Please, my lord, it is for rectification. My prayer was for rectification. If your lordship may kindly look at even the issues framed, my lord, at page internal page 5, ತೀರ್ಮಾನಿಸಬೇಕಾದ ಅಂಶಗಳೇನೆಂದರೆ ಪ್ರತಿವಾದಿಯರು ಹಾಗೂ ಗಾಳಿ ಚೂಡಯ್ಯ ಅವರ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಆದ ಎಲ್ ಮುನಿಸ್ವಾಮಿ ಅವರ ಮೂಲಕ ವಾದಿಯು ಖರೀದಿಸಿದ ಆಸ್ತಿಯು ಗಾಣಕಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 17/2A ರಲ್ಲಿ ಇದೆ ಎಂದು ಸಾಬೀತುಪಡಿಸುವರೆ. ತಮ್ಮ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಆಗಿರುವ ತಪ್ಪನ್ನು ಸರಿಪಡಿಸಿ ಕೊಡಿ ಎಂದು ವಾದಿ ಪ್ರತಿವಾದಿಯವರನ್ನು ಕೇಳಿದರೂ ಕೂಡ ಪ್ರತಿವಾದಿಯವರು ವಿನಾಕಾರಣ ನಿರಾಕರಿಸುತ್ತಿದ್ದಾರೆ ಎಂದು ವಾದಿ ಸಾಬೀತುಪಡಿಸುವರೆ. ವಾದಿ ಕೋರಿರುವಂತೆ ಕರ್ತವ್ಯ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಡಿಕ್ರಿ ಹೊಂದಲು ಅರ್ಹರೆ. This was my prayer, and I had made the owners of the property from whom I had purchased the property as the defendants. All of them were placed ex parte. The court, my lord, even in the finding, my lord, at internal page 8, my lord, Chakkubandi also I had provided, because what he is claiming as 3/3B, that has a nala going through. My Chakkubandi doesn't have a nala at all. So it is 17/2A, which I am relying on the
9897 of 2006 is already decreed.
Well, that is for 3/3B. I am not saying that I am the owner of 3/3B. My specific case is that I am owner of 17/2A, because the schedule is also completely different. My vendor, my lord, purchased property, had property in 17/2. That got ported into 17/2A and 2B. 2B, his vendor purchases it, and 2A is sold to me and to 6 other persons. A form, a layout came to be formed. I have paid 2.5 lakhs to BDA when there was a acquisition notification for as betterment charges. Those documents were not considered by the trial court to demonstrate that I was in possession of the property. And in 8729 of 2004, my lord, even till date, I have the injunction in my favor, because the injunction which was granted in 2007, confirmed in 2007, continues till date. It is a vacant site, my lord. I continue to be in possession of the vacant site. My suit, my lord, 8729, which is declaration, is pending for final arguments now.
Yes.
So the delay, my lord, is entirely because my husband was
You have
prosecuted.
filed a separate suit for declaration.
8729 of 2004 is my suit for declaration and injunction, my lord. It was a bare injunction, my lord. In 2010, I amended it to seek for declaration that I am the property.
You pursue that suit.
Lord, only trouble would be because this suit that I have not prosecuted for rectification.
That's okay, but then you pursue that suit.
It is at the final arguments, my lord, because if I can get the sale deed rectified, my lord, that declaration is a declaration would because this suit would help me in the
nature of
declaration
that you sought for.
Please, my lord.
What is the nature of declaration that you sought for?
In the 2004 suit, my lord, declare that I am the owner of survey number 17/2A.
So therefore,
please, my lord, I am seeking for that.
So therefore, you
But
pursue that suit.
this rectification was dismissed when it was brought to my notice, my lord. I
Yours
have.
8729 of 2004 was
Please.
the earlier suit.
Please, my lord, earlier suit, my lord.
So therefore, you pursue that suit.
My lord, it was brought to the notice of the party, so there was a necessity for them to, because they were taking it as a contention that this is not challenged and it is still validated, because there is no challenge made to this judgment. And the rectification suit is dismissed, hence they are not entitled for declaration as well, is one of the contention they are
When
taking.
was the declaration permitted?
In 2010, my lord.
2010.
I made an application, and pursuant to which it has been.
She will say, she will give the details. Wait, why are you jumping?
Subsequently, my lord, the respondent
When
before your
was this
lordship,
judgment marked in OS 98-97?
it has not been marked, my lord.
No, you said just now that it was marked.
No, it is not marked, my lord. It's not, nowhere has it been marked.
You said it was produced in some suit.
No, it was produced in 5159, my lord, which is my 5156, which was my bare injunction suit. 5156 of
It was
2021.
produced, is it?
It was filed, produced by the respondent in along with the written statement.
When was that?
This was produced by them in October of 2022, my lord, when they filed the written statement.
October 22.
22, my lord.
Yes, Mr. Is that a fact? When did you file this copy of the judgment passed in this suit?
Copy of the judgment passed in?
OS number 3399.
But in my objections, I've stated no. The actual facts in my objection. Your lordship will have my objections.
She was informed by her counsel in OS so and so that OS number has been dismissed.
Please see her affidavit. That is not even her case in affidavit.
Mr. When did you file a copy of this judgment in OS number 5156?
In my written statement, I have stated in 51.
When was that?
That I did. In 22, Lord, I don't have the exact date, Lord. In 2022. In 2022.
Yes.
I'll have the exact date given. Therefore, Lord, there are 3 judgments that I want to place in the Lord. But just to summarize my submission, 4 connected litigations. Twice her own suit is dismissed for non-prosecution. The 2004 suit is dismissed for non-prosecution. Husband dies in 2012. The computation has to start from the date of dismissal of her own suit, that is 2009. From 2009, if you compute to the date when they filed the RFA, 14 years delay.
Yes.
There is no accounting for the delay, even from the date of the death of the husband. When the son enters the box, is conducting all of these litigations interconnected. The son has led evidence on behalf of the plaintiff.
Who is the lawyer in all these suits?
Lawyer in the
Who is the advocate engaged by the appellant's husband in all these suits? Is he the same lawyer?
Lord, there has been change in lawyers, my lord.
No,
From
please tell us.
2023, there's a lawyer who has
Who is
been.
the advocate? The 3599 of 2008 is one Mr. T. Venkatram.
Please, my lord.
Whether
He's
he
not
is the same
no,
lawyer
no,
in
my lord.
other suits? OS
He
8729.
doesn't continue to be the lawyer.
I just get instructions on that and place because that is relevant. What your lordship asked is absolutely relevant. Because there are 4 connected suits. They have changed counsel after the death in 2015, in 2019, in 2020.
Therefore,
I'll just check that.
if the man is dead, the lady might be sitting at home. She may not. She might be oblivious as to what is happening in Bangalore.
The son has entered the box.
That is 2013, Mr. 2013. How would he know if the father has gone without leaving any information? How would the son know?
Because the son, as a GP holder, has to testify that he's fully aware. If he does not testify.
Be practical. Be practical. The man is dead and gone.
Yes.
He was handling the litigation.
Yes.
The lady was sitting in Hyderabad.
Yes.
Correct. Lady and the son were sitting in Hyderabad.
Correct.
They were oblivious as to what is happening in Bangalore. What are the numbers, case numbers? Everything was being handled by the husband.
Even in 2020, I'll produce the.
And you mentioned that in the written statement filed in 2022.
That's not the first time when I mentioned it. Not even
I don't know. That is what you said.
When he came in the box, there are certain cross-examination that I'll place to your lordship.
For them to come to know about the dismissal of 3599, they would obviously come to know only after written statement is filed.
In 5156.
In 5156.
But even in 2004 and 2006, he's actively litigating.
That man is dead, mister. Man is dead in 2012.
Lord, I'll show you lordship.
Find out if the lawyer is the same. If the lawyer is same, I think you have a point. Otherwise, this application will have to be.
Cross he has been brought to his notice in the cross in 2004 and 2006 that he is aware of.
Yes. No, if you want to attribute knowledge,
yes, some document has to show.
Yes. Yavattu?
Whenever my lord is here.
My lord, next
No,
week.
you have to bring information, not, you said you will take, you will get information.
20th. 21st.
Any Thursday, Friday?
Thursday, Friday, 23rd.
Please.
23rd, list on 20. Learned counsel for the respondent number 7 and the learned senior counsel for the appellant is directed to place on record the name of the advocate who represented the appellant
Please.
in OS number
All the connected litigation.
8729 of 2004, comma
9897 of 2006, my lord. 97 of 2006 and
9897 of 2006.
and 5156.
359 we already have.
Please.
5156 of 2021. Yes.
Please.
Serial number 16, government advocate. Serial number 16.
Government advocate.
In this case.
7878.
No, actually, it is not 7878. When from date of knowledge, it is only a
Date
few
of knowledge,
days, my lord.
you are not served.
No, government is not served, my lord.
What do you mean government is not served?
It is
How did
stated
the
to be,
case
it
proceed
is
then?
stated to be served personally in the office of the Tahsildar office.
No,
But,
whether the deputy commissioner and
Chief
the-
Secretary is also party to the suit, but is not served on the Chief Secretary.
How was the process taken out?
Personally, in hand by they have served personally.
ಎಲ್ಲಿದೆ?
ಅದು suit ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್.
ಓದಿ ಎಲ್ಲಿದೆ ಅಂತ?
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ.
Hence issue suit summons and emergent notice on IA1. Call on 22-1.
That's the LR application. 2-1 ಆಯ್ತಾ and 17
D1 to
process is
D3
paid.
served. District government ಇದೆಯಲ್ಲ ಇದನ್ನು by DGS.
Sorry, I don't have that.
22-1-1998.
Same day, 22-1 and same day it is served on. Served in the office, not in person.
No, whether through court ಹೋಯ್ತಾ ಹೆಂಗೋಯ್ತು?
ಅಲ್ಲ ಕೋರ್ಟ್ ಮುಖಾಂತರ.
ಹೌದು, ಸಮನ್
Court ಮುಖಾಂತರ.
ಸರ್ವಾಗಿದೆ. ಸಮನ್ ಸರ್ವಾಗಿದೆ.
ಹಾ.
Not in para 5 of their appeal. Issue notice ಅಂತ ಆಯ್ತು. ಇವರು ಯಾರು ತಗೊಂಡೋದ್ರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. 22 and records ಅಲ್ಲಿ ಇದೆ. Court records ಅಲ್ಲಿ ಇದೆ. Court records ಅಲ್ಲಿ ಇದೆ. No, in para 5 of their appeal they admit that.
ಏನಂತ?
The plaintiff has paid the process fee on 17/1/1998 and the suit summons is personally served on the defendants appellants number 1 to 3 on 20th January 1998 within 15 days from the date of paying the process fee, and on 22/1/1998 the defendants appellants were placed ex parte.
This for what?
Suit is for declaration that I have become owner by adverse possession. That is decreed. Now, now please see the additional affidavit that they have filed, my lord, before your lordship for condonation of delay. Please see para 4.
Yes.
But the suit is decreed. And 2000. Sorry.
Para 4.
Suit was decreed on 24/2/2000, my lord. Now, lord, para 4, I say that RTCs, entries in the RTCs came to be made in the name of the respondent on 5/2/2020, and such entries do not confer any title that I can leave. Then, my lord, next paragraph, I state that on 29/6/2000, the respondent filed writ petition seeking to consider the representation for change of kata, and this honorable court video order dated 21/7/2000 allowed the writ petition directing the Tahsildar to consider the representation that on 5/8/2000 and 28/4/2005, respondent made a representation to the Assistant Commissioner, Bangalore North Division for change of kata. Said representation was pending consideration. I state that subsequent proceedings, then para 6, my lord, I state that on 15/11/2018, the respondent filed an appeal before the Assistant Commissioner, Bangalore North Subdivision, seeking an entry of her name in the RTC based on the decree in OS number 1998, 21 of 1998, and the Assistant Commissioner by order dated 18/3 so and so 90 directed the Tahsildar to mutate the name of the respondent in the revenue records. Then, my lord, another writ petition was filed, my lord, which is mentioned at para 7. Then another writ petition is filed, my lord, which is mentioned in para 8, which by which, my lord, the petition, the respondent, my lord, sought Podi. Now that was, my lord, ordered, my lord, in favor of the respondent. Thereafter, contempt was filed. An assurance was given to this court, my lord, that they will conduct the Podi. Thereafter, my lord, they filed this appeal and said that we have filed the appeals. Therefore, the contempt was dropped. So they cannot say that we don't have knowledge. Proposed.
In 1966 ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನಿದೆ ನಿಮ್ಮ ಹತ್ರ? What documents you have produced to show that you are in possession from 1966 to the knowledge?
Lord,
from 1966.
He made an application, my lord, in 1991, my lord. For Lord, regularization of unauthorized cultivation. That, my lord, they are saying that was rejected in 1997. I'm sorry. That was rejected.
98.
Yes, 1998.
And thereafter you filed a suit?
Yes. Thereafter I filed the suit. Because there was attempt to dispossess.
No, where have you mentioned about filing of an application?
Lord, the plaint and other things are not with me at the moment.
No, if you have suppressed material fact, then limitation.
No, that would not amount to a suppression, my lord.
No,
Lord, I am claiming adverse possession on the ground that I am in unauthorized possession.
From 1991, if you had filed an application, then the time gets arrested from 1966.
Lord, point is this, from 1965 I am in possession. In 1991 I may have made the application.
Yes.
But that doesn't mean that, Lord, my possession is not adverse. My possession was adverse.
But
all along.
From 91,
yes,
because of the application, they could not have dispossessed you.
No, that.
Because of the application, they could not have dispossessed you.
No, Lord, see, please see the reasons thing in the judgment.
Now, where have you mentioned in the plaint about?
Please see para 6, my lord, it is recorded in the impugned judgment itself.
Judgment.
Para 6. About 5th line. She has stated that previously her husband was cultivating.
The form, form,
50, param 50.
Param 50.
Please see. She has stated that previously her husband was cultivating the scheduled land and he was raising crops since it is a dry land depending upon the rains. She has stated that her husband had applied for grant of scheduled land, but no grant order was made in his favor and he died in November 1996, and since then she has been cultivating the scheduled land. The specific government is made.
But Form 50
Milord, this Milord, village rustic lady, she has filed, she says that I am Milord, my husband has applied for grant. Merely because she does not mention Form 50.
Form 50, 1976 alilla. Form 50 came in 1991.
That's what. That's when he must have filed it. But they are saying the order, the application was rejected, but that order copy is not on record.
Judgment ilvalri.
Is also filed before along with the film. In my appeal, page 78, my lord.
The LCR alla destroy agbittidangide.
In my appeal, I have produced the document. Page 78, in page 78.
The appeal that is served to me does not have anything, my lord. This is what is served to me. Notice agila, how will you serve it?
In appeal copy, page 78 with the param confinement. And order subsequently, that order is also produced.
But I don't have those papers.
Page 82.
Lord, I was served only on the IA for substitution. That is IA number 1. And they have not given me any documents except this.
No, the judgment
appeal.
also does not show whether any documents
But
were
it may be
marked.
so. But what I'm saying is, my lord, they had the knowledge of this decree.
No, that is right.
They can,
Judgment.
lord, they have, lord, they can't.
Please wait. Judgmentally, there's not even one document which is marked.
But I will have to look into the other documents, my lord. Today, my lord, I stand before your lordship, whether, my lord, or not, the 23 years of, my lord, delay can be condoned when filing this appeal. When they were very much aware. They are only saying, my lord, that applications were filed, representations were given based on this judgment and decree, and they don't do anything till I file contempt petition.
Yes.
That's all subsequent events have explained in the affidavit, my lord.
Not subsequent event. They have to explain why they could not have filed the appeal.
Yes, what is the
Because no
reason?
notice is served on the appellant, my lord.
Appeal serve ಆಗಿದೆ ಅಂತ ಹೇಳಿದಿರಲ್ಲ.
ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
Appeal all one government is not served. It is served on the office of the Tahsildar. It has not come to the knowledge of the government. Nobody has-
ತಹಸೀಲ್ದಾರ್ ಅಂದ್ರೆ ಏನು? ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಬಂದು ಕೈ ಕೊಟ್ಟು ಸೈನ್ ಮಾಡಿಸ್ಬೇಕಾ?
ಅದು ಪಾರ್ಟಿನೂ ಮಾಡಿದ್ದಾರೆ ಅವ್ರನ್ನ. It is not served. Moreover, it is a fraud.
ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಡೆಪ್ಟಿ ಇವಾಗ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಸರ್ವ್ ಆಗ್ಬೇಕಿತ್ತಾ?
Yes, my lord. That is the government.
Where is it served?
Not served on the chief secretary.
ಇನ್ನೆಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ?
ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ಗೆ ಸೇಮ್ ಡೇ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
ಮೂರು ಜನಕ್ಕೂ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ರಾ?
ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಸರ್ವೆ ಅಲ್ಲ, ಸಾರಿ, ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಸರ್ವೆ ಆಗ್ಲಿಲ್ಲ. ಓನ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಇಸ್ ಸರ್ವ್ಡ್.
What? How do you say that?
ಅದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ.
Lord, that goes contrary to para 5, my lord. They say was served on appellant number 1 to 3.
Password no date. Yes, next. Tilak Raj.
Serial number 17, Tilak Raj SV. Serial number 17.
IP for the contesting respondents, madam. The applications regarding LR.
IA? The learned counsel for the appellant submits that he does not press IA 4 of 25. In view of the above, IA 4 of 25 is rejected. What about IA 6? Notice ಹೋಗಿದೆ IA ಮೇಲೆ. Issue notice on IA 6 of 2025. What is IA 3 of 25? ಸರ್ವ್ ಆಗಿದೆಯಾ? ಸರ್ವ್ ಆಗಿದೆಯೇನ್ರಿ?
2B, 2A, B ಅಂತ
ಆಗಿದೆಯಾ?
ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ರು ಸರ್ವಾಗಿದೆ ಅಂತ.
2A ಅಲ್ರಿ, 6 ಅಂತ ಹೇಳ್ತಿದ್ದೀನಿ. 6. 2A and 2B, sorry. Proposed R to be served, ಬರ್ಕೊಳ್ಳಿ. Notice on IA 6 of 2025 is served on the legal representatives. And notice to them is held sufficient. However, there is no representation for the legal representatives of deceased R2. As the cause of action is survived against the legal heirs of the deceased R2, IA 6 of 2025 is allowed, and the legal representatives of R2 are ordered to be brought on record as R2A and B. Counsel for the appellant is directed to amend the cost. What is IA 3?
We're seeking for DNA test, my lords. It's a suit for partition. It's a plaintiff's appeal. The entire dispute arises out of only one question, my lords, revolves around only one issue. It's a paternity of the appellant.
Sorry, one ನಿಮಿಷ. Regarding DNA test, it's an additional evidence. It has to be considered along with the main, because whether it is required or not, your lordship, you know, the additional evidence only on merits consider ಮಾಡಬೇಕಾಗುತ್ತೆ. This IA has to be deferred.
If this application has to be allowed,
Please.
Merits ಮೇಲೆ ಹೆಂಗ್ allow ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಯಾವುದು?
If this application has to be allowed, at the time of merits ತಗೋಬೇಕಾ ಇದನ್ನ?
ಅಲ್ಲ, whether this one DNA test was done in the trial court, it was not accepted. Now he wants a second DNA test.
Trial court
I'll make this
ಅದನ್ನ only on merits ಅಲ್ಲಿ ತಾವು ನೋಡಿದ ಮೇಲೆ ಬೇಕಿದ್ರೆ ಮಾಡ್ಬೋದು.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ರ DNA ಟೆಸ್ಟ್?
ಅವರ ಕೋರ್ಟ್ ಅಲ್ಲ, ಅವರು ಪ್ರೈವೇಟ್ ಆಗಿ ಮಾಡಿಸಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ, that is not accepted. Now he wants second DNA test. What I am submitting is
second DNA test, first test.
First test. All right. DNA test, he wants whether this is required or not, there is an evidence, additional evidence. I am only submitting that the court has to consider.
What is the law on the point?
It's law on the point.
On
where is the judgment?
Defer ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ.
Let's produce on the 23/4/2025 minutes. We filed a memo along with the citations.
Where is the latest one rendered by Justice?
Your lordships passed an order, my lords, in the POCSO matter. Your lordships observed. Let's in this case scenario, my
There's
lords.
one judgment of the Honorable Supreme Court authored by Justice B.V. Nagaratna. Where is that judgment?
I have a coordinate bench of this honorable court passed an order, my lords.
I'm giving you the names.
Please,
I'm telling you, it was about 2023 ನಲ್ಲಿ ಆಗಿದೆ. Why don't you bring that?
I'll secure it.
Pass over.
Please, my lords.
So one submission, one request, please have it next week. I will also come with that decisions. But what I am submitting is this could be considered on merits.
Correct, but this any decision on this application will have a bearing on the merits.
Please, my lords.
Any decision on this application will have a bearing on the merits. So therefore, we have to get it now, done now, not at the time of final disposal. Final disposal DNA.
Final disposal alla, while considering the merits, this IA has to be looked into because order 41/27 is there. That has to be considered along with.
Please
the
go
merits
through the judgment.
I'll secure it. Kindly pass for minutes. I'll secure the document.
List on yavat ಬೇಕು?
Next week ಅಲ್ಲಿ ಯಾವ date?
Next Thursday.
Thursday the date.
Let's interim order may be extended, my lords.
Interim order is extended till the next.
Sorry, 9.
For 18.
Appellant, the counsel on record is hospitalized, Your Honor. Kindly have it on Monday. Humble submission, Your Honor. Monday or Tuesday.
2 days.
Any date. ma'am.
Karthik,
I'm applying for respond number 4.
objections to IA? You filed?
My lord, this is regarding maintainability, my lord. Last date of application.
ಏನ್
my lord.
maintainability?
Revocation of will, my lord. They have
Revocation of
revocation of will.
PNDC is granted.
I don't have my idea, my lord.
Alternative remedy is there.
You have to go before the, how is an RFA maintainable against this order?
Kindly, Your Honor, kindly have it on Monday or Tuesday.
Allowed petitions held to retain property on which executive and adjourned ready.
Counsel has been hospitalized, that's why, my lords. Kindly. Humble submission.
ಯಾವತ್ತು ಬೇಕು?
Monday or Tuesday, any date, ma'am.
The counsel for the appellant seeks time, list on sounds.
16.
Much obliged.
Till number
K.
19.
Vishwanath.
V. Vishwanath, K. Vishwanath. Janardhan V.
Respondent number 1.
For the appellant in this case. Present applications filed by the appellant under section 151 of CPC.
IA 126.
So recall the
IA
order dated 37/2000.
Of delay of 205 days in filing the appeal. Application to recall the order dated 30th of July 2025.
Under to restore the same.
On submission, my lord. Is a suit up. The cause shown for the delay is produced and the same is accepted. Hence IA 2 of 26 is allowed and the delay of 205 days in filing the application is recalled, is condoned. IA 1 of 26 is filed for recalling the order dated 37/2025 by which the appeal was dismissed for non-prosecution. Full stop. It appears from the order dated 30th of July 2025 that when the appeal was listed for admission, there was no representation for the appellant, though it was called twice in the day. And hence the appeal was dismissed for non-prosecution. Therefore, the cause shown for not appearing on the said day is not justified. Nonetheless, since the suit from, this appeal arises out of a suit for ejectment.
Earlier suit filed by the plaintiff is for ejectment. that suit converted to agreement of sale. There is a sale between the defendant and the plaintiff for a sum of rupees 30 lakh.
For ejectment is already decreed, my lord.
No, my lord.
No matter.
For the judgment portion.
Confusing your lordship.
Plaintiff para, the plaintiff.
Allow him to confuse fully, then you can clarify. Let him confuse fully.
This is the plaintiff. The defendant approached the plaintiff with an intention to buy the scheduled property from the plaintiff, and the sale price for the plot was orally negotiated and fixed at 44 lakh. This is the plain governments of the respondents. Thereafter, as full and final sale price, the defendant paid a totally 13 lakh in installments to the plaintiff as advance towards the sale consideration, the scheduled property. However, the balance sale consideration could not be arranged by the defendant in time, not in time. The sale deed with the plaintiff here with. Thereafter, there is a due negotiations between plaintiff and the defendant. After the short duration, the tenants on the rent for a sum of rupees 18,000 per month, and the defendants paid a advance sale consideration of 1 lakh.
Though the cause shown for not appearing before the court on so and so is not justified, yet in order to give an opportunity to the appellant to contest the appeal on merits, IA 2 of 26 is allowed, 1 of 26 is allowed, and the order dated 37/2025 is recalled subject to payment of cost of rupees. Is to 5,000. 5,000 payable to the Advocate Clerks Association.
And also not to take further steps to
stop. Execution
He is not filed for stay, my lord. He is-
Have you filed any application for stay?
ಸಮಯ ಅವರು ಡೆಲಿವರಿ ವಾರಂಟ್ಗೆ ಇದು ಮಾಡಿದ್ರೆ 4ನೇ ತಾರೀಕಿದೆ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಫೈಲ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡು. ಇದು IA for delay ಇದಾ? ಮತ್ತೆ IA 2 ಇಲ್ಲಮ್ಮ ಅದು. IA 1 of 26 ಅಂತ ಅಲೋ ಮಾಡಿ restored list for orders on IA 2 of 26. Any objection for delay? Condition of delay?
I'll file my objections.
Counsel for the respondent seeks time to file objections to IA 2 of 26. List on, when will you file?
Within 15 days. ಸಮಯ ಅದ್ರ ಜೊತೆಗೆ ಒಂದು
Don't execute the order. If you take 15 days, don't execute the order.
Yes, my lord.
ಏನು ಆಗ್ಬೋದು ಅಂದ್ರೆ?
I have filed for application for breaking open the law. Even if the order is passed, I will not press for it.
ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the respondent undertakes that he will not pursue the execution petition till the next date of hearing. List on
16th April
16th April.
20, EI Sanmati.
Appeal for appellant, much of it. Your Lordship, in this case, the defendant number 5 has filed
Issue
the
notice
present-
on IA 1 of 26
Your
as
Lordship,
well as on the main
submission,
appeal.
there is attachment to movables ಮಾಡಿದ್ದಾರೆ. Your Lordship, can say I'm only a guarantor as per the
Whatever,
tripartite
if you
agreement.
want stay, you have to deposit the entire money because there is delay.
Your Lordship, one submission, my lord. I'm only a guarantor, my lord. There is a tripartite agreement between the borrower, bank and the builder. The bank has not proceeded against any of the parties. There is a clause in the tripartite agreement that they have to proceed against the builder if there is a title dispute, my lord. They have not taken that. As per the Surface Act, my lord, section 14, they have to take possession of the flat. They have not done it.
But still, why did you come after
Your
so
Lordship,
much?
may kindly see, the
After
truth was
nearly
decreed
3
in
years.
2021, my lord. Your Lordship, till 26, they have not taken steps against recovery for against the borrower, not the bank. Only in 25, they filed the execution.
After 4 years, you come.
Your Lordship, in 2025, execution petition is filed. In January, I came to know
Notice on
about.
IA 1 of 2026 as well as in the main appeal.
Your Lordship, subject to some condition, my lord, some these.
Deposit the entire money, I will grant you stay.
Your Lordship, kindly have it on Monday. I will serve the copy to the counsel who has appeared before for the bank in the execution petition.
Open for the appellant to serve the learned counsel who represented the respondents before the
Execution court.
Supreme Court.
Execution.
List on
Monday, my lord.
Monday, Thursday, 9th April.
Your Lordship, till then, because 10th.
No, till then.
They have taken, already paid the process.
5 years you dodge the matter, or you can't dodge
Your
for
Lordship,
another 2 years.
2025 execution petition ಆಗಿ 26 ಅಲ್ಲಿ ನಂಗೆ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
Kalyan Basuraj,
Serial number 21, yes, Kalyan Basuraj.
Thomas Vijay Peter. Yes.
For the appellant, my lords.
Okay, for the response.
Suit for injunction, my lords. Cross of PW, further cross evidence of PW1 was taken as not nil on 24/3/2021, my lords. This is 3 days immediately after the lockdown. The appellant was living, if my lords may kindly see page 29, my lords.
Now, what is the suit for?
In bare injunction.
Suit is for bare injunction.
Bare injunction, my lords.
And you are the?
I am the plaintiff appellant, my lords.
Suit is dismissed.
Suit is dismissed, my lords.
Ah.
If my lords may kindly see page 29, my lords. In page 29. Para 19 in the I'll read, my lords. The PW1 further deposed evidence on 2021 to 2018. The defendant had come to the terrace area and threatened him that he should not use the terrace area and obstructed the usage of terrace area and further threatened him with dire consequences. Hence, he filed suiting the prayer made in the plain. The PW1 placed to decree the suit as prayed in the plain. In support of oral evidence, marked
for opportunity.
Because
Yeah,
24
just
on
now,
24/3/20.
just now I received a copy. My learned friend sent it on the email. I was not able to open it.
I to 24/3/2021, he did not appear for cross-examination.
Yeah, I just saw it.
It was a time during which COVID was still last leg.
Yes.
Second wave of COVID was.
But
I leave it to my.
the appellant has challenged the judgment and decree dated so-and-so, passed by so-and-so in OS number 25242 of 2018, by which his suit for perpetual injunction was dismissed. Next para. The appellant filed OS number 25242 of 2018 for perpetual injunction to restrain the respondent from interfering. Respondent.
Sole defendant, my lords.
Respondent from. What is the relief?
Interfering into the peaceful possession of suit schedule B property, my lords.
Usage of the terrace and then
My lords?
Usage of the terrace.
Usage of terrace, that is the schedule C property.
Interfering with the usage of the schedule C property. Full stop. The suit was it appears that the schedule C property is the terrace over the schedule
A property, my lords.
Schedule A property. The appellant claimed that he has exclusive access to the schedule C property and that the same is in his exclusive possession and enjoyment ever since he purchased the schedule A property. He claimed that the respondent has no right, title or interest over the schedule C property and that he was interfering with his possession. Full stop. He therefore prayed for perpetual injunction to restrain the respondent from interfering with his possession and enjoyment in the schedule C property. The suit was contested by the defendant who denied that the plaintiff was the owner of the schedule C property. He also denied that plaintiff was in exclusive ownership and possession over the schedule C property and contended that the schedule C property was part of the terrace and therefore was commonly owned by all the apartment owners. Full stop. Next para. The trial court framed issues and set down the case for recording the evidence. The appellant was examined as PW1 and the case was thereafter listed on 24th March 2021 for cross-examination of the appellant. However, the appellant was not present and hence his evidence was treated as closed at 24th March.
On the same day, 24th March 2021.
Cross-examination was on the same day on 24th.
So on if my lords may see page.
Cross-examination was closed on 24/3/2021 and the case was posted for defendant's evidence. The defendant also did not lead any oral or documentary evidence and hence, the trial court dismissed the suit in terms of its impugned judgment and decree. Being agreed with the same, the appellant is before this court. The learned counsel for the appellant submits that the Appellant could not appear before the court on 24/3/2021 in view of the COVID-19 pandemic, which was in the last leg. Full
And he was
stop.
residing in
submits-
Kerala at that time.
And he was residing in
Kerala, my lords.
Kerala.
Kerala.
And he was residing in Kerala. Full stop. He therefore submits that the appellant could not be present before the court on 24/3/2021. He however submits that if an opportunity is granted to the appellant, he would present himself for cross-examination. Full stop. The learned counsel for the respondent, however, contended that the plaintiff, that even if the plaintiff's documents are taken into account, there is nothing to show that the plaintiff is the exclusive owner and in enjoyment in possession of the Schedule C property. He contends that the Schedule C property is held by all the apartment owners in common, and therefore the appellant cannot, and that no useful purpose would be served in restoring the appeal. Full stop. I consider submissions made by the learned counsel for the appellant and the learned counsel for the respondent. The only point for consideration in this appeal is whether the appellant deserves to be granted another opportunity to present himself for cross-examination and pursue the suit on merits. Next paragraph. It is not in dispute that the case that the appellant was examined as PW1 and he marked exhibits P1 to P.
Let's
Only one document.
Only
P1.
Exhibit P1 was marked, the sale deed.
Exhibit P1. Full stop. Here, the case was thereafter listed on 24/3/2021 for cross-examination. However, as rightly contended by learned counsel for the appellant, the country was gripped by COVID-19 pandemic, and during March 2021, the lockdown was still in force. Full stop. As the appellant is a resident of Kerala.
At that time he was in Kerala, my lord.
As the appellant claims that he was residing in Kerala at the time, he could not have travelled to Bangalore to attend the courts. Therefore, the reason cited for not presenting for cross-examination is just and proper and deserves to be considered favorably. In that view of the matter, this appeal is allowed. The impugned judgment and decree passed by the trial court is set aside. The suit before the trial court is restored. The party shall appear before the trial court on
anytime in the first week of June, my lord, subject to what my learned friend says.
No, I'm ready.
on first week alla kododilla. On 15th April 2026, the appellant shall without fail present himself for cross-examination. The trial court shall take up the matter as expeditiously as possible and dispose of the suit within a period of 6 months from the date of conclusion of the evidence. Yes.
Obliged.
Serial number 22, Nagaraja S.
Last time also, one night.
There is no representation for the appellant. Even in the last date, there was no representation, though the case was called twice. Hence, the appeal is dismissed for non.
Suit for partition. The property is given by the father to the daughter. One daughter is handicapped. That handicapped daughter is staying with the another daughter along with the father.
Dismissed for non-prosecution.
Much of.
Serial number 23, Shankar Nayan Bhatt.
Put for partition, we are partly decreed, and out of 3 items.
Yes, Nagaraja anta idea vakalatal nodi ಏನಂತ ಇದೆ ನೋಡಿ. ವಕಾಲತಲ್ ನೋಡಿ ಯಾರು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಹೆಸರು ನೋಡಿ. Yes, Shankar Nayan Bhatt.
Yes, appear for the
Suit is for partition.
partition, and it partly declared, out of 3 items, in a second item share was given, and in other 2 items it was refused.
The plaintiff's appeal.
Actually, the property share itself is not correctly partitioned, because the first defendant mother died during the pendency of the suit. In 2022, mother died. That was not, even though it was.
This is a plaintiff's appeal.
Yes, madam.
Emergent notice regarding rule. Till the next date of hearing, the response are restrained from encumbering or transferring or alienating the suit shall properties in any manner whatsoever. List on date.
17th April. Serial number 24. Ejectment court.
Appellant in this case. Suit for partition, my lord. Item numbers two of the suit said property belongs to me, my lord. The connected matter as 92/2025 in RFA. Stay has been granted, Your Honor. Idrili item number 2 of the suit said property, this ancestral property of the appellant, my lord. Idrili at a time of the execution of the will in the year 1944, really, first defendant, his father has executed a will, registered will, my lord. Will execute ಮಾಡ್ಕೊಡ್ಬೇಕಾದ್ರೆ
This is an RFA. You should know how to present your case.
Yes, my lord.
Who are you?
Yes, I'm the appellant in this case. I am the defendant number 16 and 17 in this suit, my lord. I am the defendant number 16 and 17 of the suit said property. Suit. I am the impleading applicant in the suit, my lord. Now impleading ಆಗಿ ಹೋಗ್ತೀವಿ. Item number 2 of the suit said property.
Who are related to the plaintiff?
ಇದರಲ್ಲಿ
How are you related to the plaintiff?
Plaintiff and first defendant is a sisters, my lord.
Plaintiff and
first defendant, first plaintiff and first defendant is a sisters. His father has executed the will in the year 1944, my lord. At a time of executing the will, ಇದರಲ್ಲಿ our father ಗೆ 4 ಜನ ಬ್ರದರ್ಸ್ ಇರ್ತಾರೆ ಸ್ವಾಮಿ. ಡಿಫೆಂಡೆಂಟ್ ಫಾದರ್ ಗೆ 4 ಜನ ಬ್ರದರ್ಸ್ ಇರ್ತಾರೆ. ಅದರಲ್ಲಿ ಚಿಕ್ಕಣ್ಣನವ್ರಿಗೆ 2ನೇ ಬ್ರದರ್ಸ್ ಇರ್ತಾರೆ. ಅವರು ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡು 1920 ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. 100 years ಬ್ಯಾಕ್ 1920 ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. 1940 44 ವಿಲ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡ್ಬೇಕಾದ್ರೆ ನಮ್ಮ ಐಟಮ್ಸ್ ಕೂಡ ಸೇರಿಸಿ ಅದರಲ್ಲಿ ವಿಲ್ ಸೇರಿಸ್ಬಿಟ್ಟಿರ್ತಾರೆ ಸಮಯದಲ್ಲಿ. ಆ ವಿಲ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ಮೇಲೆ 1986 ವರೆಗೂ ಅದು ಯಾರಿಗೂ ಖಾತಾಗಿರಲ್ಲ ಸ್ವಾಮಿ. ಅದು ವಿಲ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡುವಾಗ ಟೈಮಲ್ಲೂ ಕೂಡ ಅವ್ರ ಹೆಸರು ಖಾತಾ ಇರಲ್ಲ.
ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತಪ್ಪ ಅದು?
ಇದರಲ್ಲಿ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಮುಖಾಂತರ ಬಂದಿದೆ ಸ್ವಾಮಿ ನಮ್ಗೆ. 1920
ನೀವು ಯಾರು
1920 ನಲ್ಲಿ ಈ ಫಾದರ್ ಆಫ್ ದಿ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಇಸ್ ಬ್ರದರ್ಸ್ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಸ್ವಾಮಿ 1920 ನಲ್ಲಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಅಪಲೆಂಟ್ ತಾತನಿಗೆ ಇದರಲ್ಲಿ ಒಂದು ಶೇರ್ ಐಟಮ್ ನಂಬರ್ 2 ನಮ್ಗೆ ನಮ್ ಶೇರ್ ಅಲರ್ಟ್ ಆಗಿರ್ತದೆ.
This will is in the year 1944.
ವಿಲ್ ಇರ್ದು ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ 1944. ಅಲ್ಲಿ ವಿಲ್ ಮಾಡ್ಕೊಟ್ಟ ಟೈಮ್ ನಲ್ಲಿ ಫಾದರ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ಗೆ ಅವ್ರು ಯಾವುದೇ ರೀತಿ ರೆಕಾರ್ಡ್ಸ್ ಇರಲ್ಲ ಸಮಯದಲ್ಲಿ.
ಏನು ನೀವೇನು ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಹಾಕಿದ್ರು?
ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ ಏನ್ ಮಾಡಿದ್ರೆ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ 1993 ನಲ್ಲಿ ನಮ್ಗೊಂದು ಫ್ಯಾಮಿಲಿ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ರೆ, ಮತ್ತೆ 1960 ನಮ್ಗೆ ಸೇಲ್ ಡೀಡ್ ಕೂಡ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್. 1996 ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್ ಕೂಡ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. 93 ನಲ್ಲಿ ಕೂಡ ಒಂದು ಫ್ಯಾಮಿಲಿ ಅಗ್ರಿಮೆಂಟ್ ಕೂಡ ಮಾಡ್ಕೊಟ್ಟಿದ್ರೆ, ಇದು ನಿಮ್ ಪೋರ್ಷನ್ ಅನ್ಬಿಟ್ಟು, ಇದು ನಿಮ್ ತಾತನ ಶೇರ್ ಇರ್ತಕ್ಕಂಥ ಪ್ರಾಪರ್ಟಿ, ಇದು ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ ಅನ್ಬಿಟ್ಟು ನಮ್ ಫ್ಯಾಮಿಲಿ.
ಪ್ಲೈಂಟಿಫ್ ಅದ ಪಾರ್ಟಿನ?
ಹೌದು ಸ್ವಾಮಿ.
ಪ್ಲೈಂಟಿಫ್ ಮಾಡಿದ ಸೈನ್ ಮಾಡಿದಾರ?
ಇಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ ಪ್ಲೇಂಟಿಫ್ ಮಾಡಿಲ್ಲ, ಅವ್ರ ಸಿಸ್ಟರ್. ಇದು ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಮೇಲೆ ಇವ್ರು ನಮ್ ಮಾಡ್ಕೊಟ್ಟಿರ್ತಾರೆ, ತಂದೆ ಮಗಳು ಮಾಡ್ಕೊಟ್ಟಿರ್ತಾರೆ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ಗೆ. ಡಿಫೆಂಡೆಂಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿ ನಮ್ಗೆ ವಾಪಸ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಡಿಫೆಂಡೆಂಟ್ ಮಕ್ಕಳನ್ನ ಯಾರು ಮದುವೆ ಆಗಿದ್ರ ನಿಮ್ಮ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ ಇವ್ರ ಬ್ರದರ್ಸ್ ಇವ್ರು. ಇವ್ರ ತಾತನು ಅವ್ರ ತಾತ ಅಣ್ಣ ತಮ್ಮದಿರು ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ನಮ್ಮ ಶೇರು ಕೂಡ ಅದ್ರಲ್ಲಿ ಏನು ವಿಲ್ಲೆಲ್ಲಿ ಹೋಗಿರುತ್ತೆ ಬೇಸ್ಡ್ ಆನ್ ವಿಲ್ ಡಿಕ್ರಿ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ. ದೇರ್ ಇಸ್ ನೋ ಅಲ್ಲಿ 1920 ನಲ್ಲಿ ಯಾವುದೇ ರೀತಿ ಓರಲ್ ಪಾರ್ಟಿಷನ್ಗೆ ನಿಮ್ದು ಯಾವುದೇ ಸಫಿಸಿಯಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು ಡ್ರಾ ದ ಡಿಕ್ರಿ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಏನು ಈಗ 1944 ನಲ್ಲಿ ಏನ್ ನಮ್ಮ ಐಟಮ್ ನಂಬರ್ 2 ಸೇರ್ಕೊಂಡಿದ್ಯೋ ಆ ಐಟಮ್ ನಂಬರ್ 2 ಮೇಲೆನೆ ಇಲ್ಲಿ ಅವರು ಪಾರ್ಟಿಷನ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಬೇಸ್ಡ್ ಆನ್ ದಿ
ವೆಂಕಟಾಚಲಪತಿ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಇಂಪ್ಲೀಡಿಂಗ್.
ಅಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಐಟಮ್ ನಂಬರ್ 3 ಕೂಡ ಅವ್ರು ಸೇರುತ್ತೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ನಮ್ದೇ ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಅವರು ಕೂಡ ಅವ್ರ ಶೇರ್ ಇದೆ.
ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಡ್ರಾಯಿಂಗ್ ಅಪ್ ಫೈನಲ್ ಡಿಕ್ರಿ ಸ್ಟೇಟ್ ಹೌಎವರ್ ಆಲ್ ಫರ್ದರ್.
ಇಲ್ಲ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ, ಅಲ್ಲಿ FDP ನಲ್ಲಿ ಅವರು ನಮ್ಗೇನು ಇದೇನ್ ಕೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಐಟಮ್ ನಂಬರ್ 2 ಏನಂದ್ರೆ ಬಿಡೆಗೆ ಅಕ್ವೈರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಇದೆ, ಆ ಅಮೌಂಟ್ ಕ್ಲೈಮ್ ಮಾಡಕ್ ಹೋಗ್ತಾ ಇದಾರೆ. ಅದ್ರಲ್ಲಿ ನಾವು ಪೊಸಿಷನ್ ಇದೀವಿ ಅಂದ್ಬಿಟ್ಟು ಬಿಡಿ ಅಂದ್ರೆ ನಮ್ ಜಾಗ ಬಿಟ್ಟಿದ್ರೆ ವಿ ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಮೇಲೆ. ಅದ್ರಲ್ಲಿ ನಾವು ಪೊಸಿಷನ್ ಇದ್ರೂ ಕೂಡ ಅವ್ರ ಅಮೌಂಟ್ ಡ್ರಾ ಮಾಡಕ್ ಹೋಗ್ತಾ ಇದ್ದಾರೆ 50% ಶೇರ್ ಮೇಲೆ. ಸೊ ದಟ್ ಸ್ಟೇ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್
ಟಿಲ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ದಿ ಬಿಡಿಎ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಸೂಟಲ್ಲಿ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ ಅವರು.
ಟಿಲ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಡಿಕ್ರಿನ ಸ್ಟೇ ಕೇಳ್ತಿದ್ರಲ್ರಿ ಮಿಸ್ಟರ್?
ಅಲ್ಲ ನಮ್ಮ ಐಟಮ್ ನಂಬರ್ 2 ಸ್ವಾಮಿ. ನಮ್ಮ ಐಟಮ್ ನಂಬರ್ 2 ಮಾತ್ರ ಕೇಳ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
The respondents are restrained from withdrawing compensation determined by the Bangalore Development Authority in respect of land bearing survey number
item number 2 at fiber 2.
Item number 2 of the 5/2 of Ganikallu village, Kengeri Hobli, Bengaluru South Taluk, measuring 13 guntas. Yes.
Serial number 25, 17th April. Serial number 25, Syed Akmal Hassan.
It is made clear that this court has not granted stay of the impugned judgment and decree, and therefore the response are at liberty to proceed with the final decree. Yes.
Serial number 25.
Syed Akmal Hassan Rasli. Brijesh Patil.
My lords, after hearing the matter for some time, I had suggested the parties to
Ah.
settle on 27/11/2025.
Parties are working out a settlement.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿ 27/11 my lords.
I have 3 apartments for my share, my lord. I have offered him 1 apartment in full and final settlement.
After hearing the discourse, yeah.
3 apartments and share ಬಂದಿದೆ. 1 apartment ಕೊಟ್ಬಿಡ್ತೇನೆ ಅಂದ್ರೆ ಒಪ್ಕೊತಾ ಇಲ್ಲ. I can't do more fair than
I
that.
don't know what are the facts.
I'll tell the facts.
The suit for ejectment filed by me has been decreed. In that, my lords, he is not a party. He sought to implead himself. That order was allowed. That application was allowed. I challenged it before this.
So who is the defendant in that suit?
My lords, tenants, my lords, my tenants under agreement. I filed a suit for ejectment that has been decreed. During the pendency of the suit, my lords, he sought to implead himself in that suit saying that I am the owner. That order of allowing his impleadment, I challenged it before this honorable court. This honorable court set aside that order, saying that since plaintiff has not sought to make you a party, you cannot be made a party. That has attained finally. That order was passed in 2018. They don't choose to challenge it, my lords. Now they have challenged the decree passed in 2025.
They had filed an application for impleading in this suit.
In the suit, yes, my lords.
That is rejected.
That was allowed. I challenged it before this honorable court. This honorable court set aside that order. And that has attained finality. That order was passed in 2018.
Yes.
Now, my lords, trial has got completed. There's a decree in my favor. Now we have challenged that decree.
Yes.
Lord, I am the owner of that property. I entered into a joint development agreement with a company called Holiak Realty, which is not a party before this court. 3 apartments fell to my share. 3 apartments fell to the Holiak's share. They say that I have not paid the money, and therefore they did some internal arrangement, and they say that we have given this property to these people, Spaceline. And Spaceline says that we have given it on rent to somebody. When I went and I found that he is there, I got the rent agreement in my favor. She became my tenant, and in the cross-examination, they have clearly admitted that I am the owner of the property. They have no documents to show. Trial court records have come. If Your Honor may kindly look at the cross-examination. Clear admission that I am the owner. Please look at, they have no title. I am the owner, it is accepted. They give my property on rent.
No, but who is this defendant, Hidyatullah?
They are my tenants.
They say they are their tenants. They have all entered into agreement with me. They've been paying me the rents because I am the owner. I went and said, I am the owner. These are the documents. Look at their own owners.
How did you become the owner?
I am the developer.
He is not the developer, my lords. I'm sorry, he is not the developer.
My predecessor, my lords, Oliak Limited.
Oliak Limited is not a party.
That's Oliak Limited, my lords. The Spaceline, Oliak Limited owned some dues, certain dues to Spaceline. Spaceline handed over these properties in favor of Spaceline.
How can they hand over?
Oliak, my lords. My sister concerned, so it was handed over. I mean, all that has come in the order. You know, we cannot dispute that, my lords. He is not a party to the suit also. My lords, I give these 3 flats on rent. They continue as my tenants for more than 1.5 years. Rents have been paid. Once they stop paying me the rent, I file a suit for ejectment. In that he seeks to.
Did you induct these people as tenant? This Hidyatullah as a tenant?
No, I did not induct, my lords.
So who inducted him?
They say that they have inducted. I went and I saw him at the trust.
You did not induct this man into possession.
Yes.
I did not induct him into possession, but he transferred it.
You wanted to short circuit their lease agreement.
No, they are no lease agreement. Who are they? They have to first establish
That
themselves.
is first, file a suit for declaration,
But
recovery of possession.
they have themselves in the cross-examination admitted that I am the owner and they have no document, they have nothing. Who
Yes.
are they to give it?
So what does defendant say?
They
It's not
accept and will-
contested. He is not
Defendant has
No,
contested.
they have
but-
said the same thing. They have said that they came and showed me the document, I am paying the rents to them.
What do the defendant say?
Please look at the cross-examination.
That's
He has
reasons.
got some notice, a reply issued. What does he say? False. Taking a false and fraudulent stand, the defendant has become a tenant under Huda Abdul Alim, who
Yes.
claimed to be the owner of the supermarket.
They
Defendant
themselves have
has
admitted that she has become my tenant.
How did he come into possession? How did he come into possession? He might become your tenant.
He has become
How
a
did he
was a
come into possession?
trespasser. They had the
How
party.
did he come into possession? Did you induct him?
No, I did not induct.
How did he come?
He came into possession as a trespasser because Holy Act Realty has not given it to them.
If he's
I
a
can-
trespasser,
So I go and tell him you are a trespasser, I am the owner. Therefore he says, okay, I am becoming your tenant from now on.
Yes. You raise this contention in execution petition. Let the decree be executed for court.
But that's,
You raise this contention in execution, let the court decide in section 46
that liberty may be.
for court. IA, this IA is all considered or not? IA 2,
ಇಲ್ಲ, consider ಆಗಿಲ್ಲ.
IA 2 of 25. There
we
are two
have-
appeals, is it?
Three
He
appeals.
appeals.
Three appeals.
Three appeals.
IA 2 of 25, ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಬರ್ಕೊಳ್ಳಿ, is filed by the appellant seeking permission to file this appeal against the judgment and decree dated so and so, passed by so and so, invoice number so and so. Next para. The appellant contends that with orders on IA 2 of, the appellant contends that he is the owner of the property bearing site number 191/3, PID number 61-59-191/3, Lalbagh, Siddhapur, Jayanagar, first block, Mavalli, BBMP, ward number 61, Bangalore. Full stop. He had entered into an agreement with Holiak, HOLIAC, Realty Private Limited, for developing the aforesaid property, in terms of which, he was entitled to 3 apartments, while Holiak Realty Private Limited was entitled to 3 apartments. Full stop. Appellant claims that apartment bearing numbers D12, D21, and D22 fell to his share. Full stop. He contends that the respondent number 1, who has no right, title, or interest in the aforesaid 3 apartments, fraudulently entered into a lease agreement with the respondent number 2 and rented out apartment bearing number D21, D12 and D22. ಮೂರಲ್ಲೂ ನೋಡ್ಕೊಳ್ಳಿ ಯಾವುದು. Full stop. He contends that when he went to the apartment in question, he saw respondent number 2 occupying the apartment. And then informed him that he was the owner of the property and questioned his authority to be in possession. The respondent number 2 informed the appellant that he was a trespasser in the property. Full stop. He also informed the appellant that Spaceline Project Private Limited, the respondent number 1 herein, was the owner of the property and had entered into a lease agreement with the respondent number 2 with him. Full stop. The appellant allegedly warned the respondent number 2 of criminal action, and thereafter it was mutually agreed between him and the respondent number 2 that he would enter into a lease agreement with the appellant and continue as a tenant in the sued property. The appellant claimed that the respondent number 1, in the meanwhile, the respondent number 1 had filed a suit for ejectment of the respondent number 2. An application was filed by the appellant to be impleaded in the said suit, which was initially allowed, but was set aside by this court on the ground that the appellant cannot compel the respondent number 1 to add him as a party in the suit. Full stop. He contends that the appellant, the respondent number 1 was the landlord who had leased out the property to the respondent number 2. The appellant contends that the respondent number 1 claimed that he was the landlord and had leased out the property to the respondent number 2. Full stop. He contended that the respondent number 1 claimed that the respondent number 2 did not pay the rent, and therefore he terminated the tenancy on 9/10/2017 with effect from 25/10/2017. Full stop. He contends that despite overwhelming evidence to show that the appellant was not the owner of the property in question, the trial court decreed the suit. The appellant claims that yes, he contends that he was contends that Poliac Realty had assigned the 3 flats of the appellant to the respondent number 1.
It is their contention, my lord. It's their contention.
Come to para 29.
Which
para 29 of your application.
Respondent number 1 would be the respondent number 1 here.
Where? He contends that appellant respondent number 1 had admitted that the respondent number 1 that the appellant was bound to pay some money to Poliac Realty.
That's what they claimed. Yes. That's what they claimed. Yes, sir.
And since Poliac Realty, the appellant did not pay the money back to Poliac Realty, the 3 flats belonging to the appellant was made over to the respondent number 1.
On my lord, sir.
Full stop.
I filed a synopsis, my lord.
He therefore contends that the appellant is entitled to come on record and challenge the impugned judgment and decree. Next para. A perusal of this application is opposed by the respondent number 1. Who has filed a detailed statement of objections inter alia contending
I filed a compilation of documents. How the respondent number 1 came into
the objections?
Objections, Akila. Compilation of document. My lord had directed me to file a compilation.
The learned counsel for the respondent number 1 submits that even as per the case of the appellant, it is the respondent number 1 who had leased out the property to the respondent number 2, and therefore there is no privity of contract between the appellant and the respondent number 2. He contends, therefore, the respondent number 1 was justified in filing a suit for ejectment of the respondent number 2 from this property in question. He submits that any agreement between the appellant and the respondent number 2 is to defeat the claim of the respondent number 1 is unconscionable and cannot be looked into. He therefore submits that the appellant is bound to is not entitled to question the judgment and decree passed by the trial court. Next, I consider submissions of the learned counsel for the appellant and the learned counsel for the respondent number 1. Next para. As rightly contended by learned counsel for the appellant, respondent number 1, the appellant has admitted in the application seeking permission to file an appeal that the property in question was leased by the respondent number 1 to the respondent number 2. Full stop. It is not the case of the appellant that the respondent number 2 was inducted into the premises by him, and therefore he was the landlord and respondent number 2 was a tenant under him. Full stop. If the respondent number 1 has leased out the property to the respondent number 2, the respondent number 2 is entitled, the respondent 1 is entitled to seek ejectment of the respondent number 2 from the premises in question. If the appellant has any better right for the property in question, he is only entitled to, he is entitled to question, he is entitled to seek adjudication of his right in proceedings before the executing court, and not by filing the impugned application, not by filing the present application seeking leave to challenge the impugned judgment and decree. In that way of the matter, these applications are rejected. However, liberty is reserved to the appellant to work out his remedy in execution petition. If an application is filed, the executing court, having regard to the contours of section 46 of the Code of Civil Procedure, shall examine the case of the appellant in accordance with law.
My lords may also say, my lord, the trial court has given a finding that I am the one who had leased out the property.
Any observations made in this order shall not affect the executing court in deciding the case, deciding any application that may be filed by the appellant on merits.
There is a finding by the trial court saying that I am the one who had leased out the property in favor of
He
respondent.
established that.
Other than the observation.
ಆಯ್ತು 46 ಅಲ್ಲಿ even that can be gone into ಅಲ್ವಾ? Yes. Delhi Cuckoo.
Serial number 26, Delhi Cuckoo.
Issue notice on IA 125 as well as in the main appeal. Take out notice.
I'll take.
Yes.
My lord, there is only FDP is bill filed by the respondent.
The FDP go on. Delay ಇದೆಯಲ್ಲ, delay the stay.
ಅದು district court ಹೋಗಿ ತಗೊಂಬರೋ because of jurisdiction we had.
ಏನ್ ಮಾಡೋದು?
I'll take notice, my lord.
Take out notice.
27.
It is open for the appellant to serve the learned counsel who represented the respondents before the trial court. Mr. Sundaram.
Yes, Lord. Lordship, there are
Appearing
three
for
memos
the-
we filed. I served a copy, has received it, but office has not put up.
My lord, meanwhile, my lord, I don't have anything to say about what my learned friend says. My lord, October 24, my lord, was the last allowance that was paid to me, even according to them. We are 1.5 years down the line. Last time also, my lord, I made a submission. I asked, then your lordship also mentioned, my lord, to my learned friend, to come here with the check or DD. 4 hearings agide Swami, adad
False
ನಂತರ
submission.
ಇವತ್ತವರೆಗೂ, and he calls it a false submission. This is.
Really, if you are ready to argue, please argue.
Memo
Both
is
of you are
there.
ready to argue.
Lordship has directed me to file a memo. The memo of calculation I filed in the office. It is not put up.
I'll get it.
Yes. 1912, my lord.
Thursday, then a
There
memo
is an
of
order
cal-
also there. Then
We'll
subsequently
get
there is
it in
a.
a jiffy, Mr.
My lord.
Get it in a jiffy. In a second, we'll get it. In 1 second, we'll get it.
Yes, there are
Allah, I have a
other
copy.
three
I can
memos
give.
also, my lord.
I too.
All the memo, all the
The
memos.
whole thing, my learned friend, my lord,
That is the
hesitates
matter
to
on
make the
merits.
payment.
ಆಯ್ತು admission argument ಮಾಡ್ರಿ.
No, we will address the argument. I have not, this thing, only
yes,
thing,
Mr.
I have
Thomas.
served a copy, has received it also. We'll argue it on this, no problem.
Yes, what is the suit for?
My lord, I questioned, my lord, the order of suspension initially. From my lord, they removed me as the secretary of the YMCA. Thereafter, my lord, during the pendency of the suit,
ಏನು YMCA associate general secretary.
yes,
Associate.
This is a post for life, is it?
not a post for life.
ಅಲ್ಲಲ್ಲ ಕೇಳಿದ್ದು.
ಇಲ್ಲ, it's not a post
What
for
is the
life.
organization?
My lord, it is the young men's
Organizational chart in.
organization chart, my lord, is not produced here.
It's not put in.
I can produce it, my lord.
ಆಯ್ತು.
My lord, during the pendency, my lord, I shall produce it. During the pendency of the suit, my lord, the respondents, my lord, issue a termination notice, removing me from services. Then I amended the plaint. And I, my lord, questioned the order of termination also. And the trial court, my lord, after substantial evidence and documentary evidence also produced before it, my lord, decreased the suit partially. My lord, your lordship may kindly see the
Yes.
order. I shall read, my lord.
You are also terminated from service.
Yes, ma'am. During the pendency of the suit. Your lordship may kindly see page
Yeah? ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ 11ನೇ ತಾರೀಕು ಅಂತೇನು 11th ಏನೋ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ನನಗೆ ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಇದು 11th ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Second June.
Sir.
ಯಾವತ್ತು ಹಾಕಿದೆ?
Sir, my lord, sir, 19/12/2025 filed the object, ನಮ್ಮ
25, my lord, they are talking of 26.
ಇದು ಬಂದು ಸರ್
ಇದೆಯಲ್ಲ
ಇದು ಒಂದು ಇದು ಒಂದು
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇದೆಯಲ್ಲ
ಇದೆ ಇದೆ
ಇಲ್ಲಿದೆ ಇಲ್ಲಿ
ನನ್ನದ ಮೆಮೊ
1912 ಏನೋ ಹಾಕಿರೋದು ಇದೆ ಇಲ್ಲಿ ಮೆಮೊ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
This is
ಇಲ್ಲ they have what till that they have, my lord, till October 24 ಕೊಟ್ಟಿದ್ದ. I have no dispute about that.
Now let us see what is the judgment that is.
My lord, page 86, your lordship.
Please read. Yes, I have that. Please go on.
Yes, my lord. Suit of the plaintiff is decreed partly. Plaintiff is directed to approach the Board of Directors of YMCA Bangalore for fresh consideration regarding his suspension and termination. In the result, the order of termination of the plaintiff dated 31/10/24 is kept in abeyance till disposal of the said matter by the full quorum of the Board of Directors in accordance with law. The payment of subsistence allowance by the defendant association to the plaintiff shall be continued till fresh disposal of the matter by the full quorum of the board. None the prayer at D and E dismissed as premature. Accordingly, relief of mandatory injunctions granted with modification in prayer of the defendant, their officers, agents, other
Yes.
so and so. My lord, the second prayer, the second, my lord, order that's produced was not my prayer before the learned trial court. This is, my lord, that something was, my lord, was imported into the order. Because my question, my lord, the trial court should have either dismissed my suit.
No, we have to consider that.
Yes.
Now, what about this payment of subsistence allowance? When was the last subsistence allowance paid? As per the judgment, when was the last subsistence allowance paid? When was it terminated?
31/10/24.
31/10?
24.
My lord, I'll give a synopsis in this.
Sir, we are trying to break it down.
No,
What's the date?
for assistance of the court.
31/10/24.
You please
Date.
assist the way I want.
Yes, ma'am.
Suspension date, you know,
31, the suspension date.
the date of suspension. Five, 4/2023.
25/4/23, my lord.
25/4/23.
Yes.
Yes.
Till 30/10/24, he was terminated. The substance allowance was paid to you.
Till termination, you have paid.
Yeah, I paid.
What about from termination till today?
Yes, my lord. What happened? The suspension was upheld by Supreme Court. What we suspended, that is the trial court order, high court order set aside. Now the termination left over. The termination, there was a rider, you should approach the board for with a full quorum. As on this date, he did not comply to approaching the board.
Yes.
That is a complaint. So what happened, my lord, if the appellant continued to be lifelong,
Correct, but he has also to sustain.
Right, but it till
Let us, please tell us, within how many days he should approach? He'll approach, but till then you have to pay the.
No, but once the termination is taken place, the board has terminated him. And he is not entitled for a substance allowances.
Correct, but this judgment you are not challenged.
My lord, I am ready to, if he comes to the board, if the termination set aside, he will be reinstated. And he has not come to before the board till that. See, as for the impugned order, he should have approached the board. He has not come. See, till the board is terminated, we have paid this thing.
Have you approached the board?
I haven't, my lord, because my question before my lord is, I need not approach the board because that was not my prayer at all in the suit.
Either you take the judgment in full.
Yes.
You can't say, only give me the benefit of subsistence allowance. Termination will argue it later. No, you can't say
It
that.
is not, Your Lordship, my Lord, said, my Lord, that this is a matter to be heard on merits. My submission to my Lords is, I did not make a prayer before the trial court to say, my Lord, I questioned only the termination order. The suit was partly decreed. The trial court, my Lord, said, you pay him the subsistence allowance till the disposal of the suit. Meanwhile, my Lord, they terminate me. And my Lord, they now are refusing to pay the subsistence allowance. My question, my Lord, is,
Matter has to be heard then.
yeah, it has to be heard. My Lord, I'm ready, my Lord, your Lordship will kindly post it on
They
8.
got the LCR on the pretext they will file a paper book and all these things. That is why I filed it. They also filed one.
My
more
Lord,
thing.
somehow or the other, my learned friend doesn't want me to pay me a dime.
No. Appellant is also.
So he
filed
is,
a
my Lord,
fresh
legally
suit.
bound to pay.
Appellant
you
is also
take the
filed a
judge-
fresh suit.
See, either you take the judgment in full. See,
Yes.
you are entitled to subsistence allowance
Yes,
because the court below has granted you an opportunity to appear before the board.
yes.
Till the board takes a decision, court has directed the respondent to pay the subsistence allowance.
No, it's not, it doesn't say so, my Lord.
No, dear.
Lordship, kindly
Please
see
read.
86, man.
Over the-
Yes, my Lord,
If that is so,
Yes.
either you take the judgment in full. You can't pick up what is convenient for you.
no, then in which case, my Lord, I'll address my
No, no,
arguments on merits.
Admit. List on Yavatwik.
My Lord,
8ನೇ ತಾರೀಕು ಹಾಕು.
regarding the admission, I have, because I filed that the appeal itself is not maintainable. I filed interlocutory appeal, IA number 5.
For what?
Lordship is, the appeal itself is not maintainable.
Why?
I'll point out.
ಹೇಳಿ ಏನಕ್ಕೆ ಅಂತ.
What has happened, along with the appeal, he has filed for amendment, he has filed for, he has claimed a full salary, and he is claimed, then he also said that he should be reinstated.
You said
And,
appeal is
there
not
are-
maintainable.
Yes, ma'am.
You said appeal is not maintainable.
Yes, ma'am.
Please tell us why the appeal is not maintainable.
Because since he has not complied the trial court order,
He says that I did not ask for this relief. Court is given me some relief which I had never asked.
yes, ma'am.
That is the question that he has raised.
No, my lord, he has made a submission about 5 months when he first time it come. The LCR was called for, he said he will file the paper book and the LCR was called. Till that,
Yes,
the
yes,
paper books is not.
admit, call for records. Records ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ಬಂದಿದೆ.
ಬಂದಿದೆ.
The paper books, he said he will file,
ಬಂದಿದೆ
it's
ಅಂದ್ರೆ?
not been filed.
Records ಇದೆಯಾ? Admit, call for records, paper books to be filed within? Paper books ಬೇಕಾ?
ಇಲ್ಲ, ಬೇಕಾಗಿಲ್ಲ. So that's a
Filing
very
of paper
small
books is
question
dispensed
involved.
for the time being.
Paper book is big because the
List
Supreme
on
Court-
date ಕೊಡಿ. Yes.
Supreme Court judgment and all it is.
ಅವೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ ಸರ್, ಸುಮ್ನೆ ಪೇಪರ್ ಬುಕ್ಸ್ ಎಲ್ಲ ಯಾಕೆ? If you want to inflict him with more
That's exactly his
injury.
intention.
He has also filed a fresh suit before the trial court, pendency of this
Is
appeal.
Rahul Reddy. PV Malla Reddy.
Number 28, Rahul S. Reddy.
June, sir, June.
For the appellants in this matter,
June.
appellants are the
Somewhere in
plaintiffs.
the June, my lord.
Declaration suit,
Please, my lords, declaration
ಏನಾಗಿದೆ?
suit.
Suit ಏನಾಗಿದೆ?
Suit came to be dismissed, my lords.
Suit is dismissed.
Please, my lords, suit is dismissed. Appellants are the plaintiffs.
Reddy ಅವರು.
Yes, please.
Admit.
It is not a fit case for admission for the
Yeah.
reason that it is res judicata, it is in violation of this res judicata place. Since 1954, there were several suits in which the person under whom this person is claiming, he has admitted in the judicial proceedings that he doesn't have any rights over these properties.
ಎಲ್ಲಿದೆ?
In spite, ಅದು ಇದು judgment ಅಲ್ಲೇ ಇದೆ.
My lords.
Para number 23 to 30.
Let him say.
Please,
Para number 23 to 30, they are relevant, please, my lord. He has referred to all the suits, please, my lord. Para number 23 to 30. First suit is of 1948, please, my lord. 288 of 1948.
ಓದಿದೆಯಾ? Para 23 to 30.
Para 23, please, my lord. Internal page number 77 of the judgment, please, my lord.
ಓದು.
As discussed about, Patel Munusamaya is illegitimate son-in-law, but he cannot be considered as a member of the joint family of his sister, his father-in-law. Joint Hindu family consists of all persons lineally descended from a common ancestor and includes their wife and unmarried daughter. A daughter ceases to be members of her father's family on marriage and becomes a member of her husband's family. Hence, son-in-law cannot be treated as member of family of his father-in-law. one contention, first contention is that, see, this Patel Munshamappa, being the son-in-law, is a joint family member. Therefore, whatever the properties which are standing in the name of this Patel Munshamappa are joint family members.
Sir, you said something, you are
Yes,
now
yeah,
arguing something.
I'll
You said there's some suit res judicata.
I'll please.
Now you are
Next,
arguing on
24,
facts.
24. Now the question for consideration is the properties which is subject matter of the suit are joint family properties or not. The plaintiffs have pleaded that survey number 68 is purchased by Patel Munsamaya as per exhibit P5, sale date dated so and so so and so. The reference to this suit is eighty-six, page number 86, please, Mila. Internal page number 86. Is purchased by Patel Munsamaya as per sale deed dated 23/9/1929. It is held in OS 288 of 1949-50 that fifth defendant of that suit, Patel Munsamaya, is not a co-partner of the family and the property standing in his name are the properties of fifth defendant only. Fifth defendant is Patel Munsamaya, please, Milad. And it is held in that suit that these properties are the self-absolute properties of Patel Munsamaya. Then, please, Milad. So in 28, the learned counsel appearing for the plaintiffs has argued that the findings given in OS number 288 of 1949-50 is in respect of contention of Channappa, son of Nanjappa, that the properties are joint family properties, but it is not held that these properties are not the properties purchased by utilizing the joint family funds of Muniappa and his sons. It is important to note here only that defendant number 1 to 3 of OS number 288 of 1949-50, none other than the sons of Muniappa.
Please come to page 86, last sentence.
86, please, Mila. That is, I am reading that only, please, Mila.
It is held in OS number 288, the fifth defendant of that suit.
None other than the sons of Muniappa, that is Muniswami, Nadupanna and Buddappa, through whom plaintiffs defend number 1 to 8 and 34.
86, Banni sir, page number 86, internal page 86.
86 only I am reading.
The first sentence, Odi. It is
The
held-
learned counsel appearing for the Munisamaya as per sale deed. That is the one, please, Mila. So that is a.
Yambataru.
It starts from Munisamaya. It starts from as per sale deed dated 23/9/1929. It is held in OS 288 of 1949-50 that fifth defendant of that suit, that is Patel Munisamaya, is not a co-partner of the family and the property standing in his name are the properties of fifth defendant only. This is the first finding given in that suit, please, Milad, that these properties are belonging to the Patel Munsamaya, that is it is their his absolute property, please, Milad. Next, please, Milad, may I read the next two paragraphs, please, Milad. The learned counsel, the 87, please, claiming that it is a joint family property. In OS number 288 of 1949, though Patel Munisamaya claimed that these properties which are standing in his name are his separate properties, Muniswami, Nadupanna and Buddappa have not claimed that it is the properties purchased in the name of Patel Munisamaya by utilizing the properties belonging to them. Muniswami, Nadupanna and Buddappa have clearly stated that in the year 1908, only there was a partition between Muniappa, Usappa and Nanjappa, and as such, the properties are not the joint family properties. If properties are purchased by utilizing the property allotted to their share, then they would have denied the contention of Patel Munisamaya. So here,
if there is an earlier decree, in OS number 288.
Well, some of the properties in those suits are repeated in this property also, but apart from that also, Maharaj, there are different scheduled properties in this.
Correct. ಈ ಸೂಟಲ್ಲಿರುವಂತ ಪ್ರಾಪರ್ಟೀಸ್ ದೇ ಆರ್ part of OS number 288.
Please, my lords.
In that suit, there are two properties which are declared to be the property of Munsamaya. In ಮಿಕ್ಕಿದ್ದೆಲ್ಲನೂ it is not your property.
Please,
You are not a member of the joint family ಅಂತ ಮುಂಚೆನೆ ಆಗಿದೆ. How can you now file another suit?
Now this.
Your wife, Munsamaya's wife and children.
Please.
Or sons of children, sons of Munsamappa. How can they file now a suit?
We are the grandchildren of Muniappa. Our
Munsamayan.
Illa Muniappa. Munsamaya's.
Muniappa is the propositor
of the family.
Muniappa has brought this Patel Munsamaya
into his family.
Now Munsamaya's sons and daughters, they have agitated before the courts below.
Yes.
My claim is, my lords, the illegitimate son-in-law who was brought into the house, whether the scheduled properties were brought out of his own money, or in fact, we had mortgaged the property to one Narayanappa.
Can you file a suit for partition?
Partition illa.
Declaration.
Declaration to declare that the scheduled properties are the joint family properties of Muniappa and his sons.
How?
And
There's
possession.
already a declaration that it is not the property of the joint family.
This 288 of 1949, I'll have to verify whether these properties only are this. Adralli
Court
ಎರಡು property ಮಾತ್ರ.
ಹೇಳ್ತಾರಲ್ಲ, the same properties are involved ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಇಲ್ಲ, ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ. In fact, we have produced an exhibit stating we had mortgaged the scheduled properties to one Narayanappa. Narayanappaಗೆ mortgage ಮಾಡಿದ್ಮೇಲೆ, out of our joint family income, what the said Munswamappa will do.
Office is directed to secure the records of the trial court.
Please.
List on date.
Notices also have not been issued.
Further in 1980
Will
also.
issue consider first. No,
Please.
Make out a point for it.
In fact, after the mortgage, my lords, what the said Munswamaya will do, he will not get release the property. After the death of Narayanappa, he will get executed a sale deed from his son.
Sri Hari Deshpande.
Please.
Serial number 29. Sri Hari R. Deshpande.
Suit is for possession.
It is initially filed suit for possession by one Devraj against his two unmarried sisters D1 and D2. So during the pendency of the suit, first the plaintiff died. So LRs came on record. And later they filed there was a counter claim by the D1 and D2, they also died. And it became a suit between the two wives of the plaintiff's widow and children.
Issue notice.
ಅಲ್ಲ ಅಲ್ಲೊಂದು ನನಗೆ ರೈಟ್ ಎಲ್ಲ ಪ್ರೂವ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ, ಒಂದು ಐಎ ಇದೆ, ನಾಟ್ ಟು ಎನ್ಕಂಬರ್ ಅಂತ ಒಂದು ಐಎ ಕೇಳಿ, ನಾಟ್ ಟು ಎನ್ಕಂಬರ್ ಅಂಡ್ ನಾಟ್ ಟು
First you take out notice.
ಅಲ್ಲಿ ನೋಟಿಸ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
2025 appeal ಇದು. Issue notice on IA.
ಅಲ್ಲ ಇಶ್ಯೂಸ್ ಬೇರೆ,
25 as well.
ಪ್ರಯರ್ ಟು ಜಡ್ಜ್ಮೆಂಟ್ ಇಶ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಇದನ್ನ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿರೋದು, ಅದಕ್ಕೆ ರೀಕಾಸ್ಟೆಡ್.
30.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್
ಅಲ್ಲ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಐ ಮೇ ಪರ್ಮಿಟೆಡ್ ಟು ಸರ್ವ್ ಆನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Appellant to serve the non-counsel represented the respondents before the trial court.
A date may be fixed.
Serve marko move ಮಾಡಪ್ಪ. I'll take it up. Next. V. Vishwanath Shetty.
I pay for the appellant. The defendant's appeal, my lords, please.
Yes.
That the plaintiff respondent files the suit for the relief of declaration to declare that he is absolute owner of the suit scheduled property bearing site number 119, which is situated at Balaji Krupal layout, Sampigehalli, my lords. My lord, the claim of the respondent plaintiff is that, my lord, he has purchased the suit scheduled property in pursuance of a registered sale deed dated 9/11/2021 from Srimati Kalavati. And that he says that he is the absolute owner and came in possession of this same. My lord, he has challenged my sale deed, my lords, please, which is executed by the
plaintiff care sale ಮಾಡಿದ್ದು.
Some plaintiff sale ಮಾಡಿದ್ದು one Rachaya's wife Srimati Kalavati. Namage, how we got the property, my lord. This property was originally acquired by Rachaya, that is Kalavati's husband's family. Plaintiffs gave vendor. He acquired the property on 6/12/2003 in pursuance of a registered sale.
6/12/2003,
my lords. I am not disputing. My lord, after purchase of this property, Rachaya was intending to put up construction there. He has approached the State Bank of Mysore, Gandhinagar. He has obtained a loan amount, my lord. So he were to repay the loan amount, and also he was not interested to continue with the property. He has entered into an agreement of sale with me on, my lords, please, 24/1/2007, my lords, please. It's
after selling.
To sell in favor of.
No, first it was sold to the plaintiff.
No, ನನಗೆ ಮೊದಲೇ ಮಾರಿ ನಂತರ ಅವರು ವೈಫ್ ಮಾರಿರೋದು ಈಗ.
2003 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ, 2003 purchased by Rachaya, husband of
Rachaya. When did he sell it to the plaintiff?
To the plaintiff after death of Rachaya. His wife Srimati Kalavati has executed the registered sale deed on 9/11/2021, my lords.
9/11/21.
21. During the lifetime of Rachaya, he obtained the loan from the State Bank of Mysore. He could not be able to repay, and he wanted to sell the property. On 24/1/2007, my lords, please, he agreed to sell the property in favor of the defendant number two, my lords, please, for a valuable consideration of rupees 7,20,000.
Yes.
My lord, he has executed the agreement of sale, received a sum of rupees 4 lakhs from him, and also a general power of attorney on the same day. So also an affidavit for delivery of position in favor of me, and also authorization letter for discharge of the loan to the State Bank of Mysore and to get back the documents to me. Thereafterwards, I came in position. My lord, thereafterwards, my lords, please, this defendant number 2 being the lawful attorney, my lords, please. He has executed the sale deed in favor of the appellant number 1, my lords, please, on 30th/1/2012, my lords, please. 30th/1/2012. My lord, thereafterwards, what happened, my lords? Brother of this Rachaya,
Issue notice.
meantime, regarding alienation, there was an order of status quo. Now,
Till the next date of hearing, the respondent, the appellant and the respondent are directed to maintain status quo in respect of the suit shall property. Neither the appellant nor the respondent shall put up any construction for the suit property, and they shall not encumber, alienate or transfer or part with possession of the suit shall property in favor of any third party. List on date.
16th April.
R.A. Devanand.
Number 31, R.A. Devanand.
R.A. Devanand.
Lord, regarding the merits of the appeal, it has come on record that I don't press the appeal. See, there, in fact, they opened the case for the respondent alleging that 6 lakh rupees is the arrears of rent as due by me on the date of passing of the judgment and decree. Whereas the trial court holds that I am entitled to quit and deliver vacant possession of the property and hand over it within 3 months. 1 lakh, the second leg of the order is 1,10,000 and odd is the arrears of rent which I have deposited it. And apart from that, they have filed a memo of calculation which is so unclear, alleging that I am in arrears of rent of rupees 6,80,000, for which I gave a good understanding through the clarity of my memo, spilling the beans from which month of tenancy to which month of year I defaulted in the matter of rent wholesale.
Anyway, we are not concerned with that. Decree bagay, ejectment decree bagay.
Yes. I am, if you grant me 3 months' time, I'll quit and go.
Let the executing court decide what is the.
Very well.
Very well, my lords. But 3 months is little unreasonable, my lords. I've gotten the degree, my lords. Already 3 months they've taken.
3 months.
One month.
3 months yavat khali martire.
2 months I am in arrears of rent which I am prepared to.
Kodi 3 months yavat
We are in the 1st of April. April,
3 months would be.
May, June. July end.
1st July, you please vacate.
July end.
At what rate? The rent he's going to pay is at what, my lords?
July end it be. May it be July end?
What is the rate of rent now paid?
40,000 is the rate of rent.
No, my lords.
42.
Lord, there is no, absolutely, there is no lease deed.
Yes, what is the rate of rent that you, how much were you paying earlier?
40,000, not 42.
Well, lords, in the year 2019.
40.
Year 2019, he was paying 40,000.
Yes.
As on today, we are paying 40,000.
Where is this house?
It's a residential unit.
Residential unit situated at 8th block Jayanagar, my lords.
Jayanagar.
8th block, my lords.
What is the area?
Area is about 1,680 square feet, my lords. The apartment.
680, 3 BHK.
Yes, my lords.
2-bedroom house, perhaps.
3 BHK, my lords.
3-bedroom house.
40,000 kadme aitalla.
Kammi aitu, my lords. At 2019, I was paying 40,000. He was paying 40,000. It's
The
his hike in, come out.
Why don't you allow me to submit, sir? Why don't you allow me to submit?
He's got some problem.
Please, my lords.
He has got some problem.
Sir, the rent from the month of November 2017, that is the year of the month of commencement of tenancy.
Sir, we are not, you need 3 months' time.
3
How
months
much rent
time.
will you pay?
Please, my lord.
How much rent will you pay?
40,000.
40,000 is not sufficient for a 3 BHK in Jayanagar. If you're willing to pay 60, we'll give you 3 months. Or maybe even 4 months.
I might be listed on Monday.
Please ask him, he's here.
No, he needs the assistance of his daughter. He agrees for 45,000.
50, make it 50 and close it.
55 minutes.
No.
Well, let's,
Parkul. The appellant has challenged the judgment and decree dated so and so, passed by so and so, and OS number so and so, which is a suit for, by which the suit for ejectment was decreed, and the appellant was directed to quit and deliver vacant possession of the suit property. He is also directed to pay a sum of rupees 1,10,402, being the arrears of rent from April 2021 till 30th August 2021. It also directed that he is liable to pay mean profits from 1/10/2021 till eviction, full stop, along with interest at the rate of 9% per annum. Next para. The respondent, being the owner of the suit property, filed OS number 5398 of 2021 to eject the appellant from the suit share property. The appellant, full stop, the appellant did not contest the claim of the respondent that he was the owner of the suit property. However, he denied that he was nest away technologies. How did you become the owner?
Malaj, I was always the owner, Malaj.
No,
Nest away. Yes, Nest away technology was the management company that lent permitted the appellant herein.
The licensee in the year 1971 was one by name Synopsis. He licensed them to collect the rent and induct me into the possession of the property. And that licensee was there up till 2019.
No.
Thereafter, there is a change in the licensee. Again, once again, it gives away to Nest Away.
A new agreement came to because
there is no agreement of lease as on that day from B.
Malaj, the clarity here that is to be provided is in 2019.
Those two licensees who held the license to collect rent from me has been terminated. They have been terminated.
In 2021, first the licensee, sub-licensee was terminated, Malaj. Then his tenancy was terminated. After the lapse of the agreement, I might say.
The plaintiff, the respondent, the respondent filed OS number 5398 of 2021, contending that he was the owner of the suit property. Full stop. He had executed a special power of attorney dated 14/7/2017 in favor of City Synapse Information Private Limited, authorizing it to find identified tenants, collection of the license/lease amount from such tenants and to remit the same to them. In the year 2017, Messrs. City Synapse Information Private Limited identified the defendant who agreed to take on flat number 202, that is the suit shell property, on rent. Full stop. Later, in the year 2019, Messrs. Nestaway Technologies Private Limited acquired City Synapse Information Private Limited and entered into a service agreement with the respondents on 8/12/2019, wherein it undertook to find tenants for the scheduled property, collect rents from the tenants and remit it to the plaintiffs. Full stop. The respondents claimed that they authorized Nestaway Technologies Private Limited to enter into leave and license agreement on their behalf with respect to the suit shell property. They contend that the defendant continued to pay the rent to Nestaway Technologies Private Limited after entering into a fresh leave and license agreement dated 12/9/2019 with the plaintiffs, with the respondents. Full stop. they alleged that the defendant has agreed to pay enhanced rent at the rate of 5% after lapse of every 5% on the last paid rent on the after lapse of 11 months from the effective date of the agreement. Full stop. He claims that claimed that the defendant fell in arrears of rent from April 2021 till September 2021. Full stop. When they raised objections against the appellant continuing in the premises, he filed OS number 1406 of 2021 for perpetual injunction. Thereafter, the plaintiffs lodged a complaint before the Jayanagara police on 6/2/2021, which resulted in NCR 22 of 2021. And the police had summoned the appellant, where he undertook to vacate the premises. However, the defendant neither paid the rent nor vacated the premises. Full stop. He also failed to renew the agreement, which expired on 12/8/2020. Full stop. The plaintiffs therefore terminated the license of the defendant and accordingly issued a notice of termination on 26/8/2021, which was served on 27/8/2021. Nonetheless, the defendant failed to vacate and deliver vacant possession of the suit property. Hence, the respondents were advised to file a suit for ejectment and consequently they filed the instant suit. The suit was contested by the defendant, who admitted that he was a tenant in the property, in the suit property. He also admitted that he entered into a rent agreement with City Synapse Information Limited and thereafter entered into a renewal of the rent agreement with Nestaway Technologies Private Limited on 2/10/2020. So he also admitted that he had paid rent. He had occupied the suit property as a tenant on 8/12/2019, but claimed that he had paid a security deposit of rupees 2 lakhs to City Synapse Information Private Limited, which was transferred to Nestaway Technologies Private Limited. Full stop. He alleged that the plaintiff sent a message through WhatsApp on 29/12/2020 directing him not to pay the rent to Nestaway Technologies Private Limited. Full stop. Therefore, a dispute arose between the plaintiff and the defendant, and he was advised to seek for injunctive reliefs in OS number 1406 of 51. Full stop. He also admitted that the respondents had approached the Jayanagara police station, and at the police station, the appellant as well as the respondents were advised to pay rent of rupees 40,000 per month, and accordingly the defendant is paying the rent. He claimed that he is not in arrears of rent. Full stop. Based on these contentions, the trial court framed the following issues. Copy moved. In support of the case of the plaintiff, plaintiff number one was examined as PW1 and he marked exhibits P1 to P10. The appellant was examined as DW1 and he marked exhibit D1. Based on the oral and documentary evidence, the trial court held that the respondents had proved that they were the owners of the suit property and that they had rented out the suit property to the defendant. It also held that the appellant is bound to pay the arrears of rent at the rate of rupees 40,000 per month, and also factored escalation from 12/9/2019 and at the rate of 5% after every 11 months, and held that the appellant is bound to pay monthly rent of rupees 42,000. Full stop. Consequently, decreed the suit and directed the defendant to quit and deliver vacant possession, and also directed the defendant to pay a sum of rupees 1,10,402, being the arrears of rent from April 21 to September 21. Being agreed with the said judgment and decree, the defendant is in appeal. Next paragraph. The learned counsel for the appellant defendant submitted that the appellant has already deposited a sum of rupees 1,10,402 before this court as directed. He contends that he was a tenant inducted in the premises by Nestaway, and therefore the respondents are not entitled in law to evict the appellant. Full stop. For contra, the learned counsel for the respondent submitted that Nestaway was not the owner of the property but was authorized by the respondents to identify tenants to be inducted in the suit property. He contends that the appellant has also entered into an agreement with Nestaway as a representative of the respondents, and therefore the appellant has tacitly admitted that it is the respondents who are the owners of the property, and that he was inducted into the property by the respondents through their agency, namely Nestaway. Full stop. I consider submissions made by the learned counsel for the plaintiff as well as the learned counsel for the appellant as well as the learned counsel for the respondents. Next document. Next para. A perusal of the written statement filed by the defendant/appellant shows that he admitted that he was a tenant in the suit property. He also admitted that he had entered into a lease agreement with Nestaway, which purportedly was the licensee of the respondents. Full stop. Taxpayer receipt, office copy, notice, printout, acknowledgement, police, certified copies also. In that way of the matter, the appellant cannot challenge the authority of the respondent number 2 and cannot dispute that the respondents are the owners of the suit property, and that he was not and cannot contend that he was not inducted into the suit property by the representative of the respondents. The appellant has not denied the receipt of the notice of termination of the tenancy, and hence, the trial court was justified in decreeing the suit. Full stop. As regards the arrears of rent, since it is stated by the appellant that he has already deposited some of rupees 1,10,402, the second portion of the judgment and decree passed by the trial court is satisfied. Insofar as the other portion, namely the arrears of rent, namely the mean profits from 1/10/2021 till the date of eviction, the appellant is bound to the response are bound to work out the remedy before the trial court. Having regard to the fact that the property in question is a residential premises, it is appropriate to grant sufficient time for the appellant to quit and deliver vacant possession of the suit property, subject to the appellant paying the present day market rate of rent, which this court assesses at sum of rupees 50,000 per month. In that way of the matter, this appeal is dismissed. The appellant is granted 3 months' time to quit and deliver vacant possession of the suit property, subject to the appellant paying monthly rent of rupees 50,000 to the respondents every month without any default. It is made clear that in case the appellant fails to pay the rent for any month, the respondent shall be entitled to execute the judgment and decree. Yes.
Serial number 32.
Whether the only point that arises for consideration in this appeal is whether the impugned judgment and decree passed by the trial court warrants interference. Yes, next. 3 months,
With regard to the third leg of the order of the trial court regarding the mean profit is concerned, the trial court holds that I am entitled to pay the mean profit for being in unlawful occupation from the date 1/10/2021 till the date of the decree of the order. I am not entitled to pay the mean profits in the sense it should be correctly spelled out. Why? Because before the executing court, if the execution proceedings is taken up, so that the court should know the mean profit in the sense, the hiked rent or the revised rent as he
So
stipulates.
there's no question of high rent because you're an unauthorized occupant.
Very well, very well. Mean profit should be.
Once you're an unauthorized occupant, what the judgment rendered by the trial court is just and proper. 5% hike.
Let that be spelled out clearly in the order so that the executing court should
That
not be
would-
diverted from it.
The contention of the learned counsel for the appellant that the trial court could not have factored 5% escalation on the last paid rent to determine the mean profits. Full stop. Mean profits, comma, mean, sentence does not merit acceptance as the property is situated in an upscale locality called Jayanagar, where there's a huge demand for housing. And therefore, comma, the escalation at 5% per annum determined by the trial court is just and proper and does not warrant any interference. Yes.
Serial number
Yes.
32,
Srikanth MV.
Srikanth NV.
Defendant appeal. Suit is for my lord's injunction. My counterclaim has been dismissed, my lord's, not maintainable.
Yeah, suit property, you know.
Suit property, my lord's, the site, my lord's, bearing number. The decree, my lord's, is page number 57, my lord.
Both of you are claiming on title.
Yes, my lords.
Both of you are claiming based
Yes,
on
my lord.
title.
The suit filed by the plaintiff was decreed, and I have had a counterclaim, my lords, in the suit filed by the plaintiff. That has been dismissed.
Are you claiming under the same owner?
Please, my lords. Since, my lord, my contention was, my lords, in the written statement that the scheduled property which is claiming by the plaintiff is granted by my lords in the year 1982 by the Tahsildar to the, my lords, the father of the defendant number 1, and my lords, the children of my lords, defendant number 2 to 5. And there is some dispute, my lords, and there are several cases, my lords, for pending before the civil courts, my lords, and some cases were dismissed. And the suit filed by the, my lords, by the respondent plaintiff was decreed, injuncting, my lords, the restraining the defendant from interfering with the scheduled property. And, my lords, the altogether, my lords.
Take out notice. They could issue emergent notice.
Please.
It is open for the appellant to serve the learned counsel who represented the respondents before the trial court.
Please.
Janardhan G.
33, Janardhan G.
Abhishek Marla.
But I am not sought for any interim order as such.
Huh?
But a suit is not sought for any interim order as such. But a suit is for permanent injunction and also a mandatory injunction. He made an attempt to encroach and put up one shed in the one item of the property. There are two items. The appellants, they have purchased the property on 29/8/2006 under two registered sale deed from the.
Call for it. Call for records.
Please.
Date may be fixed. My lord.
Serial number 34.
2026 date may be fixed and then I
I'm sorry, my lord. I'm sorry.
Number 34, KK Vasant.
KK Vasant. Prithvi Vadiyar.
May I seek for a pastoral or
My lord,
pastoral or
ಇದರಲ್ಲಿ
Admission ತಾನೆ ಹೇಳಿ ಅವರು.
ಅದು ರಿಜೆಕ್ಷನ್ ಆಫ್ ದ ಪ್ಲೇಂಟ್ ಆಗುತ್ತೆ.
Rejection of a plaintiff.
The
ಏನಾಗಿದೆ?
suit for partition.
Suit application is allowed.
Application allowed, filed by the defendants.
ಆಯ್ತು ಪಾಸ್.
Serial number 35,
MD Raghunath. Yeah.
My lord, this is a defendant's appeal against the partition suit filed by the respondents, my lord, plaintiff, wherein the respondent themselves have admitted to the execution of a document, but deny the contents of the document, my lords. That is at para number 19.
Admitted the execution of the document,
but deny the contents of the document, my lords.
What is the document?
To declare that they give up their rights over the share or the portions in their respective shares, my lord, over the property.
What is the nature of the document?
It was by way of an affidavit, my lords.
Affidavit.
Affidavit. In fact, at ink page number 29, para number 19, my
But
lords.
how can they do it by just a document?
My lords, what has happened? They have received the amount, which was around 12,50,000 rupees. They agreed to it.
issue emergent notice,
My lord, the only problem is
drawing up
they'll
a final
file-
decree is stayed.
Please,
However, all proceedings up to final decree shall continue.
please, my lord.
Yes. Ramesh,
Achha.
Recovery.
defendants appeal.
Yes, my lords.
Suit is
Suit
for?
is for recovery, my lords, 10,50,000. My lords, this nothing but, my lords, nothing but, my lords, the real estate, my lords, where the plaintiff was an advocate by profession. And he had, my lords, made the plaintiff, the defendant to purchase a site, which was in dispute. My lords, when he raised a, my lords, bought out the
Payments are made through check.
Mallards, that is for refund of the amount paid by me for purchasing the site, Mallards, 240, Mallards, which was in dispute. Mallards, the learned trial judge holds that that site was sold for, Mallards, that sale consideration was received by the plaintiff. Mallards, since I have not sued for recovery of that amount, hence the suit is decreed, Mallards, on the sole ground.
Deposit 50% ಅಷ್ಟೇ. Deposit 50%.
I have never received this amount.
ಏನ್
Mallards.
ಮಾಡಕ್ಕಾಗುತ್ತೆ? We can't decide the merits of the case. Therefore, issue emergent notice. The operation and execution of the impugned judgment and decree is stayed subject to the appellant depositing 50% of the suit, 50% of the decretal amount within, before the trial court within
Mallards, within, Mallards,
4
3
weeks.
4 weeks.
Within 4 weeks.
Much of.
Serial number 37, MD Raghunath.
Mallards, execution has been
Bhagwan.
initiated. Mallards, I will deposit in the execution proceedings, Mallards.
Right, before the executing court. In EP number,
Mallards, EP number 392 of 26, Mallards.
it is made clear that the executing court shall not release the amount without obtaining orders of the court,
Much of.
without this court passing any order.
57,
My lords, may kindly pass over.
What is the suit for?
Injunction, my lords.
What is the suit property?
Unfortunately, I've not read the papers, my lord. Senior said he'll come and argue before my lords.
Residential site.
Lord, this is a road.
Lords, may kindly pass over. Senior is held up in a different court, my lords.
Must issue notice.
Lord, I'm on
Notice
caveat,
ಆಗಿದ್ಯಾ?
caveat, my lord. I'm on caveat, my lord.
Then,
Caveat for respondent number 1, my lord.
yes,
My lords, may kindly pass over.
correct. Yeah, pass off for what?
I understand, my lords. The only problem is senior is held up in a different court hall, my lords.
Dismissed.
It's dismissed, my lords.
My lord, they're claiming the suit as the road as the suit property, and during the course of examination, he admitted that he's not in the possession.
Suit property is a road.
Road, my lord.
No, but it's suit property is a vacant site ಅಂತಿದೆಯಲ್ಲ.
No, that is their claim. Trial court has found it, my lord. We have produced the sale deeds and map of the adjacent sites.
Please have a look at the suit property. It's a site measuring 30 by 40.
That's true, my lord. It is
30
his
by
claim.
60.
It is his claim, my lord. Trial court found that it is a road. That is our case, my lord. And during the course of examination, he admitted he is not in the possession.
Yes, Raghunath
My lords, may kindly pass over, my lords.
is here. We called him.
Apologies, sir.
Not suit for bare injunction is dismissed. The court holds that I should seek declaration. Not I took up a contention before the court below that BBMP has assigned a new number to my property as 4A, new number 1.
No, but you are claiming title to this property.
Please, Bill.
Suit is based on title.
Not, I've sought for injunction on the premise that I am the owner, I am in possession of the property. Defendant tried to interfere with my possession. Lord, apart from the documents which I have produced to show my title, like Kata, tax paid receipt.
If it's a road, let status quo be maintained.
Road, my lord. I have no
Workhold. Issue emergent notice to respondent number 2 until the
My lord, one submission, ma'am.
next date of hearing, comma, the parties are directed to maintain status quo of the suit property. It is made clear that neither the appellant nor the respondent number 1, respondents shall change the nature of the suit property and shall not encumber, transfer, alienate or part with possession of the suit shall property. They shall also not put up anything, any obstruction, put up You shall not put up any fence or any fence over the scheduled property till the next date of hearings. List on date code.
17th April, serial number 38, MD Raghunath.
I appear for the appellants, my lord. My lord, the plaintiff's suit has been dismissed by the Honorable Trial Court. A suit for mandatory injunction, my lords, wherein the appellants are the owners of the suit scheduled properties, which was devolved upon executions of two documents, my lord. One, a will
What is the relief for mandatory injunction?
to provide the possession back to the appellants, my lord. In fact, it was given on a compassionate grounds to the brother. The respondent is the brother, my lords. The appellants become the owner of the suit scheduled properties by way of two documents, my lord. One is a will and the other is a registered gift deed, my lords. The respondents in the cross-examination admits to the ownership of those two properties by way of an admission, my lords, stating that the parents are the original owners of the property, and also admits that it is a self-acquired property, my lords. Unfortunately, takes up a defense that the property is a joint family property. Hence, he cannot leave the possession at the Helta.
Call for records.
Please, my lords. A date may be fixed, my lords.
Huh?
A date may be fixed, my lords.
For what?
For the next.
For dismissal.
Dismissal.
No, why you people are so?
Serial number 44, I need short accommodation.
Serial number?
44. I informed the appeal.
Mr. V.B. Shivkumar.
I informed.
The learned counsel for the, you are Arvind Patil.
Yes.
Learned counsel for the respondent seeks time. List on zones.
Your Lordship, serial number 46, afternoon, I have a difficulty, Your Lordship. Any date, this Saturday or the next week, any date. I'm ready to-
Difficulty in the,
Your Lordship,
what do you mean by difficulty?
Your Lordship, there is a direction matter which
Who
I
has,
have to,
who has to pay the cost?
I have deposited. I have deposited, Your Lordship. I have deposited, I will place it with a memo before this court.
Problem in.
Difficulty I'm facing is that, Your Lordship, before Devnali court, there is a direction matter. It's an old matter coming from 2010. And there's a direction matter. I have to address my arguments in that matter. And that matter is set aside. I have requested that court for a date. They have not given me. It's a very old matter. Hence, for that difficulty. I am also ready. Any day, Your Lordship, any day.
Next Thursday.
Please.
Learned counsel for the respondent number 1 seeks time. This is however opposed by the learned counsel for the appellant. Nonetheless, since the respondent number 1 pleads difficulty, list on 9th. 9th.
Please, Your Lordship.
Could Your Lordship have it at 2:30?
ಹಂಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Much obliged, Your Lordship.
Serial number 3 disposal. Serial number 3 orders.
The document, additional documents,
Dispose of. ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಬೋದಲ್ಲ? ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಬೋದಲ್ಲ?
ಡಿಲೇ ಇದ್ರೆ
ಆಯ್ತು, ವಿಷಯ ಹೇಳಿದ್ದೆ. ನಾನು ಇರ್ಲಿಲ್ಲ, ಅದು ಸೈಡ್ ಹೇಳಿದ್ದೆ.
13 ಬಂದಿದ್ರಲ್ಲ ಸರ್, ಬಂದಿದ್ರಲ್ಲ ಅವರು ಅದು ಅಪ್ಲಿಕೇಶನ್ 13 modification ರಿಜೆಕ್ಟ್, liberty reserved, move before regular court 5th June. ಎಲ್ಲಿ ಸರ್? ಇಲ್ಲೇ ಕರಿ ಸಾಹೇಬ್ರೇನು ತುಂಬಾ ಏನೋ ಮಾತಾಡಿ. ಯಾವತ್ತಿದೆ? ಇವತ್ತಾ? ನಿಮ್ದು ಅದು? ಸಾರಿ, ಇಲ್ಲೇ ಇರ್ಲಿ ಸರ್, ಬಂದ ಆಮೇಲೆ ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡು. ಇದೆ ಸರ್. ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಕೇಳ್ಬೇಕು ಸಾಹೇಬ್ರಿಗೆ. 44 ಕೊಟ್ಟ ನಾನು. Passed over matter serial number 5. S.J. Sangvi. S.J. Sangvi.
Mr. Sangvi. ಮಾಡಿದಾರಾ? The learned counsel for the appellant has amended the cost title as per the order dated 12/3/2025, 26. Office director to check and verify. Process R2 and R3 in Beka. Did they contest the proceedings before the trial court? They're not adduced. Huh? But ejectment suit only the judges passed 100-page judgment. 100 pages. Page judgment ejectment suit. Yes, Mr. Sangvi. ಇಲ್ಲಿ ಬಂದಿಲ್ವಲ್ಲ ಪಾಸ್ ಓವರ್.
Serial number 8. Serial number 8, Sachin BS.
ಏನಾಗಿದೆ? So what happened to the application later? ಕೊಡಿಲ್ಲ. Yeah, 2925 ಅಂತ ಏನದು? 28/8/25.
Subsequently, at the last breath of the proceedings of the suit, before 1 month, they have filed one more application, that is IA number 22. In the IA number 22, the learned trial court asked whether shall I grant the interim order against you also. I openly said to the trial court 1 month before 1 month when matter scheduled from judgment, they have filed the application. Then I said, okay, file, let them allow the application.
So let the same order be continued.
One submission. The entire text of the matter is one submission. Running page number 19 of the
Pavan Chandra, can we decide the appeal in the order stage? 2026 matter. But then we have to consider that.
Your Lordship, kindly tell us one observation of the
2026 suit na merits ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡು ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಏನು ಹೇಳಿ? All right, yes. Cool.
The Lordship, kindly, I am permitted to convince this. Running page number 19, my lord, paragraph number 20. The entire text of the matter is general for property not executed by the plaintiff. That is the entire suit. So Lordship, may kindly deduce, my lord, as per the paragraph 20, my lord. As per the plaintiff, she has revoked the general for property. Please, my lord. This is one sentence is enough. She has revoked the general for property, which has been given in favor of the defendant number 5. In this regard, exhibit T2, the copy of the legal notice issued by the defendant number 5 by the plaintiff is produced, which is dated 19/2/2019. This exhibit T, where the note has. You are aware that many client along with others executed a general for property dated January 14 in respect of the A schedule property and GPA dated February 2009 in respect of the B schedule property. This is enough, my lord. Then, my lord.
This is enough, Andre. You might know the facts, Mister. I don't know the facts.
Yes,
This is enough, Andre. What do you mean by that?
That is, my lord, with respect to they are cancelled the general for property. You know, one month they are saying, my lord, we are.
Sir, what is this?
My lord.
You want me to decide this appeal?
No. Only for my lord, are not to consider the interim order because I am
Don't alienate, that is all. Don't alienate the property.
My lord, number sufficient.
Don't alienate,
I'm
Mr.
staying in Mumbai.
Do you want to alienate?
My lord, may I make my submission?
Barkul.
I'm staying in Mumbai. I want, my lord, I have invested my hard-earned money in the year 2017.
Who has stopped you from enjoying if you are there in possession? Don't alienate is what I am. Do you have intentions to sell?
My lord, that is, I have invested, my lord, the property.
Barkul.
That is what, my lord, is interim order is there, my lord. Whole
The
another 10 years I may
trial
accept
court,
it, my lord.
the trial court has decreed the suit in part,
My lord, one submission, please.
except fifth item of the plaintiff scheduled properties. Full stop. The fifth item of the plaintiff scheduled properties is purportedly purchased by the defendant number 10 A and B. A, B, C, by the
By the all the,
British-
by the all of them,
by
rest of the defendant and plaintiff.
10 A, B and C.
10 A, 2 D, who have purchased from the plaintiff as well as the defendant.
10 A to
All
D,
of the family members.
full stop. Since the appeal is admitted,
Not admitted.
admit agilva,
No. It has not considered.
since the question whether the appellants or appellant is entitled to a share in the suit item number 5 is to be decided in this appeal, the defendant number 10A, B, C and D are restrained from alienating, encumbering or transferring the suitable property in any manner whatsoever until disposal of this appeal.
Not any date.
List on,
Another 10 years, I don't expect in this office.
so there are 40-50 years litigation which is still pending.
I am now age about 56 years.
What, Mr. There, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ರಿ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಹೇಳಿ? ಅವನು
Very small matter.
yes next ಕಾಲ್ ಫಾರ್ ಇಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀನಿ.
SCM call ಮಾಡಿ, sorry.
Call for records, yes. July there will be change in roster, you have to go and mention before that judge. Technicalities either way. Yes, next.
Serial number 16, government advocate.
Put plugs on that.
ಏನ್ flags?
Notice is not served on the chief secretary.
Huh?
Notice is not served on the chief secretary.
Notice not served.
Yes, ma'am.
ಕೊಡಿ ಇಲ್ಲಿ ಏನದು LCR ಕೊಡಿ.
ಅಲ್ಲಿ LCR ಅಲ್ಲಿ ಪ್ಲಾಗ್ ಹಾಕಿದೀವಿ.
ಯಾರಿಗೆ ಸರ್ವ್ ಆಗಿದೆ?
ತಹಸೀಲ್ದಾರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್. ಫಸ್ಟ್ ನೋಟಿಸ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಅದು.
ಇದೇನು ಫಸ್ಟ್ ಫ್ಲಾಗ್ ಏನು ಹಾಕಿದ್ರ? ನನ್ನ ಎಕರೆಗೆ 2 ನನಗೆ ಹಕ್ಕು ಮಾಡಿ ಕೊಡುವಷ್ಟರಲ್ಲಿ ರೆಕಾರ್ಡ್ ನಿಂತು ನನಗೆ ಹಕ್ಕು ಕೊಟ್ಟು ಜಮೀನಿನ ನಂಬರ್ ಫಸ್ಟ್ ಇದೇನಿದು? ಫಸ್ಟ್ ಇದು ಬಂದು
ಚೀಫ್
ಚೀಫ್
ಸೆಕ್ರೆಟರಿ.
ಸೆಕ್ರೆಟರಿ. ಯಾರಿಗೆ ಸರ್ವ್ ಆಗಿದೆ ಇದು?
ಯಾರು ಸರ್ವೆ ಆಗ್ಲಿಲ್ಲ, ಸರ್ವೆ ಮಾಡ್ಲಿಲ್ಲ, ಹಂಗೆ ಹಾಕಿದ್ರು. ಮಿಕ್ಕಿದ್ದೆರಡು ತಹಸೀಲ್ದಾರ್ಗೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಫೀಸಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ರು ಅವ್ರ ಮೇಲೆ?
ಅಲ್ಲ, ನೋಟಿಸ್ ಇಸ್ ನಾಟ್ ಸರ್ವ್ಡ್
ದಟ್ ಇಸ್ ಓಕೆ. ತಹಸೀಲ್ದಾರ್ ಮತ್ತೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ, ಆನ್ ದಿ ಸೇಮ್ ಡೇ ಆಫ್ ದಿ ಹಿಯರಿಂಗ್ ಅದು ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಅದು ಅಲ್ಲಿ ಆಫೀಸಲ್ಲೂ ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ. ಕನ್ಸರ್ನ್ ಕ್ಲರ್ಕ್ ಅಂತ ಏನೋ ಬರೆದಿದ್ದಾರೆ ಅಲ್ಲಿ.
No, find out if this deputy commissioner is still in service or not. 98.
ಅಲ್ಲ, ಆನ್ ದಿ ಡೇ ಆಫ್ ಹಿಯರಿಂಗ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಅವತ್ತೇ ಬಂದು ಆಫೀಸಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಷ್ಟು ಬೇಗ ಎಲ್ಲಿ ಸರ್ವ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ? ಅದು ಕಮ್ಯುನಿಕೇಶನ್ ಆಗೋದಕ್ಕೆ
ಅದು ಹೆಂಗೆ ಹೇಳಕ್ ಅಷ್ಟು ಬೇಗ ಅಂತ?
ಅಲ್ಲ, ಕಮ್ಯುನಿಕೇಶನ್ ಆಗೋಕ್ಕಿಲ್ಲ. ಅವತ್ತೇ ಹಿಯರಿಂಗ್ ಡೇಟ್ ದಿವಸನೇ
98. When was it served?
Moreover, Ran kindly, it is a fraud played on the court.
22 once.
Grant application for grant is rejected. Admittedly, they have filed application for grant Where is the hostile possession, my lord?
Whenever you placed ex parte?
ಅವತ್ತೇ ಸೇಮ್ ಡೇನೆ 22
No, no.
When was the government placed?
It appears to be on January 2000, my lord.
Alla, 20th January 1998 is the date of service. 27/5 to 1998, they are placed ex parte.
21. My 22 avattana dependents 1, 2, 3 are placed ex parte.
22/198, next day, on the same day.
Same day ne ex parte.
Lord, my problem today is, Lord, after 23 years, Lord, I have only this paper, Lord. Even if your lordship
Please,
sees
why
the
don't you
end
go-
of,
No, why don't you go through this order sheet? 22/1/1998 is the date fixed. On that day, they is placed ex parte, then there's a decree.
no, the decree is dated 24 to 2000.
Correct, but they are placed ex parte in 22/198 itself.
Lord, then they have to take, Lord, the steps, Lord, at least, my lord, the Tahsildar and Deputy Commissioner are served, my lord.
The government is not served.
Lord, they represent the government only.
No, you are getting a declaration against the government, not against the Deputy Commissioner.
No, I know, my lord, but they are the revenue
Government
authority.
has to be served.
Lord, after 23 years, this kind of thing, Lord, they have not even said that, my lord, and they have mentioned that, Lord, there were other proceedings through which they could have come to know of the decree, my lord. Lord, then your lordship may issue notice on the IA, my lord, I will file objection.
What notice on IA?
The notice on the condonation of delay application is not
ಎಲ್ಲರಿಗೂ
issued.
ಹೋಗಿಲ್ವಾ?
ಇಲ್ಲ, it was only on the LR application.
Main appeal ಗೆ objection ಹಾಕಿದ್ದಾರೆ. They have filed objection to main appeal.
ಸರಸ್ವತಮ್ಮ,
Yes.
1A 1B ಇಬ್ಬರದಾನ ಇರೋದು. There are only 2 LRs.
Correct.
ಬೇರೆ
But
ಯಾರಿದ್ದಾರೆ?
only the notice on the LR application was issued, my lord. But I saw the,
ಬರ್ಕೊಳ್ರಿ, any objection, allow ಆಗಿದೆ application.
that application is allowed.
ಬರ್ಕೊಳ್ರಿ, learned additional advocate general is directed to furnish copy of the appeal memorandum to the learned counsel for the respondents 1A and 1B.
Along with annexures. Along with the entire.
Along with all annexures. Yes, list on. ಯಾವತ್ತು? Take whatever date you want.
Lord, meanwhile, I may be permitted to inspect.
Please do it. The learned counsel for the respondent is permitted to inspect the trial court record in the presence of the registrar.
Yes.
In the presence of the registrar judicial. Yes.
Serial number 34. 16th April. 16th.
Serial number?
34.
16th I have.
34, huh?
21st.
Mr. KK Vasant.
Lord, 16th I have.
Friday. Thursday, Friday.
Thursday, Friday.
Alla, 16th I am not in.
ಯಾವ ತರ ತಗೊಳ್ಳಿ, any Thursday, Friday you can take.
24.
Yes. Mr. Vasant.
It is the plaintiff appeal. The defendants 2 to 4 have filed an application orders 7 Rule 11 A and D, which came to be allowed and the plaintiff came to be rejected, holding that the plaintiff ought to have challenged the 1967 partition deed, though there is no challenge over.
I don't know what is the suit for.
Suit for partition filed on the ground that in the year 1949, CITB had acquired certain portion of the property in survey number 57 and 60 of Yelahanka. And there actually only CITB, then CITB. And actually they passed the award for 20 acres and so and so. 2 acre 8 guntas left in that. Another survey number 30,000 extent of land was left. And it was under the process. When the original proprietor died, his 3 sons entered into partition in the year 1967 without including this property because it's under the process. And in the year 2015, the defendants, they made inter-se partition among themselves. So far, this property is concerned. For that, we question that the partition of this property, there are 2 items of the property is left out. In the year 2015, we never challenged the 1967 partition at all. We don't want to challenge it also. That is not a subject matter. These two items are not a subject matter of that 1967 partition deed. There, your Lordship may kindly see the plain governments, particularly para 10.
ಈ partition include ಆಗಿಲ್ವಾ ಇದು?
They include ಆಗಿಲ್ಲ, that's what was stated in para 10. And I have produced the document also. I have produced the 1967 partition and I have produced the recent endorsement of 2016 issued by BDA stating what is the land available in both the survey numbers, which are also subject matter of 2015 partition deed between, intercept between the defendants. I have produced all the documents, not, even 1967 partition deed also I have produced.
So these properties are included in 1969 partition.
No, these properties are not included in 1967 partition.
ಹೇಳ್ತಾರೆ ಕೆರೆ ಅಂತ ತೋರಿಸಿ include ಮಾಡಿದ್ದಾರೆ ಅಂತ.
That's what 60/2. That is not 57/1. But I have also produced the last document, that is the endorsement. This is the property available in the year 2016.
What is the application? Where is the application?
Pardon?
Application for rejection of plaint.
Yes.
Order 7 rule 11 application ಎಲ್ಲಿದೆ?
Order 7 rule application ಅದು ಹಾಕ್ಲಿಕ್ಕೆ ಬೇಕಿಲ್ಲ ಅಂತ
Major pass.
ಕೊಡಿ.
have filed all those things, but office raised the objection, only judgment and plaint can be produced. May I read one?
If your lordship permits, my lord, I'll just explain the genealogy. Kindly
came
go to
Munirath-
page 69, my lord, 69
69.
of the appeal memorandum. There, my lord, three brothers, Chikkamarappa had three sons. Chikka Muniswamappa died in 81, Tammanna died in 83, Munibachappa is also there, but he has some issues. He died in 2014. He has also issues, but that is not shown there. Among these three brothers, the property came to be divided on 21/12/1967. Two properties are referred to. One is 60/2, another is 57/1 in the present proceedings.
67 partition.
67 partition ಅಲ್ಲಿ 60/2 ಇತ್ತು. Then, my lord, on 1969,
67/1 ಇರ್ಲಿಲ್ಲ.
57/1 is considered as the tank portion. ಅದರಲ್ಲಿ ಆ ಸರ್ವೆ ನಂಬರ್ ರೆಫರೆನ್ಸ್ ಕಾಣೋದಿಲ್ಲ.
ಇಲ್ಲ.
57/1. Then, my lord, there was another partition on 1969 among the family members of this number 2 and 3, Tammanna and Munibachappa. There, my lord, both these survey numbers are referred to. Now, the third partition on 2/2/15, on the basis of which the present cause of action is relied upon, is a partition among family members of Tammanna. That has nothing to do with this particular issue. They also refer to these properties. So the property was originally partitioned among three brothers in 67. Then in 69, there is a partition among two brothers, Tammanna and Munibachappa. In these two documents, there is a reference to it. Subsequently, in somewhere in 89,
They are not parties to the 1969 document.
69 reference is there. He does
They are
not check.
not parties.
He says parties are this Tammanna and Munibachappa and their issues.
But these people are Chikmuniswamappa's
Chikmuniswamappa, but
branch.
Chikmuniswamappa's LR Chikmuniswamappa dies in 1981. He does not question anything. Now, my lord, the cause of action is said to be 2/2/2015. They say 1969 is a void document. I will ignore. That is their plan. 2/2/15, my lord, this 60/1, 60/2 does not find a place. This is among the family members of Tammanna. And this land is acquired long ago in Yeshwantpura CATB. Yeshwantpura CATB acquire ಮಾಡ್ಕೊಂಡು compensation ಎಲ್ಲ. The land itself is not available. Property is long ago acquired for the purpose of, and their third parties are residing there. So the cause of action which relies on 2/2/15, which takes place among the family members of Tammanna, does not give him cause of action. He should go back to 67 and 69.
Let us see what you have mentioned in the application.
Application at page 80, 19. ಅದೇ ಇದನ್ನೇ ಹೇಳಿದೆಪ್ಪ. Para 4. That is why survey number 60/2 is part of partition in 1967. Award is also passed by the competent authority. It has attained finality. And para 5 is limitation.
So you also admit the notification reads that a land to an extent of 22 acres, 25 guntas in survey number 57/1 and 20
Is
acres,
acquired.
20 is acquired. There is no survey number 60 as mentioned in the plaint. It is survey number 60/2.
Correct.
I said this land is part of.
This land is
partition.
part of partition deed of 1967.
No, what he says that the entire 22 acres, 25 guntas is not acquired.
No, but
2 ಎಕರೆ 8 ಗುಂಟೆ ಅಂತಲೇ ಇದೆ.
ತೋರಿಸ್ಬಿಡ್ಲಿ ಅದು
ತೋರಿಸ್ಬೇಕು ಅಂದ್ರೆ ಅದು ಮೆರಿಟ್ಸ್
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಲ್ಲ, ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ.
Your lordship,
Let us go by the
Muniraj,
plaint
first
now.
defendant,
plaint
ಅಲ್ಲ Right.
Governmental,
Right.
do they say that any land is not
The
acquired?
different number one,
ತಾಳಿ,
he,
ನಿಮಿಷ ತಾಳಿ.
ಅದು ತಗೋತಾರೆ ಎಂಡಾಸ್ಮೆಂಟ್ ಏನೇನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ಅವರೇ ಕೊಡ್ತಾರೆ ಬಿಡಿ ಅನ್ನೋರು.
Para 10
16
ನೇ
ಅಲ್ಲಿ.
Please come to para 10. Please come to para 10. Para
12.
Para 6 ಅಲ್ಲೂ ಇದೆ. Remaining land measuring 2 acres 8 guntas was left out in Marappa's family in various blocks.
Yes.
Therefore, the land measuring 2 acres 8 guntas of land in survey 57/1.
What they say is no award is passed to an extent of 2 acre 8 guntas.
But acquisition ಆಗಿರೋದು 20 ಗುಂಟೆ ಅಂತ 20 ಎಕರೆ ಅಂತ ಹೇಳ್ತಿರೋದು.
Then, no, but even otherwise also, this land is included in the partition deed of 1967 itself.
But they are not parties to that.
No, first one they are parties, Chikkaman, their father is a party.
60/2 ಅದು.
60/2. 57/1 is concerned, that also is partitioned among the family members of two other brothers because this Chikkamani Swap also died. Only Tammanna and Munibachappa, they were partitioned among themselves. Now,
7 to 11 ಹಿಂಗ apply ಆಗುತ್ತೆ.
ಅದರಲ್ಲಿ prayer, plaintiff prayer ನೋಡ್ಬಿಡಿ.
How can 7 to 11 apply?
Prayer ಅಲ್ಲಿ
That is page 64.
prayer is, the cause of action is of 2015. How does the 2015 gives him a cause of action which is a place between partition between the family members of Tammanna, page 64. Direct the defendants to effect partition of suit schedule property of two survey numbers. One is 67, another is 57, 61. And allot half share of the plaintiff share on all suit schedule properties to direct them to put plaintiffs in exclusive half share. Declare the partition deed dated 2/2/15 entered between the defendants by including the suit schedule property in item 1 of the suit schedule property, which has not been allotted under the partition deed dated 21/12/67. That is already allotted in 21/12/67. And that hence the said partition deed dated 2/2/15 is a void document. Now see, the cause of action for this is only this 2015 document.
Correct, but then if only award is passed only in respect of 20 acres, what happened to the remaining 2 acres?
No, that 2 acres flood, he says that there is no award is passed, the entire property is in the
Then how did you partition in 1969? In the
67 flood. Partition is, the
Finally,
acquisition takes place later.
Correct.
Cushion earlier 1949.
So ಅಲ್ಲಿಗೆ ನೀವು 57/1 ಹಿಂಗ್ partition ಮಾಡ್ಕೊಂಡ್ರಿ ಹಿಂಗಿದ್ರೆ 69 ಅಲ್ಲಿ.
ಅಲ್ಲ 67 ಅಲ್ಲಿ 60/2 is included. So 1969 57/1 also is included.
Yes, how?
Now Lord, that is not very clear from the reading, but the consequential position is if he is aware of 69 document also, he says it is a void document.
Correct.
Lord, 69, if it's included in 69 document, the cause of action starts from 69.
No, but he's not a party to it.
No, he's
Not a party to it.
Lord, this 21/12/67 for one survey number, Lord, it is there. And land itself is, Lord, the suit plaint is for in respect of
2 items.
total extent of
Two items.
one is 30,087 square feet and 36,548 square feet, not for 2 acres. Now this bifurcation, this property itself, he says block number 47, block number 45, where is that property?
No, plaint ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ.
There is no identifiable property at all.
ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ಎಷ್ಟು ಅವೈಲಬಲ್
2 ಎಕರೆ ಕೇಳೋದಿಲ್ಲ, 2 acres ಕೇಳೋದಿಲ್ಲ ಅವರು.
Yes.
They are taking in respect of some block.
ಟಿ ಮುನಿರಾಜು
Correct, but order 7 to 11 ಹಿಂಗ್ apply ಆಗುತ್ತೆ sir.
No, but on the face of it, land itself is not available,
No,
is what
that
the
is not,
court
that
has.
is a ground that you have to establish after trial. ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅವ್ರಿಗೂ ಎಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಬೇರೆಯವರು ಇದ್ದಾರೆ ಪಾರ್ಟೀಸ್.
ಯಾರು
ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ
ಎಲ್ಲರೂ ಕೂಡ ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಡಿಫರೆಂಟ್ 2 to 4
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು?
ಕೇವಿಯಟ್ ಹಾಕಿರೋದು
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು?
2 to 4. Defendant 2 to 4.
ನೀನ್ ಯಾರಿಗೆ
Defendants 2 to 4. ನೀವ್
That is
ಯಾರಿಗೆ?
respondent 2 to 4, they have filed the application.
Now, whether response 2 to 4 are represented here.
ಅವ್ರು ಕೇವಟ್ ಹಾಕಿದ್ದಾರೆ, ಯಾರ್ಯಾರಿಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ.
He is appearing for
Mundaraju
only
and others.
respondent number 1.
ಮುನ್ರಾಜು and others ಅಂತ ಅಂದ್ರು.
ಹಾ.
ಯಾರ್ಯಾರು others ಅಂದ್ರೆ?
ಮುನ್ರಾಜು ಮತ್ತೆ ಮುನ್ರಾಜು
ಮುನಿರಾಜು,
ಫ್ಯಾಮಿಲಿ.
ಪ್ರಕಾಶ್, ಶಿಲ್ಪಾ,
ಮುನ್ರಾಜು
one
ತಮ್ಮನ
is son,
family.
another is the daughter of Jaipal. Mundiratnamma, wife of Jaipal.
See, this application is filed by defendant number 1.
1 and 4 below.
ಒಂದಲ್ಲ
1 and
ಒಬ್ರೇ
2 to 4.
ಒಬ್ರೇ ಹಾಕಿರೋದು ಇಲ್ಲಿ.
ಇಲ್ಲ, up 2 to 4 they have filed, that's what the order says.
There are two applications.
Huh?
I think there are two applications.
Two applications.
One by defendant number 1 and the
ಅದು ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದೆ, ಅದು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ.
ಅದನ್ನ ಏನು ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದಕ್ಕೆ ಏನು ಆರ್ಡರ್ ಮಾಡಲಿಲ್ಲ.
ಕರೆಕ್ಟ್. ಸೊ ಇದ್ರಲ್ಲಿ ನೀವು ಒಬ್ಬರೇ ತಾನೇ ಇರೋದು.
ಅಲ್ಲ, ಇದ್ರೊಳಗೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಅವ್ರ this order is passed on your application.
Yes.
So
No, no,
therefore
ಎರಡು
notice
ಹೇಳುತ್ತೆ,
is
ಅಲ್ಲ,
sufficient.
ಅದರಲ್ಲಿ
ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ
application filed on behalf of defendant number 2 to 4 ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ನೋಡಿ, ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಆರ್ಡರ್ ತಪ್ಪಿರ್ಬೋದು ಸರ್, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿ.
ಅಲ್ಲ,
2 to 4 is the application.
This is one application, another application is filed.
No, 2 to 4 is the application, IA number.
Order is passed
3.
on their application.
IA number 3.
IA number 3 filed by different 2 to 4 jointly.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ ಏನು?
IA number 3 ನೇ ಅವ್ರದ್ದು.
ಅವ್ರದ್ದು
ಅವ್ರದ್ದು
ನಂಬರ್
IA number
1.
3. IA number 1 ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್, ಅದು ಏನು ಬೇರೆ ಕಡೆ ಇದಾಗಿದೆ.
IA number 1 ಏನಾಯ್ತು?
IA number 1 they have left it like that, they did not
ಮಾಡಲಿಲ್ಲ. ಇದು ಆರ್ಡರ್ ಆಗಿದ್ದಕ್ಕೆ ಅದ್ರ ಮೇಲೆ
ರಿಜೆಕ್ಟ್ ಆಗೋಯ್ತು ಅದು.
ಬರ್ಕೊಡಿ. ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್? ಸೇಮ್ ಲಾಯರ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೇಮ್ ಲಾಯರ್ D1, D2, D3, D4 ಗೆ.
D1 ಒಬ್ರು, D2 to 4 ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ.
ಯಾರು?
D1 by SS ಅಂತಿದೆ, D2 to 4 SKK ಅಂತಿದೆ. ಯಾರು SKK?
ಬರ್ಕೊಡಿ. Issue emergent notice to respond number 2 to 4. It is open for the learned counsel for the appellants to serve copy of the appeal memorandum along with all enclosures to the learned counsel who represented the defendants 2 to 4 before the trial court. Full stop. List on yavat?
ಅದರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ಗಳು ಕೇಳಿದ್ದೀನಿ.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರು?
ಎಲಿನೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, they are deleting the property.
Entry ಮಾಡ್ರು. Until the next date of hearing, comma, the respondent number 1 is, respondents are restrained
2 to 4.
from alienating, encumbering or transferring the properties which are the subject matter of OS number
1793 of 2020.
Which is presently disposed of by the 33rd Additional City Civil and Sessions Judge at Bangalore City. But ಏನು ಕನ್ಸಿಡರ್ ಮಾಡೋರ್ಗು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
ಹೇಳಿದ್ದೀನಿ ಅಪ್ಲಿಕೇಶನ್.
ನೆಕ್ಸ್ಟ್ ಕರೀರಿ. ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ. 17th April.
For final hearing matter, serial number 39, VB Shivkumar.
Mr. VB Shivkumar. ಸಂಘವಿ ಇಲ್ರಿ.
First floor matter, serial number 5.
Mail order. We have complied.
Mr. Vasant.
Vasant ಅವರೇ. ಬನ್ನಿ. We take steps to R2 and 3. And I will give the.
R2 has not contested the suit.
ಇಲ್ಲ, he filed written statement.
He did not participate.
He filed the written statement. ತಾವು ಮಾಡಿದ್ರೆ ಯಾಕೆ ಅಂದ್ರೆ she is not in possession with the help of plaintiff. It's already your lordship may can be. Emergent notice I will take.
DW1 is Chandan Mal Jain.
ಹೌದು.
That is 3, different number 3.
Although the entire story is different, your lordship may kindly see. Or VB Shivkumar issues the notice saying that we are the tenant.
The respondents 2 and 3 were the defendants
1 and 2.
1 and 2 before the trial court. It appears that the defendants 1 and 2 did not participate in the proceedings
But they filed
except
written
filing a written statement.
File written statement ಹಾಕಿದ್ದೆ.
They except filing a written
Yes.
statement.
Yes.
Full stop. Therefore, comma, notice to the said respondents is not necessary. Hence, notice to the respondents 2 and 3 is dispensed. Yes, come on, merits.
Any day, your lordship.
Huh?
Your lordship.
Date ಅಂದ್ರೆ ಇವತ್ತೇ date.
ನಾವು ಪ್ರಿಪೇರ್ ಆಗಿಲ್ಲ papers. Your lordship may have it next time. We will argue.
List on ಯಾವತ್ತು ಬೇಕು?
17th, 18th.
List on?
17th, 18th.
17th next week ಅಲ್ಲಿ ಕೊಡಿ. 9th.
9th, your lordship ಬೇಕಾಗಿ. ಸ್ವಲ್ಪ I will not be
ಆಯ್ತು.
there, Mali.
ಒಂದ್ ಕೆಲ್ಸ
ಸ್ವಲ್ಪ 17th, 18th. Any
ಮಂಡೇ. ಮಂಡೇ.
ಯಾವ ಡೇಟ್ ಸರ್?
5ನೇ ತಾರೀಕು.
5ನೇ ಬೇಡ ಸರ್. We request your lordship ಸ್ವಲ್ಪ ಇದು ಬ್ರೀತಿಂಗ್ ಟೈಮ್ ಕೊಡಿ. We will argue the matter.
ಅಲ್ಲ ಸರ್ ಇದೆಲ್ಲ
14th, 15th
ಬ್ರೀತಿಂಗ್ ejectment suits ಅಲ್ಲಿ no breathing time.
Your lordship may have it on 14th, 15th. 15th, 16th.
ಎಲ್ಲ ಎನಿ Thursday, Friday.
Friday. 18th, Friday ಅಂದ್ರೆ 17th ಹಾಕ್ಬಿಡಿ.
10th April. Yes, next. 10th April.
For final hearing matter, serial number 39. VP Shivkumar.
Mr. C. Prakash.
I appear for the,
Ready na? Can I take it up?
last time, ಶಿವಕುಮಾರ್ ಅವರು ಹೇಳಿದ್ರು, he will give a proposal for settlement ಅಂತ. ನನ್ಗೇನು ಹೇಳಲಿಲ್ಲ ಇಲ್ಲಿವರೆಗೂ.
We always said vacant site, which is the item 1 property, we will retain it. Constructed building, we give it to them so that they can take.
Last time ಹೇಳಿದ್ರು, last time
ಅದನ್ನ ಹೇಳಿದ್ರು, ಆಮೇಲಿಂದ ಐ ವಿಲ್ ಸ್ಪೀಕ್ ಟು ಮುರಳೀಧರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಟೈಮ್ ತಗೊಂಡ್ರು. ನನ್ಗೇನು ತಿರ್ಗಾ ಆಮೇಲೆ ಏನು ಹೇಳಿ ಅದು ಬಿಟ್ರೆ ಬೇರೆ ಏನಾದ್ರು ಚೇಂಜಸ್ ಇದೆಯಾ? ಈಗ ನಾವೇನ್ ಕೇಳಿದ್ದೆ ಅಂತಂದ್ರೆ ವಿ ಆರ್ ಗಿವಿಂಗ್ ಅಪ್ 3 shares. ಅಲ್ಲ ಈಗ ಅದು ಒಂದೇ ಆಮೇಲಿಂದ ಹೇಳಿದ್ರು ಇನ್ ಅಡಿಷನ್ ಟು ವೇಕೆಂಟ್ ಸೈಟ್ ವಿ ವಿಲ್ ಗೆಟ್ ದೆಮ್ 1 site ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲಿಂದ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇನೆ.
ಯಾರು ನೋಡಿ ಅವ್ರ್ಯಾರು ಬಂದಿದ್ದಾರೆ, ಕೈ ಮುಗಿತಾ ಇದ್ದಾರೆ.
ಏನಾದ್ರು ಒಂದು ಅಮಿಕಬಲ್ ಇತ್ತು ಅಂತಂದ್ರೆ ನಾವೇನ್ ರೆಡಿ ಇದೀವಿ, ಏನಿಲ್ಲ. ಯಾಕಂದ್ರೆ ವಿ ಆರ್ ಗಿವಿಂಗ್ ಅಪ್ 3 shares, ಅವ್ರದ್ದು 2 share ಇರೋದು. ನಾವು ಕೇಳ್ತಾ ಇರೋದು ಏನು ಅಂತಂದ್ರೆ ನಾವು 3 ಜನ ಡಾಟರ್ಸ್ ಇದೀವಿ, ಆ ಓಪನ್ ಸೈಟ್ ನಮಗ್ ಕೊಡಿ.
ಯಾವ್ದು ಅಲ್ಲೆಲ್ಲೋ ಇದೆ ಅಂತ
ಬೇಗೂರಲ್ಲಿ ಒಂದಿದೆ, ನಾವು 3 share ಬಿಟ್ಕೊಡ್ತೀವಿ. ಅವರು ಮನೇಲಿ ವಾಸ ಮಾಡ್ತಿದ್ದಾರೆ, ದೇ ಆರ್ ರಿಯಲೈಸಿಂಗ್ ರೆಂಟ್ ಫಾರ್ ದ ಪಾಸ್ಟ್ ಸೆವೆರಲ್ 10-15 years. ಆರ್ ಇದ್ಕೊಂಡು ಹೋಗ್ಲಿ, ಅವ್ರ ಇಬ್ಬರೇ ಬ್ರದರ್ಸ್, ವಿ ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಟರ್ಬ್. ಅದ್ರೊಳಗೆ ಒಬ್ರು ಬ್ರದರ್ ಮದ್ವೆ ಆಗಿಲ್ಲ, ಇನ್ನೊಬ್ರು ಬ್ರದರ್ ಮಾತ್ರ ಮದ್ವೆ ಆಗಿರೋರು. ನಾಳೆ ದಿನ ಅವ್ರಿಗೆ ಬರುತ್ತದು, ನಾವೇನ್ ಕೇಳಲಿಕ್ಕೂ ಅಲ್ಲ. ನಾವು 3 ಜನ ಸಿಸ್ಟರ್ಸ್ಗೆ ಆ ಸೈಟ್ ಕೊಟ್ರೆ 3 ಜನನು ಹಂಚ್ಕೊಂಡು ನಾವು ಅಲ್ಲಿ ಏನೋ ಮನೆ ಕಟ್ಕೊಂಡು ಇರ್ಲಿಕ್ಕಾಗತ್ತೆ ಅಂತ ನಾವು ಹೇಳೋದು. ಬಟ್ ಅವ್ರ ಪ್ರಪೋಸಲ್ ಇರೋದು ಉಲ್ಟಾ, ನಿಮಗ್ ಮನೆ ಕೊಟ್ಬಿಡ್ತೀವಿ, ನೀವು ಮನೆ ತಗೊಳ್ಳಿ, ನಾವು ಸೈಟ್ ಇಟ್ಕೋತೀವಿ ಅಂತ. ಅದಕ್ಕೋಸ್ಕರ ವಾಟ್ ವಿ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್, ಆಲ್ ರೈಟ್, ಲೆಟ್ ದಟ್ ಸೈಟ್ ಬಿ ಗಿವನ್ ಟು ಅಸ್, ಲೆಟ್ ದೆಮ್ ಕೀಪ್ ದಿ ಹೌಸ್ ಫಾರ್ ದೆಮ್ಸೆಲ್ಸ್.
ಅದ್ರ ಮೇಲೆ ಏನ್ ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ? ಅದ್ರ ಮೇಲೆ ಏನ್ ಕೊಡ್ತೀರಾ? ದಿಸ್ ಸೈಟ್ ಇಸ್ 30/40.
ಇದು ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಹೌಸ್.
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್
ಹೌದು.
ಇದು 50/80, 4,000 ಇದೆ.
ಹೌದು.
4,300, 4,500.
ಹೌದು, 4,500. ನಮ್ದು 3 share, ಅವ್ರದ್ದು 2 share.
2 share ಲೆಕ್ಕ ಹಾಕಿ ಎಷ್ಟಾಯ್ತು? 1,200 ಪ್ಲಸ್ 4,400.
4,400.
6,600 ಅಡಿ ಡಿವೈಡೆಡ್ ಬೈ 6 shares.
5.
ಅಲ್ಲಿಗೆ 12 60. ಹ್ಮ್ 1,345 square feet ಬರ್ತದೆ ಎಲ್ಲ ಇಬ್ಬರಿಗೂ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ. 1,345 into 3 ಎಷ್ಟಾಯ್ತು? $3,960 square feet ಆಯ್ತು ನಿಮಗೆ. ಅಲ್ಲಿಗೆ ಇನ್ನೂ 500 ಅಡಿ ಜಾಸ್ತಿ ಬರುತ್ತಲ್ಲ ನಿಮಗೆ.
500 ಅಡಿಗೆ ಅದೇ
ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಬಿಲ್ಡಿಂಗ್ ಬರುತ್ತೆ
4,000.
ಅಲ್ಲಲ್ಲ, 500 ಅಡಿ ಜಾಸ್ತಿ ಬರುತ್ತೆ ನಿಮ್ಗೆ ಗರ್ವೆ ಬಾಳಿ ಇದು ಕೊಟ್ರುನು
ಹ್ಮ್
ಅಲ್ಲೂ 500 ಅಡಿ ಜಾಸ್ತಿ ಬರುತ್ತೆ ನಿಮಗೆ.
4,000 ಅಂತ ಅದು 4,000 ಸ್ಕ್ವೇರ್ ಫುಟ್.
50/86 ಅಂತ ಇದೆ.
29.5 ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಒಂದ್ ಕಡೆ 86 ಇದೆ. ಎಷ್ಟಾಯ್ತು?
80 ಸ್ವಾಮಿ.
86 ಇದೆ ಇಲ್ಲಿ, 86 ಅಂತ.
ಅದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. 79.
ಬೇಕಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ, ಸರಿ ಮಾಡಿಸ್ಕೋಬೇಕು.
79.5 ಅಷ್ಟೇನೆ ಇದೆ.
ಇಂಟು 86 ಅಂತ ಇದೆಯಲ್ಲ.
ಅಲ್ಲಿ 86 and western side 86.
ಅದು 4,000 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಅಷ್ಟೇ ಬರೋದು ಸ್ವಾಮಿ.
ನಮ್ಮ ಇಲ್ಲಿರೋದು 86 ಅಡಿ ಅಂತ ಬರ್ದಿದೆ.
ಅದೇ ಅದು
ಮಿಸ್ಟೇಕ್ ಅಂದ್ರೆ ಅದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಸರಿ ಮಾಡು.
ಅವ್ರು ಏನ್ ಕೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಸಪೋಸಿಂಗ್ ಇಫ್ ಯು ಆರ್ ಟೇಕಿಂಗ್ ಸೈಟ್, ನೀವೇನಾದ್ರು ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ ಅವ್ರಿಗೆ? ದೇ ವಿಲ್ ಕೀಪ್ ದಿ ಹೌಸ್. ಯಾಕೆಂತಂದ್ರೆ ನಿಮ್ಗೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಸ್ಕ್ವೇರ್ ಫುಟ್ ಜಾಸ್ತಿ ಬರ್ತಾ ಇದೆ,
ಅದೇ 1,200
ಜಾಸ್ತಿ ಬರುತ್ತೆ ನಿಮ್ ಶೇರ್ಗೆ.
800 ಅಡಿ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಬರುತ್ತೆ ನಿಮಗೆ. ಅಲ್ಲಿ ಕೊಟ್ರೆ ಅಲ್ಲಿ ಗರ್ವೆ ಬಾಳಿ ನೀವು 3 ಭಾಗ ಕೊಟ್ರೆ 800 ಅಡಿ. 800 ಅಲ್ಲ, ಜಾಸ್ತಿನೇ ಬರ್ತದೆ.
800 ಅಡಿ 4,000 ಸ್ಕ್ವೇರ್ 800 ನಿಮ್ಗೆ.
ಏನ್ ನಿಮ್ಮ ಅಣ್ಣನ ತಮ್ಮನ ಇವರು?
ಅಣ್ಣದಿರಿ ಇಬ್ರುನು.
ಇಬ್ರು ಅಣ್ಣಂದ್ರು.
ಇಬ್ರು ಅಣ್ಣ. ಇವ್ರ
ಏನೋ ಅವ್ರಿಗೆ ಆಯ್ತಮ್ಮ, ನೀವು ಮನೆ ಕಡೆ ಚೆನ್ನಾಗಿದ್ರ, ಅವರು ಸ್ವಲ್ಪ ಚೆನ್ನಾಗಿರಕ್ ಬಿಡಿ.
ಚೆನ್ನಾಗಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲೆಲ್ಲ ಬೇರೆ ಕಡೆನೂ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು. ನಮ್ಮ ತಂದೆ ಹತ್ರ ಇಸ್ಕೊಂಡು.
ಅಲ್ಲ ಅಂತ ಅವ್ರ ಶಕ್ತಿ
ಮನೆ ತಗೊಂಡು ಸೈಟು
ಕರೆಕ್ಟ್ ಅಮ್ಮ, ಅವ್ರ ಶಕ್ತಿ.
ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಸ್ವಲ್ಪ ತಡಿಯಪ್ಪ, ನೀನ್ ಯಾಕೆ ಈಗ ಇದು ಇದಿರೋದು ಮನೆ ಅಲ್ವಮ್ಮ? ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಮನೆನ ಅಂಗಡಿನ? ಆಯ್ತು, ಮನೆ ವಾಸಕ್ಕೆ ಇಲ್ಲಿ ಇದಾರೆ. ಮೇಲೆ 2 ಕೆಳಗಡೆ 2 ಬಾಡಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಷ್ಟು ಬಾಡಿಗೆ ಬರುತ್ತೆ?
ಎಲ್ಲ ಒಂದು 30,000 ಬರುತ್ತೆ.
ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದವ್ರು ಯಾರು?
30,000
ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ ನೀವು ಅಪ್ಪ ಕಟ್ಟಿದ್ದ?
ಅದು KHB ಕ್ವಾರ್ಟರ್ಸ್. ಅವಾಗ ಅವರು ತಗೊಂಡಿರೋದು 64.
ಆಮೇಲೆ ಇವ್ರೇನ್ ₹1 ಅಲ್ಲಿಂದ ರೆವಿನ್ಯೂ ತಗೊಂಡಿ.
ಆಯ್ತು, ಅದ್ ಏನೋ ಕುತ್ಕೊಂಡು YMCA ಮಾತಾಡಿ.
300 ಗ್ರಾಮ್ ಒಡವೆ ಇತ್ತು ಸ್ವಾಮಿ. 1 ಗ್ರಾಮ್
ಕೋರ್ಟ್
ಅಂತ ಕೊಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಅವರೇ ಇಟ್ಕೊಂಡು ಸ್ವಾಮಿ, ಫಿಕ್ಸೆಡ್ ಇಟ್ಕೊಂಡ್ರು. ಮನೆ
ನಮ್ಮ ಅಪ್ಪ ಅಮ್ಮನ ಹೆಸರಲ್ಲಿ ಇತ್ತು, ಅದನ್ನು ಅವರೇ ತಗೊಂಡ್ರು. ನಾವು ಕೇಳಲಿಲ್ಲ.
ಅದು ಮೆಜರ್ಮೆಂಟ್ ಅದು ಅಷ್ಟೇ, ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಅದು ಅಲ್ಲಿ ತಪ್ಪು ಬಿದ್ದು ಹೋಗಿದೆ ಅಷ್ಟೇನೆ. ಅದು ದಟ್ ಈಸ್ ದಿ ಈಸಿ.
ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ನೀವೇ ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ.
ನಾವ್ ಹೇಳಿದ್ ನೀವೆಲ್ ಕೇಳ್ತೀರಾ? ನಾವ್ ಹೇಳಿದ್ ನೀವೆಲ್ ಕೇಳ್ತೀರ?
ನ್ಯಾಯ ಸಿಗ್ಬೇಕು
ನೋಡಿ, ನ್ಯಾಯ ಅಂತ ಹೋದ್ರೆ ಜೀವಗಳು ಹೋಗುತ್ತಮ್ಮ, ಸಂಬಂಧಗಳು ಹೋಗ್ತದೆ, ಜೀವಗಳು ಹೋಗುತ್ತೆ. ಏನೋ ಬೇರೆಯವ್ರಾಗಿದ್ರೆ ನಾವು ಖಂಡಿತವಾಗಿ ಮುರಿದು ಕೊಡ್ಬೋದು. ಇವು ಅಣ್ಣ ತಮ್ಮಂದ್ರು, ಅಕ್ಕ ತಂಗಿರು.
ಅದೇ ತಾಯಿದು 1 ಗ್ರಾಮ್ ಒಡವೆ ಕೊಡೋಣ ಅಮ್ಮಂದು, ಹೆಣ್ಣು ಮಕ್ಕಳಿಗೆ ಅಂತ ಮನ್ಸು ಬರ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅವ್ರಿಗೆ ಮನ್ಸಿಲ್ಲ.
ಮನೆಗ್ ಬಂದ್ರೆ ಕಾಲ್ ಮುಡಿತೀನಿ ಅಂತ ಹೇಳಿ ಓಡ್ಸಿದ್ರು.
ಏನ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ ನೀವೇ ಹೇಳಿ.
ನಮಗ್ ನೋವಾಗಲ್ವಾ?
ಒಂದಿನ ಗೌರಿ ಹಬ್ಬಕ್ಕೆ ಕರೆದು ಒಂದು ₹50 ಒಂದು ಬಳೆನೂ ಕೊಡಕ್ಕೆ ಅವ್ರಿಗೆ ಯೋಗ್ಯತೆ ಇಲ್ಲ. ನಾವೇನು ಅವ್ರಿಗೆ ಅಣ್ಣ ತಮ್ಮದು ಕರೆಯಕ್ಕಾಗುತ್ತೆ ಸ್ವಾಮಿ?
ನೀವು ಸುಮ್ಮನಿರಮ್ಮ. ನೀವ್ಯಾಕಮ್ಮ? ನೀವ್ಯಾರು? ಅವ್ರ ಅಣ್ಣ ತಮ್ಮ ಅವ್ರು ಮಾತಾಡ್ತಾರೆ. ಅಲ್ಲ, ಇವಾಗೆಲ್ಲ ನೀವೆಲ್ಲ ಬೇರೆ ನಿಮ್ ಮನೆಗಳಲ್ಲಿ ಇದ್ದೀರಲ್ಲ. ಆಯ್ತು, ಇವಾಗ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಬೆಲೆ ಇದೆಯಲ್ಲಮ್ಮ, ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಬೆಲೆ ತಕೊಂಡು ಅದನ್ನ ನೀವು ಮಾರಾಟ ಮಾಡ್ಕೊಳ್ಳಿ. ಯಾಕೆ? ನಿಮ್ ತಂದೆ ತಾಯಿ
ಹೆಣ್ಮಕ್ಳಿಗೆ ನಿಮ್ಗೆ ಸೈಟ್ ಕೊಡ್ತೀನಮ್ಮ, ಮನೆ ವಿಷಯಕ್ಕೆ ಬರ್ಬೇಡಿ ಅಂತ ಹೇಳಿ. ಸೈಟ್ ಬಂದ್ರೆ ಒಂದೊಂದು ಸೈಟ್ ಬರುತ್ತೆ 3 ಜನಕ್ಕೆ. ಮನೆ ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ. ಇಷ್ಟು ವರ್ಷದಿಂದ ಬಾಡಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ, ಅದೇ ಮನೆಯಲ್ಲಿ ಅವ್ರ ಹಂಗೆ ಇಟ್ಕೊಳ್ಳಿ, ನಮ್ಗೆ ಯಾಕೆ?
ಆಯ್ತು, ಸೈಟ್ ನೀವು ತಕೊಳ್ಳಿ. ಅಲ್ಲಿ 800 ಅಡಿ ಬಿಟ್ಕೊಡ್ಬೇಕಾಗತ್ತ? ಸೈಟ್ ಅಲ್ಲಿ 800 ಅಡಿ ಬಿಟ್ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
ಇಲ್ಲ 4,000 ಸ್ಕ್ವೇರ್ ಫುಟ್ ಅಲ್ಲಿ 5 ಭಾಗ ಮಾಡೋಣ. 4,000 ಸ್ಕ್ವೇರ್ ಫುಟ್ ಅಲ್ಲಿ ಅದ್ರೊಳಗೆ 3 ಭಾಗ ಇವ್ರಿಗೆ ಇದ್ ಮಾಡಿದ್ರೆ when they are 3 ಭಾಗ ಇವ್ರಿಗೆ ಬರಬೇಕು. They are giving up their right over Wilson Garden property in lieu of 2 shares. ಅವ್ರ ಇದ್ರೊಳಗೆ ಸೈಟ್ ನಲ್ಲಿ 2 ಶೇರ್ ಅವ್ರು ಬಿಟ್ಟು ಕೊಡ್ತಾರಲ್ಲ, ಅದಕ್ಕೆ we are going to give up the entire Wilson Garden property over which they have 3 shares. ಏನು ನಾವು ಅದ್ರೊಳಗೆ ಏನು ಕ್ಲೈಮೇ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗೋದಿಲ್ಲ.
ಕರೆಕ್ಟ್ YMCA ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ.
ಅದು ಮಾಡ್ಬಿಟ್ರೆ
it is
let them continue to live there and we have not claimed even single rupee mean profit though they are earning rent in that property. ಇಲ್ಲಿವರೆಗೂ ನಮ್ಗೇನು ಇಲ್ಲ. ಇದು ಅವ್ರ 2 ಶೇರ್ ಬಿಟ್ಟು ಕೊಡೋದಕ್ಕೆ we are giving up 3 shares in Wilson Garden property. ಅವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಅವರು ಅದನ್ನ ಯಾರು ಮಾರಾಟ ಮಾಡ್ದಲೇನೆ ಬೈಫರ್ಕೇಟ್ ಮಾಡಿಸ್ಕೊಂಡು 3 ಜನನು ಒಂದೊಂದು ಸೈಟ್ ಇಟ್ಕೋತಾರೆ. ಇದನ್ನ ಅವರು ವಾಸ ಮಾಡ್ತಿದ್ದಾರೆ. ಲೆಟ್ ದೆಮ್ ಕಂಟಿನ್ಯೂ ಟು ಲಿವ್ ದೇರ್.
ಆಯ್ತು, ಆರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡೋದು, ಏನಾಗುತ್ತೋ ಆಗ್ಲಿ. ಇನ್ನ 20 ವರ್ಷ ಫೈಟ್ ಮಾಡಿ, ಯಾರು ಬೇಡ ಅಂತಾರೆ? ಪೊಸಿಷನ್ ಬರೋಕೆ ಇನ್ನು 20 ವರ್ಷ ಬೇಕಾಗುತ್ತೆ, ಮಾಡಿ.
ಅದು ಆಗಬಾರದು ಅಂತಾನೆ ನಾವು ಟ್ರೈ ಮಾಡ್ತೀವಿ. ಸಮ್ ಫೇರ್ನೆಸ್ ಇದೆ ಅಲ್ವಾ ಅವ್ರು ಕೇಳೋದ್ರು.
ಕರೆಕ್ಟ್, ಯು ಶುಡ್ ಬೋತ್ ಆಫ್ ಯು ಶುಡ್ ಕಮ್ ಟುಗೆದರ್, ಒಂದ್ ಏನೋ YMCA ಮಾಡ್ಬೇಕು.
ಆಲ್ಮೋಸ್ಟ್ ವಿ ಹ್ಯಾವ್ ಕಮ್ ಕ್ಲೋಸ್. ಇನ್ನೇನು ಅಂತ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ, ಏನ್ ಮಲ್ಟಿಪಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ ಅಂತ ಇಲ್ಲ.
ನೋಡಿ, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಇಟ್ಸ್ ಎ ವೇಕೆಂಟ್ ಸೈಟ್.
ಎಸ್,
ಇಫ್ ಇಟ್ಸ್ ಎ ವೇಕೆಂಟ್ ಸೈಟ್, ಇಟ್ ಇಸ್ ಲೈಕ್ ಎ ಸಿಟಿ ಅಂತ ನಿಮ್ಗೂ ಗೊತ್ತಿದೆ. ಇವ್ರು ಇನ್ನೂ ಫೈಟ್ ಮಾಡ್ಕೊಳ್ತಾನೆ ಇರ್ತಾರೆ. ಸಮ್ ಥರ್ಡ್ ಪಾರ್ಟಿ ವಿಲ್ ಕಮ್, ಏನು ಶೆಡ್ ಹಾಕ್ತಾರೆ, ನೀವು ಹೋಗ್ಬೇಕು, ಗಲಾಟೆ ಆಗುತ್ತೆ. ಇದೆಲ್ಲ ದೀಸ್ ಆರ್ ಥಿಂಗ್ಸ್ ವಿಚ್ ಕ್ಯಾನ್ ಬಿ ಅವಾಯ್ಡೆಡ್. ಯೋಚನೆ ಮಾಡಿ, ಇಲ್ಲ ಕಮ್ ಅಪ್ ವಿತ್ ಸಮ್ ಆಫರ್. ನಮ್ಗೆ ಇದು ಗರ್ವೆ ಇದು ಪಾಳಿದ ಕೊಟ್ಬಿಡಿ, ನಮ್ಗೆ ನಾವು ಇಷ್ಟು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಅವ್ರು ಮೇಕ್ ಸಮ್ ಆಫರ್. ಇನ್ನು 800 ಅಡಿ ಹೆಂಗೋ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಬರುತ್ತೆ ನಿಮ್ಗೆ. 4000 ಅಡಿಲಿ ನಿಮ್ಗೆ ಫುಲ್ ಸಿಗಲ್ಲ.
ಹೌದು,
ಗೋಯಿಂಗ್ ಬೈ ದಟ್ ರೇಟ್.
ಎಸ್,
ಅಲ್ಲಿಗೂ 800 ಅಡಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 800 ಅಡಿಗೆ ಏನ್ ಬೆಲೆ ಕಟ್ತೀರಾ ಹೇಳಿ?
800 ಅಡಿಗೆ ಬೆಲೆ ಕಟ್ಕೊಂಡ್ರೆ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಪ್ರಾಪರ್ಟಿ ಏನು ಇರಲ್ವಲ್ಲ ನಮ್ಗೆ.
ಹಂಗಿರೋ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ತಗೊಳ್ಳಿ, ಅಲ್ಲೂ ತಗೊಳ್ಳಿ, ಕೇಸ್ ನಡೀಲಿ ಅಷ್ಟೇ. ಕೇಸ್ ನಡೀಲಿ. ಇಲ್ಲ, ಕಮ್ ಅಪ್ ವಿತ್ ಸಮ್ ಟರ್ಮ್ಸ್. ನಮ್ಗೆ ಒಂದ್ ಕೋಟಿ ರೂಪಾಯಿ ಕೊಡಿ ಅಂತ ಕೇಳಿ. ನೀವು ಕೊಡಿ ಅಂತಲ್ಲಮ್ಮ, ಅವ್ರು ನಿಮಗ್ ಕೊಡ್ತಾರೆ, ತಗೊಳ್ತೀರಾ? ನೋಡಿ, ಏನು ಬೇಡ ಅಂದ್ರೆ ಕೇಸ್ ನಡೆಸಿ. ಎಸ್ ಮಿಸ್ಟರ್ ಆರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡಿ ಕೇಸ್. ಏನು ಬೇಡ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕ, ಕೇಸೇ ನಡೆಸ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅವರು ಸೈಟ್ ತಗೊಂಡ್ರೆ ಅಲ್ಲ 5 ಶೇರ್ಸ್ ಆಗ್ಬೇಕಲ್ಲ ಮೇಡಮ್. 5 ಶೇರ್ಸ್ ಆಗ್ಬೇಕು.
ನೋಡಿ, ನಿಮ್ ದೊಡ್ಡಕ್ಕ ಹಿಂದ್ಗಡೆ ದೇವ್ರ ತರ ನಿಂತಿದಾರ ಅವ್ರು. ಅವ್ರಿಗೇನು ಬೇಡ. ಅವ್ರ ಮೇಲೆ ಏನ್ ಕನಿಕರ ಇಲ್ವಾ ನಿಮ್ಗೆ? ಏನಪ್ಪ
ನಾವು ಜೊತೆಗೆ ಅಪ್ಪ ಅಮ್ಮ ಸಾಕಿದವ್ರು ಜೊತೆಗಿದ್ದವ್ರು ನಾವು. ಅವ್ರ ಹುಷಾರಿಲ್ಲ ಅಂದಾಗ ಇವ್ರು ಅವ್ರ ಗಂಡನಲ್ಲಿ ಇದ್ದು ಆಸ್ತಿ ಮಾಡ್ಬೋದು, ಇವತ್ತು ಅಪ್ಪನ ಹತ್ರ ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಅದನ್ನ ಯಾರು ಕೇಳೋದಿಲ್ಲ. ಈಗ ಬಂದು ನಮ್ಮ ತಂದೆಯವ್ರು ಹೇಳಿದ್ರು, ಆಗೋದಿಲ್ಲ ಬಿಲ್ ಮಾಡಿದ್ವಿ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಇದ್ದದ್ದು. ಬಟ್ ಬಿಲ್ ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ. ಅದೊಂದು ಪಾಯಿಂಟ್ ಅವ್ರಿಗೂ ಗೊತ್ತದು, ಹೆಣ್ಮಕ್ಳಿಗೂ ಗೊತ್ತು. ಆ ಸೈಟ್ ಅಲ್ಲಿ ಏನೋ ಎಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತ ಸುಮ್ಮನೆ ಆಗುತ್ತೆ. ಇಲ್ಲಾಂದ್ರೆ ಬಿಲ್ಗೆ ಆ ಸೈಟ್ ಸೆಟ್ ಮಾಡ್ಕೊಳ್ಳೋದಾಗಿತ್ತಲ್ಲ. ಹೆಣ್ಮಕ್ಳು ಸಂಬಂಧಗಳೆಲ್ಲ ಹಾಳು ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ನಾವು ಎಲ್ಲೋ ಕೇಳಿ ಚೆನ್ನಾಗಿರೋ ಕೇಳಿ ಹೆಣ್ಮಕ್ಳು ಅಪ್ಪ ಅಮ್ಮ ಮಾಡಿದ ಅವತ್ತಿಂದ ಇವಕ್ಕೆ ಚೆನ್ನಾಗಿರೋದು. ಇವತ್ತಿನ ದಿನ ನಾವು ಯಾರು ಬದುಕ್ತಾ ಇರೋದು?
ಮಾಡಿ ನೀವು ಇವರದ್ದು ಅಪ್ರದತ್ತ
ಅವ್ರ ಗಂಡ ಜೈಲಿಗೆ ಹೋದ್ರು. 2 ವರ್ಷ ಜೈಲಲ್ಲಿ ಇದ್ರು. ನಾವು ಏನಾದ್ರು ನಿಂತಿದ್ದೀವಿ. ಅವಳ ದುಡ್ಡು ತಂಗಿ ಆದವರು ಸೋತಾಗಲ್ಲ. ನಾವು ಗಂಡ ಜೈಲಿಗೆ
ಅಯ್ಯೋ ಹೌದು ನೀನೇ ಬಂದು ನನ್ನ
ದುಡ್ಡು ಗಂಡ ಅನ್ಸ್ಕೊಂಡವ್ರು. ನಾವು ಕಷ್ಟ ಬಿದ್ದಿಲ್ಲ ಅವತ್ತೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಮನೆಗೆ ಕೊಡೋದು ಯಾರೋ ಕಟ್ಕೊಂಡು ಇಂದು ಕೇಸು ಅವತ್ತು ಅಪ್ಪ ಮನೆಗೆ ಸೇರ್ಬಿಡಿ ತಂದ್ರು. ನಾವೇನು ಇಲ್ಲ ಬೇಡ ತಂಗಿ
ಇವತ್ತು ನಾನ್ ಚೆನ್ನಾಗೇ ಇದ್ದೀನಿ.
ಅದನ್ನೇ ಹೇಳಿದ್ದು ನಾವು ಮಾಡಿದ್ದೀವಿ ಚೆನ್ನಾಗಿಲ್ಲ. ಬೇರೆ ಕೇಳಿಲ್ಲ. ನಾವೇನು ತಂದೆ ಮಾಡಿದ್ರು ಕ್ಲೀನ್ ಮಾಡಿದ್ರು ಮದುವೆ ಆಗಿಲ್ಲ ಅಂತ ನಾವು ಜೀವನಕ್ಕೆ ಯಾರು ನೋಡ್ತಾರೆ? ಇವ್ರು ಯಾರು ಬಂದು ನೋಡ್ತಾರೆ ಅಥವಾ ಇನ್ನೊಬ್ರು ನೋಡ್ತಾರೆ? ಇವತ್ತು ಅವ್ರಿಗೆ ಆರೋಗ್ಯ ಇರೋದೇ ಪರವಾಗಿಲ್ಲ. ಅವರು ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಅವ್ರ ಆಸ್ತಿ ತಗೊಂಡು ಭಾಗ ನನಗೆ ಕೊಡ್ತಾರೆ ಅಂತ ಯಾರು ಬರ್ಕೊಡ್ತಾರೆ?
ನೀನೇ ಅಯ್ಯೋ ನಿನ್ ಮಕ್ಳ ಮೇಲೆ ಆಣೆ ಮಾಡಿ ಹೇಳು. ನಮ್ಮ ಅಪ್ಪ ಅಮ್ಮ ನೀನ್ ನಾಚಿಕೆ ಹೇಳ್ತೀರ ಮಾತಾಡ್ಬೇಡ ನೀವು.
ಆಯ್ತು ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ ಕೇಸ್ ಹೇಳಿ. ಆಯ್ತು ಕೂತ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. ಹೇಳಿ.
2 item properties.
Yes, please.
2 item properties. In so far as one item, that is item 20, there is a will executed, mutual will. So far as item 1 is concerned, it's purchased jointly by the parents.
Allot item number 1.
Item 1 is the sale deed purchased jointly by both father and mother. The sale deed is produced before.
ಯಾರ ಹೆಸರಲ್ಲಿ ಇದೆ ಸೇಲ್ ಇಡೋದು?
Sale deed both Lingana and Lingappa. Exhibit P4. Exhibit P4.
Yes.
P4 in both the names as on 24/1/2003. But this is not in dispute because item 1 property is to be divided amongst all. There is no controversy. Insofar as item 2 is concerned, there is a will executed by the parents. Can we see exhibit D1?
Exhibit D1, na?
D1. Exhibit D1 at page 186.
Kodri.
Both parents have executed.
186.
186. It's executed by both the parents. I may permit to read the will. We have 2 sons, 3 daughters as detailed below. First son, Shiv Shankar, aged 49 years, unmarried, 2 years. Second son, Yashwant Kumar, 42 years, married. He is living with 2 children, his wife with us. Both my sons are residing now in our house, 117 first 5th May, KH quarters, Pilsen Garden, Bangalore. The details of our 3 daughters are noted below. Srimati Manjula, aged 45 years, married to K. Shankaraj. During 1978, he expired. During January 2001, she is living separately with her 2 sons. Srimati Uma Devi, 44 years, was married during 86 to Shri Nagendra. She is living separately with the 2 sons. Srimati Shashikala, aged 37 years, is also married. Doing SPOM.
SPOM andre?
Typographical mistake. Shri Venkatesh, and are living separately with 1 son and 1 daughter. All the 3 daughters are married and are well settled with their husbands and sons. Daughters are living with their husband, leading happy lives separately with us, from us. Their marriages have been done by us in a befitting manner as per our social systems, meeting all expenditures, jewel, clothes, utensils, marriage expenses. We have now the following property in our possession is noted as Schedule A. This is self-earned own property and purchased by the sale deed dated so and so, and not from our ancestors. Because of the increasing age by day to age by day to both of us, we are afraid of our deterioration of our health. As now we have sound disposing state of mind and affairs, we desire to bequeath the above scheduled property mentioned in Schedule A only to our two sons mentioned above in the above property in our self-earned property. Now this declaration really is because with a view to avoid disputes of fiction among the two brothers in respect of the above scheduled property after their demise. So we think it proper now to expedite to make following arrangement with regard to our property by the Schedule A. Therefore, I do hereby bequeath that after my death and after the death of my wife, the ownership of the above scheduled property shall be transferred to our two sons, only as stated below. Will reads, as long as we are executants are alive, scheduled property A mentioned in this deed shall be with exclusive ownership of the executants, and we shall enjoy all interest and rights relating thereto, including all the rights relating to its transfer by hypothecation. No other person shall have any sort of right to oppose or raise dispute or to cause interference in the matter of our scheduled property. The bequeathed scheduled property is as follows. Schedule A, first floor and second floor full A schedule built up area shall exclusively to L by Yeshwanth second son. Ground floor full with its built up area also of the A schedule shall exclusively to Shiv Shankar my first son. The staircase shall be commonly used by both belonging to them. Both our sons shall have every right to enjoy or sale, hypothecation or alienate that part and parcel of the property A schedule and B schedule as per our will declared place. Either of us shall have a right to claim ownership on the other on any other properties as against this will. They shall have the rights so on. But this was the will that came to be executed pertaining to item 2 property. The learned judge with the trial court gives a reasoning on the basis of the will. He accepts the execution of the will. He does not dispute the will. He also says that the will is appropriately proved and that is not challenged by the other side. The learned judge only comes to the conclusion that Srimati Lingama had no right over the property. A mutual will could not have been executed. That's the only ground that was raised by the learned judge in his belief.
Yes.
And that was the only contention that was raised. Thereafter, my lord, there's a gift deed that came to be executed. Of course, my lord, the gift deed may not have its effect because
Gifted in respect of the other property.
no, only in respect to this property.
Ah.
By the mother. And mother did not plead. The court comes to conclusion that in the pleadings there is a variation. Mother, when filing written statement, she did not disclose the will. Thereafter, after the death of the mother, the will is produced by an additional written statement. These are the contentions on which the court comes to the conclusion that item 2 property is also allowed.
See, that is a suspicious circumstance.
No, even that also he does not come to. Even
Let us see the evidence of the attesting witness.
Suspicious circumstances also is not one.
No, that is one circumstance. The will was not, no.
That finding that is given by the court. Court gives a finding that.
Now let us see what the evidence of DW1 is.
Just read it, that which is unchallenged. Kindly take page 67. That's his reasoning. Because this reasoning is not challenged by the others. Page 67, paragraph 28. In this case, defendant 2 and 3 have produced the original will D1. D1 will deed bears the signature of Lingana. Further, it is also duly attested by two attesting witnesses. Further, 2 attesting witnesses to the will deed are also examined by defendant 2 and 3. As such, first ingredients as stated in the aforesaid decision are fulfilled by defendants 2 and 3. Further, will deed is also executed in accordance with section 68 of the Indian Evidence Act. As such, 5th ingredient is also fulfilled. The plaintiff have not disputed the mental capacity or health of the deceased K. Linganna at the time of execution of D1, alleged will D. As such, there is no necessity of considered the aspect whether testator was in a sound state of mind at the time of executing the will, deed or not. Now let us examine the material on record in order to adjudicate whether there are any suspicious circumstances existing surrounding the execution of the will, D1 will deed or not. D1 alleged will deed dated 25/1/2006. The said will deed jointly executed by Linganna and Lingappa. As it is discussed earlier, Linganna was the absolute owner of the suit scheduled item 2 property. As such, Lingamma had no right to execute the will deed with respect to item 2 property during the lifetime of her husband. Execution of the alleged will deed by Lingamma jointly along with Linganna is not permissible under law. But that may not be correct because it was mutual. Husband and wife both were living together. A mutual will between the husband and wife, the finding may not be correct. The learned judge in a mutual will between the husband and wife, their understanding to live, because the will I read to my lords. The will says that till my wife lives, so her right was safeguarded insofar as the house is concerned, so that the children need not dispossess her or throw her.
ಮುಂದೆ ಓದಿ.
Yes, ma'am, that's it. It is to be noted here that in the additional written statement of defendant 2 and 3, which was filed on 5/10/2015, it is pleaded in para 3 page 2 that Linganna executed will deed on 25/1/2006, bequeathing item 2 property in favor of defendant 1. Thereafter, Lingamma has executed gift deed in favor of defendants 2 and 3. The said averments in the written statement is contrary recitals of D1 will deed. With D1 will deed is not executed by Linganna in favor of Lingamma. Further, nowhere in the written statement of defendant 2 and 3, it is specifically pleaded that Linganna and Lingamma have jointly executed the will in favor of defendants 2 and 3. Defendant 1, Lingamma, has also jointly executed will deed along with Linganna. She has also signed the will deed. As such, Lingamma might have got knowledge about execution of D1 will in the year 2006 itself. Admittedly, Linganna died on 25/1/2011. Present suit filed after the death of Linganna. Defendants 1 to 3 have filed the written statement on 8/9/2011, but nowhere in the written statement defendants have stated anything about the execution of the will by Linganna in respect of the suit schedule item 2 property. Even though Lingamma was aware about the execution of the alleged will, deed K. Linganna and herself in favor of defendant 2 and 3, she has again executed gift deed on 5/3/2012 in favor of defendant 2. When the will deed was already executed by herself, K. Linganna, as per D1, what was the necessity for her to execute the gift deed in favor of defendants 2 and 3 is not properly explained. P6 gift deed, there is no mention about the execution of the will deed jointly by herself and Linganna earlier in favor. This is the reasoning that was there. This is the only question that arises for
So ಎಲ್ಲಿದೆ ಇದು ತಾಯಿಗೆ ಬದುಕಿರೋವರೆಗೂ she is entitled to stay in the house ಅಂತ ಎಲ್ಲಿದೆ?
will.
ಎಲ್ಲಿ ತೋರ್ಸು.
There is.
As long as we the executants are alive.
Page 186. Because of our age, page 188. Because of increasing age by day to both of us, we are afraid of our deterioration of our health in future. And as now we have sound disposing state of mind and affairs, we desire to bequeath the above property mentioned in A Schedule A to our 2 sons mentioned above. Now the declaration of this will, because with a view to avoid disputes of fiction, the 2 brothers in respect of the above property after our divorce. So we think it proper to expedite and following arrangements with regard to such. Therefore, I hereby declare that after my death and after the death of my wife, the ownership of the above property shall be transferred to 2 sons only as stated. So therefore, after the death of my wife is what is this. So the wife lived, suit was filed against her also. But there could not be anything that could be said because mother was to live in the house. And after her death, property vested. The execution of the gift deeds, but there is no recital that the court says that will should have been mentioned in the gift deed. the wisdom of the draftsman, how he could have written it. But therefore, this property is bequeathed insofar as the appellants are concerned by virtue of the will deed executed. But there is nothing wrong. A mutual will can be executed by husband and wife. But the Supreme Court has also said mutual wills are permissible by husband and wife. There may not be ownership insofar as the mother is concerned, but they live together. The word used is plural, both the persons live together. Therefore, nothing could have been doubted insofar as the will is concerned, insofar as item 2 property is concerned. If it is bequeathed, they will keep the property. Item 1 property, they can share along with the other sisters. It's the only case.
Yes.
Lords, admittedly, the property belonging to Linganna. And Lingamma, there was no necessity for Lingamma to join the will. And this will.
There is no necessity
for Lingamma to join the will.
Ah.
And secondly, whatever it is, it should have been stated in the written statement. And as additional written statement, they have introduced this will. This shows that this will is subsequently prepared by them for the purposes of denying the share to the daughters. That is the reason why the court has disbelieved the will. The existence of will has come under suspicious circumstance. That is the reason why the will is disbelieved. As regards the other property, there is no dispute regarding that. Whether the will is genuine or not.
Yes.
The will is not genuine because nothing is stated in the written statement. That is the observation made by the trial court also in the judgment.
So let us see the written statement.
Yes, written statement.
First written statement is on page 14.
It is only in paragraph 7A, by way of amendment, they have brought this. At paragraph 7A, the plaintiffs are married daughters.
Please read paragraph 4.
Yes. The scheduled property is the vacant site, and after the purchase of no further investment is made by the parties for putting up any construction. However, the scheduled property is fenced with compound wall. The father of the parties died on 25/1/2011, and after the death of the after his death, the revenue records have been transferred to transfer into the individual name of defendant number 1 with the consent of other daughters who has been paying the property tax. However, the defendant number 1 having 50% right on the scheduled property in her individual capacity on her right, in addition to her entitlement for another 50% in remaining area of the husband, if the same is considered as individual property of her husband in accordance with section 8A and rule 10 of so and so Succession Act. There is nothing about the execution of the will.
Will ಬಗ್ಗೆ ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರಲೇ ಇಲ್ಲ.
ಇಲ್ಲ. ಏನು
ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ correct. So far as item number 2 is concerned, in the first written statement that was filed on 8/9/2011,
nothing.
There is nothing.
There was nothing.
Amendment was brought because mother was alive.
First written statement and the amendment was brought under first written statement you did not mention.
Mother was alive and therefore she had joined in filing the return statement. After her death, the amendment was brought.
Yes.
Even if it is,
So by
if
that
it-
time, Lingana was dead.
Lingana was.
So therefore, why you did not mention about the will executed?
This amendment is long after.
Hmm.
And for the first time, it was introduced in. That is the reason why the trial court has disbelieved
7A
it.
was brought.
Yes.
Gifted is registered or not?
No, not registered.
It's not
Gift
registered.
deed is registered.
Is registered.
That is registered. As exhibit, it is marked P6.
Exhibit P6.
Hmm. ಅದ್ರಲ್ಲಿ at least ಇದೆಯಾ ರೆಫರೆನ್ಸ್ ಇದೆಯಾ?
Reference illa. Will.
Reference illa. That is the observation of the trial court also.
There's no
In the-
reference. with
There is no
regard to the-
reference.
The exhibit D1 is not registered.
No,
Even is not.
not registered.
Hmm. Do they admit the signatures of Lingana on the exhibit D1? Do the plaintiffs admit?
There's
No.
no dispute at all.
No, let us see let us see the cross examination PW1. Shashikala.
PW1 plus examination. Cross examination. ಅಲ್ಲಿ ಇನ್ನೊಂದು ಇಲ್ಲಲ್ಲಿ
160.
ಒಂದೇ ಡೇಟ್ ಅಲ್ಲಿ ಎರಡು ವಿಲ್ ಇದೆ.
ಹ್ಮ್
ಒಂದೇ ಡೇಟ್ ಅಲ್ಲಿ ಎರಡು ವಿಲ್ಲು.
ಎರಡು will?
ಎರಡು ಅನ್ರಿಜಿಸ್ಟರ್ಡ್.
25th
ಅಲ್ಲ ಮಾರ್ಕ್ ಆಗಿರೋದಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿಲ್ದಿರೋದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ.
ಮಾರ್ಕ್ ಅಂದ್ರೆ ಸ್ವಾಮಿ ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ 25/1/2006 ಇಸ್ವಿನಲ್ಲಿ ಒಂದು ವಿಲ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಒಂದು ಐಎ ಹಾಕೊಂಡಿದ್ದಾರೆ 15th 2015 ಅಲ್ಲಿ. ಅದು ತಾಯಿಗೆ ತಂದೆ ವಿಲ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಆದ್ರೆ ವಿಲ್ ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ 2021 ಅಲ್ಲಿ ತಂದೆ ತಾಯಿ ಇಬ್ರು ಸೇರಿ ಅದೇ ಡೇಟು 25/1/2006 ಅದರಲ್ಲಿ ವಿಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ 2021 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಹ್ಮ್
ಅದೇ ಸೇಮ್ ಡೇಟ್.
ಯಾರು ಹಾಕಿದ್ದಾರೆ? ಪ್ಲೇಂಟಿಫ್ ಹಾಕಿದಾರ? ಇದು ಡಿಫೆಂಡೆಂಟ್ ಹಾಕಿದಾರ?
ಡಿಪೆಂಡೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
Yes, is that a fact? You refer to some will in some applications.
ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
ಅದ್ರೊಳಗೆ ನೋಡಿ.
ಇದರಲ್ಲಿದೆ.
There is no such document.
ನೋಡಿ ಸರ್. Execution.
Yeah, item number 2 was subsequently introduced.
Item
ಹೌದು.
number 2
2
was subsequently introduced.
subsequently introduced.
No, no, no. It was that.
ಮತ್ತೆ ಇದನ್ನ ಹೇಳ್ತೀರಾ, ಆದ್ದರಿಂದ ದಾವಾ ಹಾಕುವ ಸಮಯದಲ್ಲಿ ನಾನು ದಾವಾ ಐಟಮ್ 2 ಆಸ್ತಿಯನ್ನು ಈ ದಾವೆಯಲ್ಲಿ ಸೇರಿಸಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ?
ನಾನು ಬರೀ 3 ಶೀಟ್ ಕೊಡ್ತಾರೆ.
ಹ?
ದಾನ ಪತ್ರ ಬರೆಯುವಾಗ ಅದು ಮಿಸ್ಟೇಕ್.
No. ದಾನ ಪತ್ರ ಮಾಡಿದ ಸಂಗತಿ ಇದು PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಓದ್ತಾ ಇದ್ದೀನಿ. ಹಾಗೂ ಮೃತ್ಯು ಪತ್ರ ಮಾಡಿದ ಸಂಗತಿ ನನಗೆ ಈ ದಾವಾ ಹಾಕುವ ಸಮಯದಲ್ಲಿ ಪೂರ್ತಿಯಾಗಿ ತಿಳಿದಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆದ್ದರಿಂದ ದಾವಾ ಹಾಕುವ ಸಮಯದಲ್ಲಿ ನಾನು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ನಂಬರ್ 2 ಆಸ್ತಿಯನ್ನು ಈ ದಾವೆಯಲ್ಲಿ ಸೇರಿಸಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
ಸರಿ ಅಲ್ಲ, ಸೇರಿಸಿದ್ರು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಆದ್ದರಿಂದ ದಾವಾ ಹಾಕುವ ಸಮಯದಲ್ಲಿ ನಾನು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ 2 ಆಸ್ತಿಯನ್ನು ಈ ದಾವೆಯಲ್ಲಿ ಸೇರಿಸಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದಟ್ ಇಸ್ ಯುವರ್ ಸಜೆಷನ್.
Yes.
So is it introduced later?
No. It was not.
Both the schedules were incorporated in the first instance during the lifetime of the mother.
ನೀವು ಕನ್ಫ್ರಂಟ್ ಮಾಡಿಲ್ಲ ಎಕ್ಸಿಬಿಟ್ D1 ನ
ಕನ್ಫ್ರಂಟ್ ಮಾಡಿ.
ನಾಟ್ ಇವನ್ ಕನ್ಫ್ರಂಟೆಡ್. ಈ ತರ ವಿಲ್ ಮಾಡಿದ್ರು ಅಂತ ಅವ್ರಿಗೆ ಹೇಳೇ ಇಲ್ಲ. ಸಿಗ್ನೇಚರ್ ನೀವು ನಮ್ಮ ಅಪ್ಪಂದು ಅಂತ ನೀವು ಕೇಳಿಲ್ಲ.
That was because amendment was brought. Thereafter issues were there. PW1 was not recalled.
ಕರೆಕ್ಟ್ ಸರ್, ಬಟ್ ನೀವು ಕೇಳ್ಬೇಕಲ್ವಾ? ವಿಲ್
Additional issues ಮಾಡಿದ್ದು, it was later, thereafter it was.
Did anybody prevent you from asking?
There was no prevention.
Huh.
The only thing is mother was alive. Thereafter these two persons came on record. 7A was introduced in the written statement on production of the.
ಆಯ್ತು, 7A ಮಾಡಿದ್ಮೇಲೆ ಅಡಿಷನಲ್ ಇಶ್ಯೂ ಆಗ್ಲಿಲ್ವಾ?
Additional issues ಮಾಡಿದ್ರು ಮತ್ತೆ recall ಮಾಡಿದ್ರು.
ಆಯ್ತು, ನೀವ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ವಾ? You should have, correct, you should have, it is, you have to prove.
Of course, that could have been done.
You're supposed to, ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ವಾ ವಿಲ್ನ? ಮತ್ ಅವ್ರಿಗೆ ತೋರಿಸ್ಬೇಕಲ್ಲ, ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸ್ಬಿಟ್ಟು ಈ ತರ ನಮ್ಮ ಅಪ್ಪ.
Ought to have been done. If I was there, I would have done it. I was not involved. It's only in the appeal stage that I could probably.
Yes, let us see what the attesting witnesses say.
Attesting witness evidence. And our DW2 attesting witness.
Gift deed register ಆಗಿದೆ ಅಲ್ಲ?
Gift deed is registered. The attesting witness stated Linganna had brought the typewritten will duly stamped and containing 4 pages, requested me to read the contents, explain the same to him. Accordingly, after reading the contents, understanding the same, I explained the details, writing to the Lingamma and to his wife, Lingamma in Kannada language, which was also, this was not in dispute at all, insofar as it's concerned.
Yes, please read this evidence of DW1. Mr. Muralidhar.
Yes, ma'am.
ಓದಿ. ನನಗೆ ಲಿಂಗಣ್ಣ ಆತ್ಮೀಯರಾಗಿದ್ದು ಅವ್ರ ಮಕ್ಕಳು ಸಹ ನೋಯ್ತೀನಿ.
Yes. I've been presently working as senior engineer, engineering department, BMTC, Shantinagar, Bangalore 27 since 2014. I put in 35 years of meritorious service in BMTC. I'm working in the remaining office, training office of BMTC Industrial Training Center. Second para. During the second week of January 2006, Mr. Linganna approached me and met me in the office and informed me that he will be executing a will jointly along with his wife Lingamma, bequeathing his residential property to his both sons. That on 24/1/2006, Linganna has represented me to meet him in his residence during the lunch hours the next day, along with Mr. T.D. Purushottam, Junior Training Officer, Industrial Training Center, BMTC. Accordingly, both myself and Sri So-and-so went to the residence of Sri Linganna and Sri Lingamma about 12:30 noon and met both of them. Then both Linganna and Lingamma informed us that they have prepared a will making the bequest in favor of their sons, Sri so-and-so in respect of residential house wherein both of them were living along with their sons. Both of them informed us that the ground floor portion will be given to their first son and L. Shivkumar after the lifetime, and similarly the first floor and second floor portion will be given to their second sons and so on. So Linganna brought typewritten will duly typed in stamp paper containing 4 pages and requested me to read the contents and explain the same to him. Accordingly, after reading the contents and understanding, I had explained so writing of Lingamma and his wife, in which their mother tongue after the seal with training correctness of the same. Both Mr. Lingamma and Linganna had signed the will in our presence simultaneously on 4 pages. Thereafter, both of them requested us to sign the will as the attestors of the same. Accordingly, I had signed as the first witness and I had so and so. I state that after we had signed the will as the attesting witnesses, Mr. Lingamma and his wife Srimati so-and-so had represented has requested to keep the said will in my custody and to hand over the same to their son after the lifetime of both of them. Accordingly, I had kept the will at my residence along with so-and-so somewhere both in 2021 while searching my other records. I had updated so-and-so. This is the evidence of the attesting witness, DW1.
Do you have a photocopy of the will?
Yes, my lords.
Photocopy ಇದೆಯಾ?
ಇದೆ. D1.
Yes. Yes, please.
My respectful submission is there is a difference in the contents of the will and what is stated in the written statement by them. It is only by way of amendment. They have introduced this will with an intention to deny the share. This is the reason why the learned trial judge has decreed the suit. The intentions of the appellant was bad. It is only to deny the share of legitimate share of the daughters.
Yes.
At paragraph
Exhibit
20
ಇದು gift deed is registered ಅಲ್ಲ?
Yes, gift deed is registered. Gift deed is registered. At paragraph 29 of the judgment, the learned judge has discussed about the will. D1 is a signed will dated so and so. The said will is jointly executed by Lingamma and Linganna with my learned friend read already.
ನೋಡಿ ಇನ್ನೊಂದು I don't know whether you
There is not even a mention in the
ಮುರಳೀಧರ್
gift
ಅವರೇ,
deed. Yes.
ಇವಾಗ ದಿಸ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಏನಾದ್ರು ಒಪ್ಕೊಂಡ್ರೆ ತಾಯಿಗೊಂದು ಶೇರ್ ಇದೆಯಲ್ಲ, ತಾಯಿಗೊಂದು ಶೇರ್ ಏನ್ ಮಾಡ್ತೀರಿ? There is a gift deed.
Yes, there is
ತಾಯಿ ಶೇರ್ ಬೇರೆ ಇದೆ.
There is a gift deed between Shiva Shankar
No, after the Linganna died intestate, assuming Linganna died intestate.
Yes.
ಇವ್ರು ಬೇರೆ ಇದೆಯಲ್ಲ, ಲಿಂಗಮ್ಮನಿಗೆ ಒಂದು ಬೇರೆ ಭಾಗ ಇದೆಯಲ್ಲ, ಅದು ಗಿಫ್ಟ್ ಬಂದಿದೆಯಲ್ಲ.
ಒಂದು ಶೇರ್. ಲಿಂಗಮ್ ಶೇರ್ ಮಾತ್ರ ಗಿಫ್ಟ್ ಬಂದಿದೆ.
ಅಲ್ಲಿಗೆ 3 ಶೇರ್ ಅಲ್ಲೇ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಮನೆಗಾಯ್ತು.
My lords are trying to say it should have been 1/6 share ಅಂತನ.
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ 1/6 ಆಗುತ್ತೆ.
One property ಗೆ 1/6 ಆಗುತ್ತೆ.
She was a joint holder
Yes.
insofar as item 1 is concerned.
ಯಾವುದು?
Co-owners, both husband.
ಐಟಮ್ ನಂಬರ್ 1.
ಐಟಮ್ ನಂಬರ್
ಐಟಮ್ ನಂಬರ್ 1 ಅದ್ರ ವಿಲ್ ಬರ್ದಿಲ್ವಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ವಿಲ್ ಇಲ್ವಲ್ಲ.
She died
ಅದ್ರ
during
ಬಗ್ಗೆ
the pendency of the suit.
Correct, but she has not bequeathed the item.
there's no big way.
So 1/6 ಆಗತ್ತಿದು. If it is 1/6 then half property in item number 2 will go to the plaintiff defendants, 2 and 3, half property. So ಅದ್ರಲ್ಲಿ half ಇದ್ರಲ್ಲಿ half ಕೊಡ್ಬೇಕು.
ಅಂದ್ರೆ ಮದರ್ ಶೇರ್ ಹೋದ್ರೆ
ಅದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ ವ್ಯಾಲ್ಯೂ ಇದೆಯಲ್ಲ, ಅದ್ರಲ್ಲಿ half ಇದ್ರಲ್ಲಿ half ಕೊಡ್ಬೇಕಾಗತ್ತೆ. Mother's share will go to these people because of the gift.
Mother share is only in respect of Wilson Garden property, not in the other property.
Correct. 6 shares ಆಗುತ್ತಲ್ವ ಸರ್?
6 share
6 shares 3 share ಇವ್ರಿಗೆ ಬರ್ತು.
3 share
ಸೊ
ಇವ್ರಿಗೆ
ಅರ್ಧ ಬಂತು ಅವ್ರಿಗೆ. ಸೊ ಇನ್ ಮಿಕ್ಕಿದ ಅರ್ಧ ನಿಮ್ಗೆ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ.
Yes.
ಅಲ್ಲಿ ಎರಡು ಭಾಗ ಇದೆ ಅಲ್ಲಿ. 2 ಭಾಗ ಅಲ್ಲಿದೆ.
ಅಲ್ಲಿ
3 ಭಾಗ ಇಲ್ಲಿದೆ.
ಅಲ್ಲಿದ್ರೊಳಗೆ ಏನು ಗಿಫ್ಟ್ ಇಲ್ವಲ್ಲ? ಗಿಫ್ಟ್ ಎಂತದ ಇಲ್ಲ. ವಿಲ್
ಅದಕ್ಕೆ ಗಿಫ್ಟ್ ಇಲ್ಲ.
ವಿಲ್
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲಿ 2 ಭಾಗ ಇದೆ, ಇಲ್ಲಿ ಅರ್ಧ ಭಾಗ ಇದೆ. ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಅರ್ಧ ಭಾಗ, ಅಲ್ಲಿ 3ನೇ 1 ಭಾಗ.
ಅಲ್ಲಿ 3ನೇ 1 ಭಾಗ.
ತಗೊಳ್ಳಿ, 1 ಫ್ಲೋರ್ ಹೋಗುತ್ತೆ ನಿಮ್ಗೆ. 1 ಫ್ಲೋರ್ ಯಾರು ತಗೋತಾರೆ?
ಅದೇ ಸಮಸ್ಯೆ ಬಂದಿರೋದೀಗ.
1 ಫ್ಲೋರ್ ಯಾರು ತಗೋತಾರೆ ಹೇಳಿ?
ಅದನ್ನ ಆತರ ತಗೊಳ್ಳಿಕ್ ಆಗಲ್ಲ.
So therefore ಈ ಇಶ್ಯೂ ಆದ್ರೆ ಇನ್ನೊಂದು 10 ವರ್ಷನೇ ನಡೀಬಹುದು. You want to the litigation to linger on, you can do it. You can do it.
ಯಾವ ರೀತಿ ಮಾಡಿದ್ರು ಇವ್ರೇನಾದ್ರು ಒಂದ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ it should be sold and profit should be.
ಅಲ್ಲ, ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ house cannot be sold because they are living there.
They are living there.
They are entitled for 1/3 share.
Yes. They are living there. Let them continue to live there. We are not disturbing them.
The moral story ಬೇಡ, ಈ ಸಾರ್ಟ್ ಮಾಡೋದು ಹೆಂಗೆ ಅಂತ ಹೇಳಿ. ಸಾರ್ಟ್ ಔಟ್ ಮಾಡೋದು ಹೆಂಗೆ? ಒಂದು ವೇಳೆ if I uphold the will, please see this, if I uphold the will, full property ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ. ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಫುಲ್ ಪ್ರಾಪರ್ಟಿ ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ. ಅಲ್ಲಿ 5 ಭಾಗ ಆಗುತ್ತೆ.
ಅಲ್ಲ 5 ಭಾಗ ಆಗುತ್ತೆ.
ಅಲ್ಲ 5 ಭಾಗ ಆಗುತ್ತೆ. ಸೊ ಸಿ ದಿ ifs and buts.
Yes, if will is upheld, we don't get anything here.
ನೀವೇನ್ ಡಿಸ್ಪ್ಯೂಟೇ ಮಾಡಿಲ್ಲ. DW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಡಿಸ್ಕ್ರೆಡಿಟೆಡ್ ಈಸ್ ಎವಿಡೆನ್ಸ್. ಅವ್ರು ಹೇಳ್ತಾರೆ, ನಾವು ಲಿಂಗಣ್ಣವರು 1992ನೇ ಇಸ್ವಿಯಿಂದ ಪರಿಚಯ, ಅವಾಗ ಹೋಗ್ತಾ ಇದ್ದೆ, ಲಿಂಗಣ್ಣವರು ಮತ್ತೆ ಲಿಂಗಮ್ಮ ತೀರೋದಾಗಲೂ ನಾನು ಹೋಗಿದ್ದೆ ಅಂತೆಲ್ಲ ಹೇಳ್ತಾರೆ. ಯು ಡೋಂಟ್ ಸೇ, ಯು ಡೋಂಟ್ ಇವನ್ ಪುಟ್ ಎ ಸಜೆಷನ್. ನೀವ್ ಯಾರು ಅಂತಾನೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಮ್ಮ ಮನೆಗೆ ನೀವು ಬಂದೇ ಇಲ್ಲ, ಡೋಂಟ್ ಇವನ್ ನೋ ಯು ಅಂತಾನು ಒಂದು ಮಾತು ಹೇಳೋದು. ಯು ಡೋಂಟ್ ಇವನ್ ಪುಟ್ ಎ ಸಜೆಷನ್.
The trial court proceeded on the ground that there is no mention about the will in the written statement and also in the gift deed. There is not even a mention. Therefore, the court has reached the conclusion that it is not a genuine.
No, but he says I came to know about the will in 2021 hand over ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವರು
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೆ.
It was in the custody of DW1 and
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೆ ಯಾವಾಗ?
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದು 2021 ನಂತರ 21
ಎಷ್ಟನೇ
ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದು.
ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
23/11/2015.
2021
Additional return statements. 21.
ಸರ್ ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದು ಯಾವಾಗ ಸರ್?
ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದು ಬೇಗ ಹಾಕಿದ್ದಾರೆ.
ಇದು ಪ್ಲೈಂಟ್ ಆಯ್ತು.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಡಿಷನಲ್ ಫಸ್ಟ್ ರಿಟರ್ನ್ ಇಲ್ಲ 2015-14 ನಲ್ಲೇ ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
2015
ಕೊಡಿ.
8/9/2011 ಅಲ್ಲಿ ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿರೋದು. 8/9 DW1 ಯಾವಾಗ ಹೇಳ್ತಾರೆ ನೋಡಿ ವಿಲ್ ಬಗ್ಗೆ, ವಿಲ್ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಯಾವಾಗ ಹೇಳ್ತಾರೆ?
ವಿಲ್ ಬಗ್ಗೆ ಹೇಳೋದು ಬರೀ ಓನ್ಲಿ ಇನ್ 2021. ವಿಲ್ ಬಗ್ಗೆ ಹೇಳೋದು ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಇನ್ 2021 ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್.
ನೋ. ಈ ಸೇಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಓದಿ ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ? ನನ್ನ ಮನೆಯಲ್ಲಿ ನನಗೆ ಸಂಬಂಧಪಟ್ಟ ಖಾಸಗಿ ದಾಖಲೆಗಳನ್ನು ಹುಡುಕುತ್ತಿದ್ದಾಗ ವಿಲ್ ಪತ್ರ ಸಿಕ್ಕಿತು. ಲಿಂಗಣ್ಣನ ಮರಣಾನಂತರ ಅವರ ಮಕ್ಕಳ ಜೊತೆ ನಾನು ಅನ್ಯೋನ್ಯವಾಗಿದ್ದೇನೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಕುಟುಂಬದ ಸ್ನೇಹಿತರು ಮಾತ್ರ ಆಗಿರುತ್ತಾರೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಲಿಂಗಣ್ಣನವರೇ DW2 ಪುರುಷೋತ್ತಮರವರಿಗೆ ತನ್ನ ಮನೆಗೆ ಬರುವಂತೆ ತಿಳಿಸಿದ್ದ. ನಾನು ಹೋದಾಗಲೇ ಪುರುಷೋತ್ತಮ್ ಸಹ ಲಿಂಗಣ್ಣವರ ಮನೆಗೆ ಬಂದಿದ್ದ. ನಾನು ವಿಷಯ ಸಮಯದ ಬಗ್ಗೆ ಮುಂಚೆ ನನ್ನ ಯಾವತ್ತೂ ಮಾತಾಡಿಲ್ಲ. ಸಹಿ ಮಾಡಿದೆವು. ಸರಿ. ನೋಡಿ
ನನ್ನ ಮನೆಯಲ್ಲಿ ನನಗೆ ಸಂಬಂಧಿಸಿದ ಖಾಸಗಿ ದಾಖಲೆಗಳನ್ನು ಹುಡುಕುತ್ತಿದ್ದಾಗ
ಪ್ಯಾರಾ 6 ಬನ್ನಿ. ಜುಲೈ 2021ರಲ್ಲಿ ನಾನು ಮೊದಲ ಬಾರಿಗೆ ಲಿಂಗಣ್ಣ ಮತ್ತು ಲಿಂಗಮ್ಮ ವಿಲ್ ಬರೆದುಕೊಟ್ಟ ಬಗ್ಗೆ 2 ಮತ್ತು 3ನೇ ಪ್ರತಿವಾದಿಯರಿಗೆ ತಿಳಿಸಿದೆ.
ಲಿಂಗಣ್ಣ ಮತ್ತು ಲಿಂಗಮ್ಮ ಮರಣಾನಂತರ ಜುಲೈ 21ರವರೆಗೆ ವಿಲ್ ಬಗ್ಗೆ 2 ಮತ್ತು 3ನೇ ಪ್ರತಿವಾದಿಗೆ ತಿಳಿಸದೆ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮರೆತಿದ್ದೆ ಎಂದು ಹೇಳುತ್ತಾನೆ. ವಿಲ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಆಸ್ತಿಯನ್ನು ಯಾರು ಗಳಿಸಿದ್ದರು ಮತ್ತು ಹೇಗೆ ಗಳಿಸಿದ್ದರು ಎಂಬುದಕ್ಕೆ ನನಗೆ ಖುದ್ದಾಗಿ ಮಾಹಿತಿ ಇಲ್ಲ. ವಿಲ್ ಬರೆದುಕೊಡುವವರಿಗೆ ಆಸ್ತಿಯ ಬಗ್ಗೆ ಕಾನೂನುಬದ್ಧ ಹಕ್ಕು ಇತ್ತೋ ಇಲ್ಲವೋ ಎಂಬುದರ ಬಗ್ಗೆ ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ. ಲಿಂಗಣ್ಣನವರು ಮೃತ್ಯುಪತ್ರವನ್ನು ಟೈಪ್ ಮಾಡಿಸಿಕೊಂಡು ಬಂದಿದ್ದರು. ಅದನ್ನು ಅವರು ನನಗೆ ಓದಿ ಹೇಳಿದಾಗ ನಾನು ಅದನ್ನು ಓದಿ ಲಿಂಗಣ್ಣನವರಿಗೆ ತಿಳಿಸಿದ್ದೆ. ಲಿಂಗಮ್ಮನವರು ಆ ಸಮಯದಲ್ಲಿ ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರು.
ಎಂತ ಸಜೆಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲಿ. ಎಂತ ಸಜೆಷನ್. ಲಿಂಗಮ್ಮರವರು ಆ ಸಮಯದಲ್ಲಿ ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರು ಎಂದರೆ ನಿಜ. ಅಲ್ಲಿಗೆ ವಿಲ್ ನೀವೇ ಒಪ್ಕೊಂಡ್ಬಿಟ್ರಲ್ಲ.
ಅಲ್ಲ, ವಿಲ್ ಪತ್ರವನ್ನು ತಟಸ್ಥರಾಗಿದ್ದರು
ಆ ಸಮಯದಲ್ಲಿ. ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರು ಅಂದ್ರೆ ಸರಿ.
ಅವ್ರು ಹೇಳ್ದಾಗ ಕೇಳ್ತಾ ಇದ್ರು ಅಂತ ಅಷ್ಟೇನೆ.
ಅದ್ ಯಾಕೆ ಹೇಳ್ಬೇಕಾಯ್ತ ಸಜೆಷನ್?
ಕೆಲವರಿಗೆ ಒಂದು ಈ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಿನಗಟ್ಲೆ ಮಾಡೋದು ಅಡ್ವಾಂಟೇಜ್ ಅನ್ಕೋತಾರೆ. ದಟ್ ಈಸ್ ರಾಂಗ್.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನ್ ಕೇಳ್ಬೇಕು ಅನ್ನೋದಕ್ಕಿಂತ ಏನ್ ಕೇಳಬಾರ್ದು ಅನ್ನೋದು ಮನವರಿಕೆ ಇರ್ಬೇಕು ವಕೀಲರಿಗೆ.
ನೋಡಿ, ದಿನಾಂಕ 25/1/2001ರಂದು ಲಿಂಗಮ್ಮನವರ ಮನೆಗೆ ಹೋಗಿದ್ದೆ. ಆ ಸಮಯದಲ್ಲಿ ಮೊದಲ ಬಾರಿಗೆ ಲಿಂಗಣ್ಣ ಮೃತ್ಯುಪತ್ರ ಬರೆದಿರುವ ಸಂಗತಿ ಮಧ್ಯಾಹ್ನ 12:30ಕ್ಕೆ ಗೊತ್ತಾಯಿತು. ಲಿಂಗಣ್ಣ ನನಗೆ ಮೃತ್ಯುಪತ್ರವನ್ನು ನೀಡಿ ತನ್ನ ಮರಣಾನಂತರ ಅದನ್ನು ಮಕ್ಕಳಿಗೆ ಕೊಡುವಂತೆ ತಿಳಿಸಿದ್ದ. ಆ ಸಮಯದಲ್ಲಿ ಲಿಂಗಮ್ಮ ಅಂದ್ರೆ ಏನ್ ಇವ್ರು ಹೇಳೋದು 2006 ಇಂದ 2021ವರೆಗೂ ಏನು ಅವ್ರಿಗೆ ಯಾರಿಗೂ ಇನ್ಫಾರ್ಮೇ ಮಾಡಲಿಲ್ಲ ನಾನು. That is, they have created this will to their convenience since they sought amendment to the writ petition in 2021. They have prepared the witness in such a way.
ಬಟ್ ಅವ್ರಿಗೆ ವಿಲ್ ಗೊತ್ತಿಲ್ವಲ್ಲ, ವಿಲ್ ಕೊಟ್ಟಿದ್ದು
ಅದೇನೆ ಇದೆಲ್ಲ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಆಮೇಲಿಂದ ಇಟ್ ಇಸ್ ಆಲ್ ಆಫ್ಟರ್ ಥಾಟ್. 2011 ಸೂಟ್, 2021 ನಲ್ಲಿ ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಂಟ್ರೊಡಕ್ಷನ್ ಆಫ್ ದಿಸ್ ವಿಲ್ ಅಂಡ್ ಸಪೋರ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್. ವಾಟ್ ಹಿ ಸೇಸ್ 2006 ಇಂದ 2021 ವರೆಗೂ ನನಗೆ.
ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 122 ಪೇಪರ್ ಬುಕ್ 122. 2, 4, 6, 8, 12ನೇ ಲೈನ್ ಓದಿ. I used to visit
the house of Linganna frequently during the lifetime since our office and the residence was located in the same area and we are the family friends. I know their sons and daughters also.
ಇದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನಿದೆ? What is the cross
I
examination?
used to attend all his family functions.
What is the cross examination for this?
ಕೊಡಿ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
Same thing that was done in para 6.
ಅಶ್ವಥ್ ಗೌಡ. ಜುಲೈ 21ರಲ್ಲಿ ನಾನು ಮೊದಲ ಬಾರಿಗೆ ಲಿಂಗಣ್ಣ ಮತ್ತು ಲಿಂಗಮ್ಮ ವಿಲ್ ಮಾಡಿಕೊಟ್ಟ 2 ಮತ್ತು 3ನೇ.
ಅದೆಲ್ಲ ಸರ್ ಪ್ಯಾರಾ 5 ಓದಿ ಸರ್. ನನಗೆ ಲಿಂಗಣ್ಣ ಆತ್ಮೀಯರಾಗಿದ್ದು ಅವರ ಮಕ್ಕಳು ಸಹ ನನಗೆ ಚೆನ್ನಾಗಿ ಪರಿಚಯ ಇರುವುದರಿಂದ ಅವರ ಮನೆ ಎಲ್ಲಾ ಕಾರ್ಯಕ್ರಮಗಳಿಗೂ ಮತ್ತು ಅವರ ಮನೆ ಎಲ್ಲಾ ವ್ಯವಹಾರಗಳಲ್ಲೂ ಸಹ ನಾನು ಭಾಗಿಯಾಗುತ್ತಿದ್ದೆ. ಸಾಕ್ಷಿಯು ಲಿಂಗಣ್ಣ ತನಗೆ 1992ರಿಂದ ಪರಿಚಯ ಇರುತ್ತಾರೆ ಎಂದು ಹೇಳುತ್ತಾರೆ
ಎಂದು ತಿಳಿಸುತ್ತಾರೆ.
ಲಿಂಗಣ್ಣರವರು
2011ರಲ್ಲಿ ಮತ್ತು ಇಸ್ವಿ 12ರಲ್ಲಿ ಲಿಂಗಮ್ಮ ಮರಣ ಹೊಂದಿದ ಸಮಯದಲ್ಲಿ ನಾನು ಅವರ ಮನೆಗೆ ಹೋಗಿ ನೋಡಿಕೊಂಡು ಬಂದಿದ್ದೆ.
ಇಲ್ಲಿದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ನೀವು ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. ವೇರ್ ಇಸ್ ಎ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್?
ಅದ್ರ ಬಗ್ಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ.
ಯಾಕೆ ಬರಕ್ ಹೇಳ್ರಿ? ದುಡ್ಡು ಗಿಟ್ ಕೊಡಕ್ ರೆಡಿ ಇದೀರೇನ್ರಿ ಮಿಸ್ಟರ್? ದುಡ್ಡು ಕೊಡಕ್ ರೆಡಿ ಇದೀರಾ? ಏನು ಇಲ್ಲ, ಆಯ್ತು ಕೂತ್ಕೊಳ್ಳಿ. ಎಸ್ ವಿಲ್ ಬಗ್ಗೆ ಏನ್ ಇಲ್ವಲ್ಲ, ಡಿನೈಯೂ ಮಾಡಿಲ್ಲ. ಲಿಂಗಣ್ಣನ್ ಸಿಗ್ನೇಚರ್ ಡಿನೈ ಮಾಡಿಲ್ಲ.
ಲಿಂಗಣ್ಣನ್ ಸಿಗ್ನೇಚರ್ ಡಿನೈ ಮಾಡಿಲ್ಲ.
ಸೊ ಲಿಂಗಣ್ಣನ್ ಸಿಗ್ನೇಚರ್ ಡಿನೈ ಮಾಡಿಲ್ಲ. ಪುರುಷೋತ್ತಮ್ ಮತ್ತು ಇನ್ನೊಬ್ಬ ವಿಟ್ನೆಸ್ ಆತನಿಗೂ ಏನು ಕೇಳಿಲ್ಲ. ನೋಡಿ, ಲಿಂಗಣ್ಣ ವಾಸ್ ವರ್ಕಿಂಗ್ ವಿತ್ ಮೀ ಇನ್ ದ ಸೇಮ್ ಸೆಂಟರ್. DW2 ಹೇಳೋದು. Therefore, myself and Linganna had more acquaintance and cordiality. I used to visit the house of Linganna frequently and we were family friends. DW2 ಏನ್ ಕೇಳಿದ್ರು?
ಎರಡು ಒಂದೇ ತರ ಹೇಳಿದ್ದಾರೆ. DW2 ನಲ್ಲೂ
ಸೇಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಲಿಂಗಣ್ಣ ನಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟಿನಲ್ಲಿಯೇ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರಿಂದ ನನಗೆ ಪರಿಚಯ ಆಗಿದ್ದರು. ಲಿಂಗಣ್ಣ ನನಗೆ ಪರಿಚಯಸ್ಥರಿರುವುದರಿಂದ ಮತ್ತು DW1 ನನ್ನ ಮೇಲಾಧಿಕಾರಿಯಾಗಿದ್ದರಿಂದ ನಾನು ಮತ್ತು DW1 ಕೂಡಿ ಲಿಂಗಣ್ಣನ ಮನೆಗೆ ಹೋಗಿದ್ದೆವು.
ಮೃತ್ಯು ಪತ್ರವನ್ನು DW1 ಅವರು ಲಿಂಗಣ್ಣನವರಿಗೆ ಓದಿ ಹೇಳಿದರು. ಲಿಂಗಣ್ಣ ಅವರ ಬಗ್ಗೆ ತಿಳಿದುಕೊಂಡು ಸಹಿ ಮಾಡಿದರು. 25/1/26ರಂದು ಲಿಂಗಣ್ಣನ ಮನೆಗೆ ಮೃತ್ಯು ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡುವ ಸಲುವಾಗಿ ಮಾತ್ರ ಹೋಗಿದ್ದೆ, ಬೇರೆ ಉದ್ದೇಶವಾಗಿ ಹೋಗಿರಲಿಲ್ಲ.
ಈ ವಿಲ್ ನಿಮಗೆ ಲಿಂಗಣ್ಣ ಇವ್ರು ಕೊಟ್ರು, DW1 ಕೊಟ್ರು ಅಂತ ಹೇಳಿದ್ರ ನೀವು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ?
ಇವ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ಅದನ್ನ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ವಿಲ್ ಅಲ್ಲಿ ಇದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
7A ನಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ, ಪ್ಯಾರಾ 7A, ವೇರ್ ವಾಸ್ ದಿಸ್ ಹೈಡಿಂಗ್ ಟಿಲ್ 2021?
DW1 ಕೊಟ್ರು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
ಹೇಳಿಲ್ಲ.
This is what is para 5, page 141. I submit that second defendant had been running a printing press for last 25 years. I have been working as a TA operator at Bangalore for past 30 years. I have contributed our income source. And both our parents have executed a will on 25/1/2006, bequeathing item 2 property, schedule so and so, so and so. That particular aspect was not said.
ಮತ್ತೆ
Is
it not doubtful for anybody to hand over a will to the witness? Will is intended to be executed to ensure that the property goes to the children. Why would Lingana hand over the will to the witness?
One aspect, but the witnesses, they themselves have spoken, saying that it's in 2021.
Correct, but ಗಂಗಣ್ಣ ಲಿಂಗಣ್ಣ ತೀರೋಗಿದ್ದು 2011 ಇಸ್ವಿನಲ್ಲಿ. 11 ಇಸ್ವಿಲ್ ಆದ್ರೆ ವಿಲ್ ಅನ್ನ ಲಿಂಗಣ್ಣವರು ಎಂತದ್ದು
2000
RV ಗೌಡಂಗೆ ಯಾಕೆ ಕೊಡ್ತಾರೆ? Why did he leave the will with Gowda? Ashwath Gowda. ಅವ್ರ ಹತ್ರ ಯಾಕೆ ಬಿಡ್ತಾರೆ ವಿಲ್ ನ? He will leave it with the children. Ordinary circumstances, he will live with the children. Why did he give it to the DW1?
He propounded the will, that's all.
Yaru?
Not the defendants who propounded.
Correct, sir. But this is a suspicious circumstance ಅಂತ ಹೇಳ್ತಿರೋದು. This is a suspicious circumstance. DW2 ನಿಮಗೆ ನನಗೆ ವಿಲ್ ಕೊಟ್ರು ಅಂತ ನೀವು ಹೇಳಿಲ್ಲ. DW1 ಹೇಳ್ತಾರೆ ನನಗೆ 10 ವರ್ಷದ ನಂತರ ನಾನು ಯಾವ್ದೋ ಪೇಪರ್ ಹುಡುಕುವಾಗ ಸಿಕ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ವಿಚ್ ಮೀನ್ಸ್ ವಿಲ್ ವಾಸ್ ವಿತ್ DW1. DW1 ಯಾಕೆ ವಿಲ್ ಕೊಡ್ತಾರೆ ಲಿಂಗಣ್ಣ? These are
Plain not they have in the written statement. He has only said in para 7 to that extent, that's all.
Therefore, I think what the trial court is done is right. Ashtena?
Gift deed.
You will get that share. 1/3. Barcode. Gifted prove ಮಾಡಿದಿರಾ?
Gifted.
Well, gifted also, it's a compulsory attestable document.
But it's a registered document.
And it's a compulsory attestable document. It has to be proved. ಆಯ್ತು, ಡಿಫೆಂಡೆಂಟ್ ಅವರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ D1, no?
D1 has stated.
In the written statement she has stated.
D1 has not stated.
D1, but this gift deed was.
ಅಲ್ಲ, ಫಸ್ಟ್ ಫೈಲ್ ಮಾಡಿದ ಲಿಂಗಮ್ಮ ತಾನೆ. ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ ಲಿಂಗಮ್ಮ ಹಾಕಿದಾರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಗಿಫ್ಟ್ ಡೀಡ್ ಬಗ್ಗೆ ಹೇಳಿದಾರ?
ಇಲ್ಲ. Either this gift deed has come into existence during the
After-
pendency of the suit,
Pendency of the suit.
2012.
Lingama was a party to the proceeding.
So whether Lingam at least anywhere in the suit has admitted about the execution of the gift deed.
No.
Matte?
After the execution of the gift deed, she died.
Was there any issue regarding valid execution of the gift deed?
No.
There was no issue. There was no issue.
And-
No dispute with regard.
Huh?
There is no dispute that was raised also.
No, but then
Issue,
even a gift.
except issue number 2, whether plaintiffs further prove that the registered gift deed dated 5/3/2002 alleged to have been executed by defendant 1 in favor of defendant 2 and 3 is not binding. It's the only issue that was raised.
This
The
only
court
shows the way in which the case was conducted.
Of course.
Gift deed also has to be proved. Unless Lingam herself accepted in the written statement, ಹೌದು ನಾನು ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ gift.
The gift deed was executed. During her lifetime, she has not spoken to about the gift deed.
So therefore that will have to be proved alwa, at least.
Of course not, that
Yeah.
issue was there. They did
Yeah.
not examine any witnesses insofar as gift
Hmm.
deeds.
Registered
This-
gift deed alleged to have been executed different ways, not binding upon them.
This is because 2011 suit. This is in 2012. After, that is on pending suit 5/3/2012. By then she had filed already written statement. There is not even a mention about the daughters in this gift deed. Therefore, during the pendency of the suit, it is influenced by other defendants to execute this gift deed. That is the reason why the
No,
issue.
this gift deed is a compulsorily
Yes, yes.
registrable attestable document.
Yes.
And you are bound to, they are bound to prove it.
Prove it.
Proof ಏನ್ ಕೊಟ್ಟಿದ್ರಿ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ.
Except production.
Very badly conducted.
Of course.
The defendants 2 and 3 in OS number so and so on the file of so and so have filed this appeal challenging the judgment and decree dated so and so, by which the suit for partition was decreed. Full stop. Next para. The parties shall henceforth be referred to as they were arraigned before the trial court. Next para. The suit in OS number 5342 of 2011 was filed by the daughters against their mother and 2 brothers, claiming partition separate possession of their share in the suit's real properties. The suit properties were a vacant site and a residential building where the defendants 2 and 3 resided. Full stop. The plaintiffs claimed that their father and mother had purchased the suit item number 1 for valuable consideration and therefore were their independent property. Insofar as item number 2 is concerned, they contended that the same was allotted to their father by the housing board and that their father constructed a building thereon. Full stop. They claimed that their father died on 25/1/2011, leaving behind the plaintiffs and the defendants to succeed to his entire estate. They claimed that after the death of their father, the defendant number 1 was maintaining the affairs of the joint family. And full stop. They claimed that there was no division in the properties of the family. Full stop. They claimed that during June 2011, they demanded their share in the suit property, which was turned down, and hence they were advised to seek for partition separate possession of their shares in the suit property. Full stop. The suit the defendants 1 to 3 filed a written statement on 8/9/2011. Inter alia contending that the suit schedule property was jointly purchased by the defendants in the joint names of the defendants one and deceased link and their father in terms of a sale deed dated 24/1/2003. Full stop. They contended that the plaintiff defendant number 1 was entitled to 50% share in suit item number 1. They claimed that their father was only a name lender, while the contribution to purchase item number 1 was by the defendants 2 and 3, and there was no personal contribution by their father. They also claimed that the personal funds of the defendant number 1, which she got as Tridana from her parents, was utilized for the purpose of purchasing suit item number 1. Therefore, they contended that there was no contribution by Linganna, by their father, to purchase the item number 1. Full stop. They claim that after purchase, further investment was made by them for putting up construction, by putting up a wall compound. They claim that their father died on 25/1/2011, and revenue records were transferred to the names of the defendants with the consent of defendant number 1 with the consent of other defendants. They claim that defendant number 1 had 50% right in the suit property in the suit item number 1, while the remaining 50% was owned and possessed by their father. As far as item number 2 is concerned, they did not dispute the fact that the said property was allotted to their father by the housing board. First item number 1 ಬಗ್ಗೆ ಎಲ್ಲೂ ಹೇಳೇ ಇಲ್ವಲ್ಲ, 2 ಬಗ್ಗೆ ಎಲ್ಲೂ ಹೇಳೇ ಇಲ್ವಲ್ಲ? ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ.
ಫಸ್ಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಹೇಳೇ ಇಲ್ವಲ್ಲ ಐಟಮ್ ನಂಬರ್ 2 ಬಗ್ಗೆ? However, they did not mention anything about the suit item number 2. Later, they amended the written statement and inserted para 7A, where they contended that their father died on 25/1/2011 and their defendant number 1 died on 5/7/2012. They claimed that both their parents had executed a will on 25/1/2006 bequeathing the item number 2 in the suit schedule to the defendants. Full stop. They claimed that the suit item number 2 was therefore owned and possessed by the defendants 2 and 3, and the plaintiffs have no right to claim the suit schedule item number 2. In addition, they contended that their mother had executed a gift deed dated 5/3/2012 in favor of the defendants. Thus, they claimed that they become the absolute owners in possession and enjoyment of the item number 2 property, over which the plaintiffs have no right or claim whatsoever. Full stop. They also claim that the plaintiffs did not object for transfer of the kata of the suit item number 2 in the name of the defendants 2 and 3, and hence plaintiffs are not entitled to any share in the suit properties. An additional written statement was filed by the defendants 2 and 3, wherein they contended that then right, IA number 3 was included. IA number 3 was filed by the plaintiffs to include item number 2. Yeah, item number item number 2 include ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನಪ್ಪ ನೀವು item number IA number 3 4 ಹಾಕಿದಾರಲ್ಲ. To permit the plaintiff to amend prayer column A, insert item number 2. ಏನಾಯ್ತು? Wherein they contended that their mother, they contended the plaintiffs had filed IA number 4 to include item number 2 and to seek 1/5 share in both the properties. That the said application was allowed by the court vide order dated 27/7/2015. The plaintiff defendants therefore contended that they were advised to file additional written statement. Full stop. They contended that item number 2 property was the self-acquisition of their father, who had executed a will on 25/1/2006, bequeathing the same to the defendant number 1, and after the demise of Lingana on 25/1/2011, the item number 2 property became the absolute property of the defendant number 1, who had got the khata duly transferred to her name on the basis of the will, and she was paying the property tax to BBMP. They contended that they were residing along with the defendant number 1 and in item number 2, and that defendant number 1 had gifted her interest in item number 2 in favor of the defendants 2 and 3. Therefore, they contended that item number 2 is their absolute property and the same is not available for partition. An additional written statement was also filed by the defendants 2 and 3 on 23/11/2018, where they contended that the plaintiffs had filed an application for amendment of the plaint to include an additional prayer to declare the gift deed dated 5/3/2012 as not binding on them. Full stop. It is contended that the said challenge was made after nearly 6 years from the date of the execution of the gift deed, and hence the relief sought for was barred by the law of limitation. Full stop. Based on these contentions, the trial court recorded the following issues. The plaintiff number 3 was examined as PW1 and she marked exhibits P12. P1 to P17, of which Exhibit P4 was a sale deed dated 24/1/2003 in respect of item number 2, item number 1. And Exhibit P5 was a sale deed in respect of item number 2. Exhibit P6 was the copy of the was the gift deed dated 5/3/2012. Full stop. The defendants examined the attesting witnesses to the will as DW1 and DW2. Full stop. The defendant number 2 was examined as DW3 and he marked the full stop. The will dated 25/1/2006 was marked through DW1. Full stop. Based on the oral and documentary evidence, comma, the trial court held that there is no dispute that suit item number 1 was purchased by the parents of the plaintiffs and defendants 2 and 3. It also held that the parents of the defendants 2 and 3 had not made any testament insofar as suit item number 1 is concerned. It therefore held that both the plaintiffs and the defendants are entitled to an equal share in the said property. Full stop. As far as item number 2 is concerned, comma, it perused the will at Exhibit D1 and held that though the will conformed to the requirements of Section 68 of the Evidence Act and Section 63 of the Indian Succession Act, comma, it held that the defendants 2 and 3 were not able to purge two suspicious circumstances, namely, number 1, that the defendants did not mention about the will dated 25/1/2006 in the written statement filed by them for the first time on so and so 2015 allanteno idu ನೋಡಿ
2011.
On
27/8/2011.
27/8/2011. However, full stop. Number 2, that there was no mention about the execution of the will in the gift deed dated 5/3/2012, purportedly executed by the defendant number 1. Full stop. It therefore held that these two circumstances gave an impression that the will was fabricated by the defendants only to deny the legitimate share of the plaintiffs in the suit properties. Consequently, it disbelieved the will at Exhibit D1 and decreed the suit for partition and declared that the plaintiffs are entitled to 1/5 share in the suit scheduled properties. Being agreed by the said judgment and decree, comma, the plaintiffs, the defendants 2 and 3 are before this court. Next para. The learned counsel for the defendants 2 and 3 submitted that the defendants had examined DW1 and DW2, who were the attesting witnesses to Exhibit D1. He submits that DW1 and DW2 were family friends who knew not only the deceased Linganna, but also the plaintiffs and the defendants. He submits that in the course of cross-examination of DW1 and 2, not a suggestion was made that they did not know the family of Linganna and the plaintiffs and the defendants. He also submits that DW1 specifically deposed that The will dated 25/1/2006 was handed over by him to the defendants 2 and 3 on during July 2021. He therefore submits that the defendants 2 and 3 could not mention about the execution of the will when they filed the written statement in the year 2011. Full stop. He further contends that one of the grounds on which the trial court rejected the law, one of the circumstances that weighed in the mind of the trial court to disbelieve the will was that the will was executed by Lingana and the defendant number 1, though defendant number 1 did not have any title to the suit item number 2. He contends that in exhibit D1 there is a specific reference that defendant number 1 was entitled to reside in the suit item number 2 during her lifetime, and therefore it was incumbent upon therefore Lingana felt it appropriate to include defendant number 1 while the will was executed in favor of the defendants 2 and 3. He therefore contends that both the suspicious circumstances pointed out by the trial court are answered by the aforesaid explanation. Thus, he contends that except for the above, there is no reason why the will should be disbelieved. Full stop. He further contends that the parents of the defendants 2 and 3 were residing in the suit item number 2 along with the defendants 2 and 3. And therefore, it was natural for them to execute a will bequeathing the suit item number 2 in favor of the defendants 2 and 3. Besides this, he contends that defendant number 3 is a bachelor. 3 na 2 na? Defendant number 2. Shiv Shankar is defendant number 1. Defendant number 2 is a bachelor who is also residing along with the defendant number 3 in the suit property, and thus to protect the interests of his sons, Lingana and property. Full stop. He invited the attention of the court to a suggestion put to DW1 in the course of cross-examination, which reads as follows. Copy mode. He contends that this suggestion establishes that even the plaintiffs are conscious of the fact that the suit item number 2 was bequeathed by Lingana and defendant number 1 in favor of the defendants 2 and 3. Therefore, he contends that the impugned judgment and decree passed by the trial court, insofar as declaring that the plaintiffs are entitled to an equal share in suit item number 2, may be interfered with. Full stop. As regards item number 1, he fairly contends that the said property was purchased by the father and mother. He fairly contends that there is nothing on record to show that the said property was purchased by the defendants 2 and 3 in the name of their father and mother, and therefore the judgment and decree passed by the trial court insofar as item number 1 is just and proper. Per contra, the learned counsel for the plaintiffs contended that though the execution of the will is established by the plaintiffs, by the defendants 2 and 3, but the same is surrounded in is replete with suspicious circumstances, and therefore the trial court was right in disbelieving the will and directing and decreeing the suit in respect of suit item number 2. He contends that the suit item number 2 was allotted to the father by the Karnataka Housing Board, and he constructed a building thereon where the family was residing. He contends that The defendants 2 and 3, he contends that the father of the plaintiffs died in the year 2011. And from the year 2011 till the year 2020, 21, the defendants 2 and 3 did not mention about the execution of a will by their father. He also contends that this will was executed jointly by their father and their mother, though their mother did not have any title in the suit property. Full stop. He further contends that the will was not in the possession of the defendants 2 and 3, as DW1 stated that he handed over the will to the defendants 2 and 3 in July 2021. This he submits is a strong circumstance that goes against the law, against the valid execution of the will. Full stop. Therefore, he contends that the trial court was right in decreeing the suit and decreeing the suit and declaring that the plaintiffs are entitled to an equal share in suit item number 2 also. Full stop. I consider the submissions made by the learned counsel for the defendants 2 and 3 and the learned counsel for the plaintiffs. I also perused the records of the trial court as well as its judgment and decree. Full stop. The only point for consideration that arises in this appeal is whether the defendants 2 and 3 are able to remove the suspicious circumstances that surround the execution of Exhibit D1. And the the 2 points that arises for consideration, and whether the defendants prove the lawful execution of the gift deed dated 25/1/2012. 5/3/2012. Bracket Exhibit P6 executed by the deceased defendant number 1. Yes, I will continue. I'll continue to free ಆಗಿದೆ ನೋಡಿ. Next Thursday ಇದೆಯಾ? Next Thursday ಯಾವ್ದಿಲ್ವಾ? Next Thursday ನೋಡಿ, ಅದ್ರೊಳಗೆ ಏನೋ ಟೈಮ್ ಇದೆ, ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಪಾರ್ಟಿ ಟೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ 12th ಮೇಲೆ ಯಾವ್ದಾರ ಡೇಟ್ 30th ಬರ್ತದೆ.
ಯಾವುದು 2:30? ಕಲ್ಪನಾ PV. Yes. Annexure?
Page number 13, Partition. ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 35ರ ಜಮೀನಿನಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡುವುದನ್ನು ನಿಷೇಧಿಸಿದೆ ಹಾಗೂ ಸದರಿ ಜಮೀನಿಗೆ ಗ್ರಾಮಸ್ಥರಾಗಲಿ ಮತ್ತು A ಪಾರ್ಟಿ ಮತ್ತು B ಪಾರ್ಟಿ ಜಮೀನಿಗೆ ಪ್ರವೇಶಿಸಿದಂತೆ ನಿಷೇಧಿಸಿ ನಿಷೇಧಾಜ್ಞೆಯನ್ನು ಜಾರಿಗೊಳಿಸಿದೆ. ವ್ಯವಸಾಯ ಮಾಡೋದನ್ನೇ ನಿಷೇಧ ಮಾಡಿದೆ.
Yeah, what is the issue?
The issue is respondent.
ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಓದಿ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಪ್ರಸಂಗದ ನಾಗರಾಜ ಅಪ್ಪುಗೌಡ ಮತ್ತು ಏನ್ ಅಣ್ಣ ತಮ್ಮಂದ್ರ?
ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಡಿಯಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳ A ಪಾರ್ಟಿ ನಾಗರಾಜು ಪಾರ್ಟಿ B ಹೇಳಿದರು. ದಿನಾಂಕ 9/3 ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದ್ದು ಪ್ರತಿವಾದಿ B ಪಾರ್ಟಿ ಮಂಜು. ಅದಾದ್ಮೇಲೆ ನಾವು
ಎಲ್ಲಿದೆ ಶುಂಠಿ ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಇನ್ನ ಇವಾಗ ಹಾಕಿದ್ರೆ ಇನ್ನ ಅದೇನ್ ಬೆಳಗ್ಗೆ ಇನ್ನ ಬಂದೆ ಚಿಗುರೇ ಆಗಿಲ್ಲ ಅದು.
ಇವರಿಗೆ ಈಗ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಗೆ ಟೈಮ್ ಇದೆ ಮಿಲಾಡ್, ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ 22/6/2026. ಇವಾಗ ಆಸ್ ಪರ್ ಟೇಕ್ ದ ಇನ್ಸೆಕ್ಷನ್ ತಹಶೀಲ್ದಾರ್ ಮಿಲಾಡ್, ಇವರಿಬ್ಬರು ಈಗ ಫ್ಯಾಮಿಲಿ ಮತ್ತೆ ಸ್ಟೇ ಕೊಟ್ಬಿಟ್ರೆ ಗಲಾಟೆ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆ ಮಿಲಾಡ್.
ಕರೆಕ್ಟ್. ಏನ್ ನೀವೇ ಶುಂಠಿ ಹಾಕಿದೀವಿ ಒಣಗೋಗುತ್ತೆ ಅಂದ್ರೆ ಎಲ್ಲಿ ಚಿಗುರೇ ಬಂದಿಲ್ವಲ್ಲ ಮೇಡಮ್. ಮನೆ ಬಿಡಿ, ಮನೆ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ಬೇಡಿ ಅಂತ ಹೇಳಿ, ಮನೆಗೆ ಹೋಗ್ಬೇಡಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಜಮೀನಲ್ಲ ಮನೆಯೊಳಗೆ ಹೋಗ್ಬೇಡಿ ಅಂತ ಹೇಳಿ.
4-5 ಜನ
ನೀವ್ ಹೇಳಿದ್ದೇನ್ ಬೆಳಿಗ್ಗೆ ಶುಂಠಿ ಹಾಕಿದೀವಿ ಚಿಗುರಿದೆ ಇನ್ನು ಒಣಗೋಗ್ಬಿಡುತ್ತೆ ಅಂತ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ ತೋರ್ಸಿ, ಒಂದ್ ಕಡೆ ಒಂದೇ ಚೂರ್ ಚಿಗುರಿದೆ ತೋರ್ಸಿ ನೋಡೋಣ. ಎಲ್ಲಿದೆ ಎಲ್ಲಿದೆ ನೀವು ಊಣಿದಿರ, ಗೆಡ್ಡೆ ಊಣಿದಿರ. ಎಲ್ಲಿ ತೋರ್ಸಿ. ಮೇಡಮ್ ನೀವೆಲ್ಲ ಡ್ರಿಪ್ ಮಾಡಿಸಿದಿರಿ.
ಅಲ್ಲಲ್ಲ, ಆಸ್ ಪರ್ ಮೈ ಇನ್ಸೆಕ್ಷನ್ ಮಿಲಾಡ್, ಇವರು ಪಿಟಿಷನರ್ ನಂಬರ್ 1 ಅಂಡ್ ಪಿಟಿಷನರ್ ನಂಬರ್ 3 ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಮಿಲಾಡ್, ಪಿಟಿಷನರ್ ನಂಬರ್ 2 ಮಿಲಾಡ್ ಸನ್ ಮಿಲಾಡ್. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಈ ಒಟ್ನಾಗೆ ಪಿಟಿಷನರ್ ನಂಬರ್ 1 ಮತ್ತೆ ಫ್ಯಾಮಿಲಿ ಕಲ್ತು ಈ 3 ಎಕರ್ 10 ಗುಂಟೆಸ್ ಜಮೀನ್ ಖರೀದಿ ಮಾಡ್ತಾರೆ ಮಿಲಾಡ್. ಮಾಡಿದ್ಮೇಲೆ ಈ ಅಣ್ಣ ತಮ್ಮರಿಗೆ ಸೇರ್ ಕೊಡೋದಕ್ಕೋಸ್ಕರ OS ನಂಬರ್ 385/2025 ಅಲ್ಲಿ ಸಿವಿಲ್ ಸೂಟ್ ಇದೆ ಮಿಲಾಡ್. ಇವರು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಮಿಲಾಡ್. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಇವರು 5-6 ಜನ ಕೂತ್ಕೊಂಡು ಗುಂಪು ಕಟ್ಕೊಂಡು ಗಲಾಟೆ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ ಆಸ್ ಪರ್ ತಹಶೀಲ್ದಾರ್ ಮಿಲಾಡ್ ಡೇಟೆಡ್ ಆನ್ 13/3/2026 ಅಲ್ಲಿ ಮಿಲಾಡ್ ಆರ್ಡರ್ ಮಾಡಿರ್ತಾರೆ ಮಿಲಾಡ್. ಈಗ ಆಸ್ ಪರ್ ಮಿಲಾಡ್ ಅದು ಇನ್ನೂ ಈಗ 1 month ಆಗಿಲ್ಲ ಮಿಲಾಡ್. ಈಗ ಇವ್ರು ಮತ್ತೆ ಗುಂಪು ಕಟ್ಕೊಂಡು ಮತ್ತೆ ಗಲಾಟೆ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆ ಮಿಲಾಡ್. ಸ್ಟೇ ಕೊಟ್ರೆ ಮತ್ತೆ ತೊಂದರೆ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆ. ಇವರು ಕೆಲಸ ಮಾಡಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ, ಇವರು 10-15 ಜನ 5 ಜನ ಈ ತರ ಕೂಡ್ಬಾರ್ದು ಅಂತ ಆ ತರ ಸ್ಟೇ ಮಾಡಿದ್ರು ಆಸ್ ಪರ್ ಮೈ ಇನ್ಸೆಕ್ಷನ್ ಮಿಲಾಡ್.
ಆಯ್ತು, ಬಟ್ ಡ್ರಿಪ್ ಲೆಟ್ ಪರ್ಮಿಟ್ ದೆಮ್ ಟು ಆಪರೇಟ್ ದ ಡ್ರಿಪ್.
ಆ ಟ್ರಿಪ್ಗೋಸ್ಕರ ನಮ್ಮ ಒಬ್ರು ಇಬ್ರು ಅವ್ರ ಮನೇಲಿ ಹೋಗಿ ಕೆಲಸ ಮಾಡ್ಬೋದು. ಬಟ್ ಈಗ 10-15 ಜನ ಕಲ್ತು ಗಲಾಟೆ ಮಾಡೋ ಚಾನ್ಸಸ್
ಇರುತ್ತೆ. ಓನ್ಲಿ ಪರ್ಮಿಟ್ ದಿ sprinklers to be operated ಅಷ್ಟೇ. Nobody will enter, nothing till the next date. ಮೇಡಮ್ ಶುಂಠಿ ಹಾಕಿರ ಕಡೆ ಅಗ್ರಿಕಲ್ಚರ್ ಆಕ್ಟಿವಿಟಿ ಏನ್ ಮಾಡ್ತೀರಾ? ಎಸ್
as per 163 BNSS ಇದು ಆಗಿದೆ ಮಿಲಾಡ್. as per CRPC 144
ಬರ್ಕೊಳ್ಳಿ. issue emergent notice to the respondents. AG is that HCGP is directed to accept notice for respond number 2 and 3. 2, 3 and 4. Full stop. Till the next date of hearing, comma, the petitioners are only permitted to operate the sprinkler, water sprinkler in survey number 31.
as per 31 ನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 13/2 ಅಂತ ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ ಮಿಲಾಡ್ ನಂಬರೇ ಹಾಕಿಲ್ಲ, ಪೇಜ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಮಿಲಾಡ್. ಸೆಕೆಂಡ್
ಸರ್ವೆ ನಂಬರ್ 31 ದೊಡ್ಡ ಹುನ್ನೂರ್ ವಿಲೇಜ್, ಆರ್ನಹಳ್ಳಿ ಹೋಬಳಿ, ಪಿರಿಯಾಪಟ್ಟಣ ತಾಲೂಕ್. And new survey number
31 ಹಿಸ್ಸಾ 2 ಅಂತ ಹೇಳ್ತಾರೆ ಮಿಲಾಡ್.
31/2.
Yes ಮಿಲಾಡ್.
Old survey number 31, new survey number 31/2.
Yes ಮಿಲಾಡ್.
It is made clear that the order dated 13/3/2026 passed by the respondent number 4 is not stayed. Yes. ಆಪರೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಸ್ಪ್ರಿಂಕ್ಲರ್ ಆಪರೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಮೇಡಮ್ ಶುಂಠಿ ಹಾಕಿರೋ ಕಡೆ ಅಗ್ರಿಕಲ್ಚರ್ ಆಕ್ಟಿವಿಟಿ ಮಾಡಲ್ಲ, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಫಸ್ಟ್ ಆ ಸೂಟ್ ನಡೀಲಿ ಅದೆಲ್ಲ. ಆಯ್ತಮ್ಮ, ಇಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಮುಂದೆ ಹೋಗಿ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ ಅದೆಲ್ಲ ಆಗುತ್ತೆ. Yes, we'll consider. Yes, next. ಶ್ರೀರಂಬ ತಗೊಳ್ಳಿ, ಯಾವತ್ ಬೇಕು ಡೇಟ್, ಯಾವತ್ ಬೇಕು ತಗೊಳ್ಳಿ. ಪ್ಲೀಸ್ ಟೇಕ್ ವಾಟ್ ಎವರ್ ಡೇಟ್ ಯು ವಾಂಟ್. ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ, ಟೇಕ್ ವಾಟ್ ಎವರ್ ಡೇಟ್ ಯು ವಾಂಟ್. ಕೊಡಿ ಅವ್ರು ಯಾವತ್ ಯಾವ ಡೇಟ್ ಬೇಕು ಅವತ್ತೇ. ಆಲ್ ಇಂಟ್ರಿ ಮಾಡರ್ಸ್ ವಿಲ್ ಬಿ ಎಕ್ಸ್ಟೆಂಡ್.
ಕೊಡ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
ಯಾವತ್ತು ಬೇಕಾದ್ರೂ ಕೇಳ್ರಿ ಕೊಡ್ತಾರೆ. ಕನ್ನಡದಲ್ಲಿ ತೆಲುಗ
ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಕೊಂಬಿಟ್ಟಿದ್ದೀವಿ 16th ಏಪ್ರಿಲ್ ಎಲ್ಲ ಅಂತ ಅದು ಒಂದು ಮಾಡಿಫೈ ಆಗಿರೋದು ಒಂದು 47 48 9th ಏಪ್ರಿಲ್ 46 47 48 46 47 48 9th ಏಪ್ರಿಲ್ ಇದೆಲ್ಲ 16th 9th ಏಪ್ರಿಲ್ 9th ಏಪ್ರಿಲ್ 9th ಏಪ್ರಿಲ್ ಎಂಟ್ರಿ ಮಾಡೋದಿದೆ
ಸರ್ 51
43 16th
ಸರ್ 51 16 ಗೆ 51
16th
41 ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ ಸರ್ ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ ಎಕ್ಸ್ಟೆಂಡ್
ಮಾಡ್ರೆ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ಆಗುತ್ತೆ
42
16th 40 16th ನೀವು ಹೇಳಿದ್ರಿ 12th
42
16th 16th ಸರ್ ಎಲ್ಲ 16th ಎಲ್ಲ 16th ಮೇಡಮ್ ಎಕ್ಸೆಪ್ಟ್ ಎಲ್ಲ 16th ಎಕ್ಸೆಪ್ಟ್ ಆ ನಂಬರ್ 9th ಏಪ್ರಿಲ್
ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ ಐಎ ಹಾಕಿರೋದು ಡೇಟ್ ಬೇಕು ಐಟಮ್ 2 ಇಂಪ್ಲೀಡ್ ಮಾಡಿರೋ
ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ 16th ಆಗಿದೆ ಹೌದು 16th ಆಗಿದೆ
ಅವ್ರು ಹೇಳಿ ಯಾವ ಡೇಟ್ ಅಂದ್ರೆ ಇಲ್ಲಿ ನಾನು ಆಕ್ಚುಲಿ ಎಂಡೋಸ್ ಮಾಡ್ಬಿಟ್ಟೆ ನಾನು ಇಲ್ಲಿ ಡೇಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಆ ಡೇಟ್
ಅಲ್ಲ ಬರ್ದ್ಬಿಟ್ರ
ಅಲ್ಲಿ ಬರ್ತಿದ್ದೀನಿ ಇಲ್ಲಿ ನೋಡಕ್ಕೆ ನಾನು ಅದು ಬರ್ದ್ಬಿಟ್ಟೆ ಆಮೇಲೆ ಇದು ಬರ್ದು
ನಾನು ಈಗ ಮತ್ತೆ ಈಗ ಬರ್ದು ಮತ್ತೊಂದು ಆರ್ಡರ್ ಮಾಡ್ರಿ ಅಂತ
ಅಲ್ಲೇ ಡೇಟ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಇದು ಅಷ್ಟೇ ಇದು ಅವ್ರಿಗೆ
ನೀವು ಬರಲ್ಲ
3295. Connected matter. DKM. ಅಮಲ್ ಮಾಡಿದ್ದಾರೆ. ಅಮಲ್ ಮಾಡಿದ್ದಾರೆ. ಆ ಪೇಪರ್ನ ಅಲ್ಕಂತ ಇರುತ್ತೆ. ಡಿಸ್ಪೋಸ್ ಏನಾದ್ರು ಆಗೋ ಚಾನ್ಸ್ ಇದೆಯಾ? ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೋದಾ? ಯಾಕಂದ್ರೆ ಫ್ರೆಂಡ್ ಆಲ್ರೆಡಿ ಅಲ್ಲೇ ಬರ್ಕೊಂಡು
ಆಗ್ಲಿ ಬಿಡಿ, ನೋಡ್ಕೊಳ್ಳೋಣ. ಹಾ, ನಾನು ಅದಕ್ಕೆ ವೆಯ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಎಲ್ಲಿ ಅಂದ್ಬಿಟ್ರೆ ಕಷ್ಟ ಅಂತ ಅಲ್ಲೇ ನಿಂತಿದ್ದೀನಿ. ಇಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿ ಅಂತ ಅಲ್ಲೇ ನಿಂತಿದ್ದೀನಿ.